So, hearty welcome to the training program. We'll start the program in a short while, sir.
Okay.
Good morning, sir. Manohar, sir, are we audible?
Yes, good morning.
Good morning, sir. Sir, we will begin the program.
Okay.
Have a long history of working for the achievement of human rights
the Vice Principal, and all the participants. I was just opening to see the schedule of the program, and it is more about the human rights. Human rights is not a demand, but it is our right. Each and every individual of India, by its very constitution. So it is, in other words, getting to know and becoming aware of human rights is empowering. People of all class, of all level, like including women, children, and other vulnerable groups. So I believe this little program or this webinar will empower the people, participants, and others who would later be listening about their own rights. I'm very happy today that this initiative is taken by us, by the department, with the help of NHRC. And I, on behalf of the college BSSS, welcome each and everyone present for this webinar. I wish fruitful sessions and a fruitful inaugural.
Thank you, Father. We are honored to have Shri Manohar Mamtani ji, retired session judge of the Higher Judicial Service, among us. He graduated from Rajasthan University in Jaipur with the BSc LLB DCLL degree. He is a former director of the MP State Judicial Academy in Jabalpur and a former Registrar General of the High Court of Madhya Pradesh in Jabalpur. Furthermore, he has attended various regional, state, national, international seminars and workshops on legal topics and also remains associated with various social organizations. For his significant contribution to the domain of human rights, he has received numerous accolades from prestigious institutions such as the MP State Bar Council, Jabalpur, Devi Ahilya Vishwavidyalaya, Indore, Gandhi Medical College, Bhopal, and Association of Physicians, Bhopal. Currently, he is working as a member of the Judicial MP Human Rights Commission, Bhopal, and has remained the acting chairperson for the same during the period from August 2017 to April 2018. It is an honor, sir, to have you on board with us as our chief guest for the online training program sponsored by NHRC. May I take the privilege to invite Shri Mamtani ji to deliver the inaugural address and share his words of wisdom.
Thank you, madam. Good morning to all. Respected Dr. John, Principal, Bhopal School of Social Science, resource persons of this training program, Dr. Kavita Singh, Professor R.R. Patil, Mr. Prashant Dubey, and Dr. Susmita Dhar. Teachers, ladies, gentlemen, and above all, dear students. I feel honored and privileged to get an opportunity to inaugurate this one-day basic training program on human rights, sponsored by the National Human Rights Commission, New Delhi. It must be a proud moment for the institution, as the outcome of this program will certainly sensitize all the participants and would inculcate the awareness amongst them, which will be beneficial to protect the human rights as well as fundamental rights enshrined under the Constitution of India. I hope today, in these 4 training sessions, with thought-provoking deliberations of the resource persons, on the given topics and active participation of the students, all stakeholders will move ahead on the path of Sarve Bhavantu Sukhinah, means may everyone be happy. During last 2 years of COVID-19 pandemic, we all have learned about importance of social science, especially human behavior towards unprivileged and needy persons, to ensure protect of dignity and respect of every individual without any type of discrimination. Therefore, my humble request to all resource persons and participants would be that apart from specific sessions, if time permits, also ponder upon the issues like right to food, right to health, right to education, rights of migrated workers and persons, as these all have been termed as fundamental rights as well as human rights and part of Article 21 of the Constitution of India by our Honorable Supreme Court in various pronouncements. My best wishes to all of you who are concerned for this good cause. I would also like to express my sincere thanks to the institution and best wishes for the successful completion of this training program. Thank you to all. Jai Hind, Jai Bharat.
Thank you, Shri Mamtani ji, for taking out his valuable time for our session and sharing his expertise on fundamental rights, which is also human rights in context to the prevailing pandemic. With this, we conclude the brief inaugural session. I also thank Father John PJ and Sister Sonia for their gracious presence. Thank you.
Thank you, Father. Thank you, sister.
Moving on to the technical session, Session 1, Introduction to Human Rights. And our expert speaker, Dr. Kavita Singh, Professor at West Bengal National University of Juridical Sciences in Kolkata. Professor Singh has over 11 years of teaching experience prior to joining WBNUJS. She has worked as a lecturer at the University of North Bengal's Department of Law and the S.K. Acharya Institute of Law at Kalyani University. Criminal law, criminology, victimology, and family law are among her research interests. She is also a visiting faculty member at the Government of India's Central Detective Training College, the Central Bureau of Investigation Training Center, Judicial Academy of West Bengal, and the Swami Vivekananda State Police Academy in West Bengal. Ma'am, with immense pleasure and honor, I welcome you to the program.
Thank you. At the very beginning, a warm good morning to one and all, the organizing team, the dignitaries who are present, the resource persons who are present, and the trainees. In the warm good morning, we are here to discuss the human rights issues and challenges which are there, which we face every day in the day-to-day life. So I would congratulate the organizing team for having a thought on having this kind of trainings for the trainers. And you will find that, today the most spoken about is human rights. But when it comes to protection of human rights, most of the times we fail in protecting the human rights of the common people. So, my theme of discussion today is the constitutional provisions, the other international instruments which are there, which play a very important role in shaping the domestic laws. So, what I have thought that I would do a complete comparative discussion, so that our discussion today becomes little interesting. Otherwise, if I come and discuss the constitutional provisions and I don't discuss the relationship between the international instruments and the role international instruments play in the shaping of the domestic laws, I would fail to clarify the participants as to what is the use of these international laws. So to start with, I'm sorry, I was speaking without the mic. I'm very sorry.
Ma'am, you were audible.
Acha, okay.
It's okay. You're audible, absolutely.
1 minute. Okay, so somehow my mic was okay. So I have a small presentation, as I was telling that my presentation which I have prepared is with the understanding that we will discuss constitutional provisions in the light of international instruments and how international instruments are used to shape the domestic laws. So my discussion today is divided into 3 parts, and in the short period of 1.5 hours, which I thought I'll keep 10 minutes for the question answer, so that the participants would ask clarify their doubts. And so I hope I would be meeting with the time. To start with, let me show my presentation. Is it visible?
Yes, ma'am. Yeah.
Thank you so much. Okay. So see, I have shaped the title as human rights, and I have put Constitution of India at the beginning, then ICCPR, and the other international covenants regarding human rights. So our core discussion would be protection of human rights in the light of Constitution and other international instruments. Now, this is the mostly used, image that every human has human rights. So human being, we all understand who all are the human beings. And a human being, being human, by virtue of birth, one acquires this right, and this right cannot be abrogated, taken away. No kind of discrimination can be done in any manner within the human beings in the society. So taking from there, what we find is that the human rights are basic rights available to any human being by virtue of his birth in the human race. So, every human being born to the land of Aryavarta, that is Hindustan, is born with these rights, and these rights cannot be taken away by anyone, be it state or be it other people in the society. So it is inherent in all human beings, irrespective of their nationality, religion, language, sex, color, or any other consideration. Now, the Protection of Human Rights Act, which we had in 1993, has defined human rights as human rights means the right relating to life, liberty, equality, and dignity of individuals guaranteed by the Constitution. So you see, there is a direct link in the definition from the Constitution. So the people of the country derive this right from the Constitution of India, or embodied in the international covenants and enforceable by the court in India. So that means these are enforceable rights, and if human rights violations have taken place, then in that case, the people can go to the court and challenge, and remedies are available in the Constitution. So these remedies are the ones which actually protect the human rights of the individuals. And 2 basic articles in the Constitution actually help the common people if their right is violated. That is, one is Article 32 and the other one is 226. By virtue of Article 32, one goes to the Supreme Court of the violation of human rights or fundamental rights. And on the other hand, 226 article, where while if the violation is there, can go to the High Court challenging the violation. Now, protection of human rights is essential for the development of the people of the country, now which ultimately leads to the development of the nation as a whole. So, if any one's section or any one member or anyone, if is not protected, or anyone's right is not protected, human rights or fundamental rights is not protected, then in a way, the country is far behind development. So for the purpose of development, everyone should contribute equally with full, potential, so that it would contribute to the country's economy, and people in the country would be contributing in the development of the country. So the Constitution of India guarantees basic human rights to each and every citizen of the country. Now, the framers of the Constitution have put their best efforts in putting down the necessary provisions. However, what we find is that the continuous developments taking place and the horizon of human rights has been expanded in time. So there are judicial pronouncements, there are the interpretations of the articles of the Constitution in a manner to continuously give a meaning to the human rights which are present in our Constitution. So the parliamentarians are now playing a great role in recognizing the rights of the people, and accordingly the laws are passed, that is, the statutes are passed. Amendments of the statutes are taking place wherever there is required, be it substantive law, be it procedural law, be it evidentiary law, and wherever you will find that there is violation or there are deviation from the protection of the rights of human beings, then in that case the laws are amended, and so the best examples which I can give of amendment is, after the Nirbhaya rape case, you find that the IPC, CRPC and evidence was amended. Then recently in 2018, again, the IPC, CRPC and evidence was amended, whereby, we are now, the rape is considered to be a serious human rights violation. So IPC, CRPC and evidence was amended if that prosecutrix, a girl child, is below the age of 12 years, or if there is a gang rape of a girl child below the age of 12 years, if there is a gang rape of a girl below the age of 16 years, we have actually changed the punishment. In case of child below the age of 12 years, we are now talking about, giving death penalty to the rapist. So we have already made amendment in the law, making it stringent so that, there would be deterrence in committing the crime of rape. So this was just an example to it. Now coming to the historical perspective and the development of human rights in our country. Human rights in India, it was there since the ancient period. That means it originated in the ancient period itself, and it can easily be recognized from the principles of Buddhism, Jainism. And in the Hindu religious books and texts like Gitas, Vedas, Arthashastras and Dharmata Shastras, they also contains provisions of human rights. And if you look into the Muslim rulers like Akbar and Jahangir, they were also very much appreciated for their regard for rights and justice. Now, during the early British era, the people suffered a great violation of several rights, because we were controlled and governed by an external ruler who did not have the the concerns for the common people, and this led to the birth of modern human rights jurisprudence in India. So you can say that the British era was the era in which the violations of human rights which gave arouse to the revolutionary movement in the country. And when the country became independent, then in that case the framers of the Constitution paid more emphasis in documenting rights in the Constitution, so that these rights could not be violated, and if violated, people would have redressal in the system. So on January 24th, 1947, Constituent Assembly voted to form an advisory committee on fundamental rights with Sardar Patel as a chairperson. Now, the drafted list of rights which were prepared by Dr. Bhimrao Ambedkar, B.N. Rao, and K.T. Shah, Harman Singh, and K.M. Munshi, and the Congress Expert Committee. So, though there were a few amendments proposed, there were almost no disagreement on principles which we incorporated these rights. So the rights in the Universal Declaration of Human Rights were almost completely covered in the Indian Constitution. So, in the latter part of my discussion, I'm going to discuss, which article is related with which article of UDHR, so that comparison would actually make you understand this particular aspect, that the framers of the Constitution was very well in consonance with the very in agreement that we will have these rights enumerated in the UDHR in our Constitution, and we will see that these rights become fundamental rights. So 19th fundamental rights were covered in Motilal Nehru Committee, which was there set up in 1928, and out of them, which 10 appears in the fundamental rights chapter, whereas 3 of them appears in the fundamental duties. So that means the division was such that when Constitution came into force, we adopted 10 of the rights out of it in the fundamental rights chapter, and 3 of them in the fundamental duties, because rights and duties go hand in hand. Now, if there is right, there has to be duties, and if there are duties, there has to be rights. So simultaneously, the citizen of the country, even non-citizens of the country, visitors who are there, foreigners who are there, who come to the country have to abide by these fundamental duties. And on the other hand, they are protected with the fundamental rights in our Constitution. Now, coming to the question, what are human rights? And the international instruments which we have by virtue of human rights, which came into existence, and the party and signatory to these international instruments, countries who are states who are parties to the instrument, and they are signatory to these instruments, have an obligation to abide by these provisions in their domestic laws. So if we look into the meaning of expression human rights, this word human rights have been originated after this word was coined after the Second World War. You all know that the outcome of Second World War has given rise to serious concerns towards humanity, because humanity suffered a lot in this era. And as a consequence, tremendous developments have been made in the field of human rights. So the first development is the coming of the Universal Declaration of Human Rights. Now, Universal Declaration of Human Rights was adopted by the United Nations General Assembly in 1948, and subsequently, large number of international human rights instruments and covenants came into existence. So, the 4th generation of human rights which we talk about is the Charter of 1945, UN Charter of 1945, 1948 UDHR, 1966 Civil and Political Rights, as well as 1966 Economic, Social and Cultural Rights. And in 1953, we have European Convention of Protection of Human Rights. Now, due to paucity of time, I will not be able to deal with the European Convention, but what I have thought that I will emphasize more on the Universal Declaration of Human Rights, and I will discuss civil and political rights and economic and social and cultural rights in the light of the Indian Constitution. So international human rights and fundamental rights, if we talk about, finds place in our Constitution of India in Part 3 of the Constitution. So India signed the Universal Declaration of Human Rights on 1st January 1942. And part of the Constitution also refers as this part, part 3 of the Constitution is referred as Magna Carta and contains the fundamental rights. So these rights, which are directly enforceable against the state in case of violation, and Article 13, Clause 2 prohibits states from making any law in violation of fundamental rights. So, if there is a law passed by the state, it can be challenged on the ground that it is unconstitutional. It violates fundamental rights of the citizens, and it can be struck down according to the Article 13, Clause 2 of the Constitution of India. Now that means the state owes a responsibility to see that when they are passing any law, then they are not violating these laws. So taking examples, if I want to give you some examples, like Section 9 of the Hindu Marriage Act, that is restitution of conjugal rights. Now, many a times this section has been challenged before the court, and the constitutionality of this section was challenged on the ground that it is violative of the right of the women who is having the right to consent that whom she would actually submit to this her body and whom she would not. And so this has been challenged many a times, and you will find that the courts have actually considered that marriage is an institution where both party agrees for submitting to each other, and on that ground, the constitutionality of Article 9 was upheld, that it does not violate Article 14, 19, or 21. Similarly, you will see that there are certain terror legislation like the TADA, the POTA, the UAPA, Unlawful Activities Prevention Act. All these three statutes have been challenged that it is violative of violative of the Constitution, because there are certain provisions in this law which are deviating from the constitutional provisions of Article 14, 19, and 21. But all these statutes constitutionality of all these statutes were upheld by the Supreme Court on the ground that in the name of national security and internal security of the country, the legislature is empowered to come up with certain stringent provisions in the law, even deviating from the cardinal principles of criminal law. So they were not considered as violative of Article 14, 19, 20, and 21. So in this situation, what we find that it can be challenged and it can be struck down as well. So I'll give you two examples, like right to die, or the right to take one's life, or that is in certain offenses, if it is a repeat offense, then the person will be given death penalty. Like, for example, in Arms Act, we had a provision where a person would be accused of the crimes second time. They're keeping banned arms with them. Then in that case, there was death penalty. So Supreme Court had struck down that provision in the Arms Act. And similarly, when we talk about Mittu versus State of, there's a Supreme Court judgment where Supreme Court said that, right to die is not a fundamental right. And then the question came in of euthanasia. So in euthanasia, the Supreme Court said that if the person who is suffering from any disease and has gone to the state of vegetative state, in those situations, there would be a committee of experts belonging to different different areas, like there has to be doctors, there has to be social scientists, there has to be activists in that committee who would see that the viability of taking that person's life, that the person will not be returning back to the society or not. So partially Supreme Court had recognized euthanasia, not completely. So there would be always a chance that the person. So it is not a fundamental right, but there can be a situation where the person in a vegetative state can be put on, or the person who is put on, say, a system where he or she the chances of survival is nil. In such situation, they would actually look into and then allow the person's death peacefully. So that those are certain issues which we have been taken up by the Supreme Court, and they have recognized these rights. So the law, if it is in violation of our fundamental right, can be struck down as well. Now, fundamental rights that are part would be declared void. The remaining part of the law will be applicable. And if void part cannot be separated from the main act, the whole act may be declared as void as well. So in that situation, the entire law will become obsolete. It will not be used anymore. Now, here in case of Kasavananda Bharti versus State of Kerala, Supreme Court observed that the Universal Declaration of Human Rights may not be legally binding instruments, but it shows how India understood the nature of human rights at the time the Constitution was adopted. So, when the Constitution framers sat down to frame the Fundamental Rights chapter, they took provisions from the Universal Declaration of Human Rights and incorporated in the Constitution. So directly they are not maybe binding, but they have an impact and they have an impression inbuilt in the Constitution of India that was recognized in this particular case. Then coming to the another important case, that is Railway Board and versus Chandrima Das. In this case, you will see, this woman was raped in a Yatri Nivas of railway. So she sued the Railway Board for the violation which took place in the Yatri Nivas. So in this case, also Supreme Court observed that UDHR has been recognized as a model code of conduct adopted by United Nations General Assembly, and the principles may have been read if needed in the domestic jurisprudence. So, under Article 21, a foreigner was extended fundamental rights protection, and she was compensated for the violation of her fundamental right, which took place, the violation took place in that Yatri Nivas of the railways. So, this is in a unique way how Supreme Court has actually laid down or incorporated the international instruments while interpreting the domestic laws. Coming to as I told you, now I have come down to the second part of my discussion. In the second part of my discussion, I'm going to do a comparative analysis where the framers of our Constitution has incorporated the UDHR in the Constitution of India. So, a provision of Universal Declaration of Human Rights along with corresponding provisions of Constitution of India, which we are going to discuss in this section. So, you see there are 3 columns in the chart. In this slide, and the first column provides the brief description of the provision which is there in the Constitution of India, then the article which is there in UDHR, and the article which is there, corresponding article which is there in our Constitution of India. So equality and equal protection before law. This provision of this fundamental right is laid down in the UDHR Article 7. And we have actually incorporated that principle, which is there in Article 7 of the UDHR, in Article 14. So everyone will be treated equally before the law is the provision, and no one can be discriminated on any ground, that is caste, color, creed, religion, etc. So Article 14, every law has to pass the test of Article 14. And say if a person is a rich person, or if a person is a poor person, they all will be considered equal before the eye of law. And if they have committed any crime, which is an offense under the domestic law, they both will be treated equally. So in the eye of the law, or in the eye of the court, both the offenders will be treated equally. All the citizens in the country will be treated equally. Whatever color, whatever creed, whatever religion they follow, they would be treated equally. The second article is, what is the remedies available in the Constitution of India if there is any violation of that fundamental rights. So for the remedies available, in the beginning also I told you, coming back again, that under UDHR, this is Article 8. Remedies a state has to provide for violation of fundamental rights. And corresponding article which we have, it is Article 32 of the Constitution of India. So in Article 32, what we do is that if anyone's citizen of the country's fundamental right is violated, they could go to the Supreme Court and file a writ and against the state, that is Union of India, and then the remedy will be made available. So the court is going to see that there was violation of fundamental rights or not, and accordingly the person would be granted compensation, or strictures can be passed against the state, which state needs to comply with. Here I'll give you only one example. On with the right of the terrorist as an accused in a criminal justice, and on the other hand, the victims of the who face the problem of there was a in the Parliament attack case, there was a security personnel who was in the duty of the protecting the or taking care of the law and order matter inside the Parliament. Now, at the time when the attack was taken, if you done, you will remember that there was a evening time when there was the shifting duty. So one set of staff would leave for the day, and another set of staff would join the duty. So the attackers took that time so as there would be no security personnel in the concerned place where they should have been posted for the taking care of the law and order matter. So when this police officer was leaving at the time, leaving his duty, when he was going home after completing his duty, there was this attack going on. So he did not die out of the bullet injury from the attackers, but he died because the wall fell on him, because the wall was actually completely shattered down with the bullets. So the wife of the police personnel came to the High Court, Delhi High Court, seeking that had my husband died in duty, then I would have got compensation from the state. Now, as my husband was off duty, and there was a attack in the Parliament, and he died not directly out of the bullet shot, but he died out of the the result of the bullet shots in the wall, which the wall fell on him, and because of that he died. So there was no direct connection, but there was indirect connection, and I, being a citizen of the country, suffered the loss, and for which if the state does not support me with compensation for the loss of my husband in duty because he was off duty, I would be compensated by the Union of India for the loss which I have incurred by the attack of the terrorist in that incident. So so the Delhi High Court extended 5 lakh compensation and a job for the women because her fundamental rights was violated. So, under Article 32, she had filed under 226, but, the similar kind of situation can arise. You can go to the Supreme Court and get remedy under the Constitution of India. So this was only one example. There are many other examples because Chandrima Das case was under Article 32. We have, a series of cases starting from Vishakha versus Union of India. I can give you many other cases like, Domestic Working Women's Forum case, all the prisoners' rights case. You will find legal aid cases. You will find which were filed under Article 32, and I'll come to that issue where Supreme Court had liberalized the locus standi under the Constitution of India under Article 32. Even a postcard was considered as a PIL, and remedy was extended to the victims of violation of fundamental rights. Coming to the second right, that is right to life and personal liberty. UDHR under Article 9 protects this right, and so framers of the Constitution have incorporated this in Article 21. And in Article 21, all the new rights which have come into. If I talk about Article 21 in brief, you will see that in 1950, this Article 21 was negatively interpreted. And there was a minority opinion of in A.K. Gopalan's judgment, which became the majority opinion in Menka Gandhi versus Union of India. So, this Article 21, which was negatively interpreted in 1950, was positively interpreted in Menka Gandhi's judgment, and henceforth Article 21 was all positively interpreted, and so no one could be deprived of the right and right to life and personal liberty. Only that is according to the procedure established by law. So you will find, all the legal aid cases like Husainara Khatun, Sheila Barse, then we have these cases of prisoners' rights, all protection of the rights of the prisoners, all came into that, even the prisoners, even the convicts, whoever is in the custody of the state in the correctional home, they also have right to live with human dignity. And right not only does not mean life, but life with human dignity. So state owes a responsibility to see that they do not live like an animal existence inside the correctional home, but they have right to live with human dignity, and this can be only taken away. So the people who are there inside the correctional home, they do not have a fundamental right of Article 15, that is moving around the country freely. Free movement is not there. Otherwise, all the rights are available to the prisoners. So, Article 21, huge discussion can be there. So due to paucity of time, I'm not taking into so much. Coming to the next article, the next provision, that is protection in respect of conviction of offences. So this is laid down in UDHR, Article 11, Clause 2. And in our Constitution, we have this protection in respect of conviction of offences, that is Article 20. Now, Article 20 is a very renowned article where, it has 3 clauses, and it protects the people from double jeopardy, self-incrimination. So if there is any person who is punished for an offense once, then he cannot be punished for the same offense again. And that means, say a person has been given death penalty, given life imprisonment for murder of X. Now he cannot be again challenged or asked to undergo punishment, or there cannot be again trial and punishment for the death of X again. So protection is given under this Article 20 Clause 1 in respect of conviction of offense. So it would amount to double jeopardy. But say a person is involved in a dacoity and murder of say X, and again he has committed dacoity and murder of Y. Then in this situation, it does not become double jeopardy. And say if we take another example, that is, a person has been prosecuted under the criminal law for the offense committed by the person, the offender, and the offender is again prosecuted under the civil law. Prosecuted in the means there is a civil proceeding against him, and where the remedy is a civil remedy like he would be getting compensation for the tort which he has committed. So that would not amount to double jeopardy. You must understand this difference. So if there are 2 remedies, like for example, under 498 capital A, a husband is accused of cruelty against the wife. Now, under the Domestic Violence Act, again, the husband is accused of committing domestic violence against the wife. So in these 2 situations, wife has right to file case in both the places. That means she can lodge an FIR under section 498 capital before the police station, and the husband, the wife can again go to the court directly with the help of the protection officer and file a complaint case of domestic violence against the husband. So this two, if she is applying two different laws here, the accused is same and the offense of cruelty is same, but in one case it is a civil remedy and the other case it is a criminal remedy. So in this situation, this Article 20 clause 1 is not hit. So you must remember this. And so women has remedy in different places. Like she can again go under the Hindu Marriage Act and file a case of divorce for the same cruelty committed by the husband. But that is again a civil remedy. So, and Domestic Violence Act, is a quasi-civil law, and which has come in for, giving remedy to the women. That is, so there would be restraint order, there would be restoration back to the matrimonial home, there would be compensation given to the women for the cruelty, and she could also avail the maintenance order under the Domestic Violence Act. So, this Article 20 clause 1 is not hit. Now coming to the right to property, Article 17 allows this right in UDHR. In the Constitution of India, right to property was a fundamental right. But today, in today's time, state has made a change in this. It was there in Article 31 earlier, but now we don't have this article in the Constitution of India, because state has authority to take away anyone's right, anyone's property at the time of need of emergency. Now, so what happens is that right to freedom of coming to the next the article in the Constitution, which lays down provision for right to freedom of conscience and practice, profess, propagate any religion. Now this is a hot debated issue in today's time, that is right to religion, and people are confusing with the cultural rights and religious right. Religious right is a fundamental right, but right to right to certain practices or certain customs or certain culture, which we are taken into consideration, which is they laid down in our Article 25 clause 1 in the Constitution, and the corresponding article was there in UDHR in Article 18. Coming to freedom of speech, again, this is a hot debated topic in today's time. We find this article present in Constitution of India in Article 19 clause 1A, and in UDHR it was Article 19. Now, freedom of speech, but this Article 19 clause 1 clause 1A provides for certain restrictions and limitations. So you cannot give a hate speech that would actually disturb the peace or create insecurity, and the state's security is on threat because of that speech. That would be violative of Article 19 clause 1 subclause A. So freedom of speech is there, yes, and because of this article, the press, the social media enjoys this right to speak whatever we want, but it is visited with certain limitations and restrictions. So the citizens of the country has to abide by those limitations and restrictions. And when we are talking about these limitations and restrictions, we will have to see that it does not violate anyone else's fundamental right. And on the other hand, it should not break the peace in the country. So, if there are fake news is created, or if there are situations where, there is a incite to cause harm to one particular section of the society, then in that case, this would be a violative of Article 19 clause 1 subclause A. So In this case, we have actually in Information Technology Act, Section 66 capital A has been struck down by the Supreme Court in Shreya Singh's case. You all must have been knowing that she had posted a message in her Facebook post against a politician, and which was she was put behind the bar under Section 66 capital A because she had done it in the cyber law. She had violated the cyber law, and correspondingly, it was challenged that Article 19 clause 1 subclause A was violative, and Supreme Court had actually struck down this section, saying that police should not use Section 66A in such kind of cases, because people have right to speak. Freedom of speech is guaranteed under the Article 19 clause 1 subclause A, and after Shreya Singhal case, in 2021, Supreme Court had to come with hard hand again, because the police was levying Section 66A against people if they were speaking against the politician in the social media. And so Supreme Court had to circulate this judgment of Shreya Singhal to all the high courts, asking the high courts to distribute this judgment to the common police stations and the courts, that court would not entertain if police comes up with or court will not take cognizance of the cases under Section 66 capital A. So for reference, you all can read Shreya Singhal, and in Google, if you search the status, you will come to know about the judgment, where again Supreme Court actually comes with hard hand, asking the circulation of this judgment and creating awareness that Section 66 capital A has been struck down by the Supreme Court. Coming to the next provision is that everyone will have equal opportunity in the public service. So all services which would be provided by the state to the public, everyone will be treated equally. Similarly, for job opportunities also, everyone will be treated equally. Now, this is laid down in Article 21, Clause 2 of UDHR. And in Constitution of India, we find this article in Section 16, Clause 1. But if you see clause 16 clause 2, 16 clause 3, 16 clause, we have these provisions in the Constitution of India, whereby you will see that state has been empowered to give special treatment to the people who come from the economically, socially, politically backward class, and special provisions can be made for them. That by that we mean by that we mean the reservation, and so state can make reservation for certain class of people in the job opportunities, and people can give opportunity to a special class of people for special kinds of public services. So all these schemes which Government of India comes up, or with the state comes up, when we see during lockdown, there was a free distribution of food grains to the common people. But they had created a class of people who are falling falling in the category of say below poverty line, or they have certain right to food. When we are talking about article right to food, and in that food, right to, in that act, you will find we have created class of people who are needy because they come from certain class, people who are economically background class, or that there has been categorization there in the law, and accordingly the food distribution has been done. So upper class people who can afford food, they were not provided, but people who are genuinely fall in the category of say lower backward class, or economic or politically backward class, they were provided this food facility. So in services also, they have to be given special preference, not only in admission process, but also even in service promotions as well. So these schemes are there. Policy of the government is there. We need to take into account. There was a lot of debates in the Supreme Court, and then finally Supreme Court laid down that the reservations cannot be beyond 50%. But again, there is a whole lot of debate going on, where you will find that we have protection, we have Supreme Court judgments, and then vis-a-vis this tug and war between the judiciary and the legislature is going on, and we are yet to have a whole consensus on this reservation policy. So if on that also there can be two hours discussion. So I will not take so much of time. Coming to the next provision, that is protection of minorities. Now, protection of minorities is laid down under UDHR and Article 22. And corresponding article in Constitution of India is Article 29, Clause 1. So, here this article protects the rights of the minorities. At the time when India got independence and we adopted our constitution, framers of the constitution felt that there was a need that a special treatment has to be given to the protection of the minorities in the country, and accordingly they were given certain benefits under Article 29 Clause 1. And subsequently, there are certain, extended benefits under Clause 2 and 3. So that also has its importance in its own sphere, that the minorities will have, be allowed to create or teach their religion to their people, and they could come up with their institutions, educational institutions and religious institutions, for which state would be funding them for these institutions. And for the majority people in the state, this facility was not there. Nobody has ever challenged this, and therefore this right is going on. Maybe a time would come when the majorities would become minority, and then this will be challenged, I think. So we will have to wait and see. So categorization of minorities are there in Article 29. So, and this is a very, again, a hot debated issue going on in today's time. Coming to the next provision is right to education. Now, right to education did not find as a fundamental right at the time when the constitution came into existence, or when constitution was adopted. This was there in UDHR in Article 26 Clause 1. But, the framers of the constitution kept this in the category of directive principles, that, when state would be capable, because, at the time when Britishers handed over the state to the Indians, that time the economy of the country was very poor, and state could not provide education to the common people or all the citizens of the country in one go. So the framers of the constitution felt that if this provision would be kept in the UDHR, and time would come when the state would be a developed economy and would be capable of providing education to one and all, then in that case, because of that, it was put in the directive principles. But, by virtue of Supreme Court's judgment, we find that, it was a pressure on the legislature to come up with an article in the constitution and amending the constitution. Article 21 capital A was added. And by virtue of Article 21 capital A in the constitution, by way of amendment, state was responsible to come up with a law also, right to education. So this Right to Education Act was passed, and state would be responsible to give free education by virtue of this act to the people until the age, to these children up to the class 8. So state would be responsible, and if any children fail to get education, that would be failure of the state. Two of my students have done research on right to education's implementation in West Bengal, and the situation is that the outcome of the findings of the research was that state tries to comply with the law, but state fails due to various reasons, when the parents do not send their children to the school. Though, there is a provision of giving penalties to the parents who do not send their children to school. But, that could not be implemented because these parents are themselves hand to mouth, and they need the help of the children during the day hours to contribute to the family income. So, in such situation, it becomes a very difficult situation for the state to implement this. And the state provides midday meal to the students in the school, for which children are enticed to come, but there are many children who still do not turn up. And we find that this law is not optimally utilized to educate the children in our society. So this was the second part of our discussion, where we compared with the Universal Declaration of Human Rights without the provisions of our Constitution. Similarly, we will now compare with the ICCPR, Civil and Political Rights, in the international instrument along with the Constitution. So many of the civil and political rights contained in the International Covenant on Political and Civil Rights are enshrined in Part 3 of the Constitution of India, and India has signed and ratified this particular international instrument, that is Civil and Political Rights, International Covenant on Civil and Political Rights. So in Supreme Court, in Jolly George Varghese versus Bank of Cochin, Justice Krishna Iyer observed that though the provisions which are present in ICCPR but do not find place in Indian Constitution, that does not make the covenant an enforceable part of corpus juris in India. So this judgment plays a very important role in interpreting Article 21 in a positive manner. Coming to the comparative analysis, which we are going to do, we will again revisit this when we are comparing ICCPR with the provision which we have in our Constitution. We will have some laws again, discussed. So taking care of first article is article right to life and liberty. So in ICCPR, this right finds place in Article 6, Clause 1 and Article 9, Clause 1. So this corresponding article is under Article 21 of the Constitution of India. So we have discussed this earlier in detail. I'm not discussing it again. Coming to another important provision, that is Prohibition of Trafficking and Forced Labor. So this finds place in Article 8, Clause 3 of ICCPR. And the corresponding article which we have is Article 23. Now, in this article, you will find that a state already has a law in place corresponding Article 23 in India, that is Immoral Trafficking Prevention Act. So if women are trafficked for the purpose of commercial sexual exploitation, then for that, we have a law for under Article 23, and for bonded laborers also, Prohibition of Bonded Labor Act is there, where no labor can be taken without paying adequate remuneration for the labor, and for which the state has to come up with a minimum wages for the labor, and accordingly the minimum wages have to be paid to the laborers. So otherwise it would amount to forced labor. And so we have provisions here. Under the substantive law, IPC, we have provisions of, kidnapping and abduction. And we also have a particular section of 370 capital A for trafficking. Where the act would amount to trafficking, even if a human being is trafficked for the purpose of organ trading or a person has been trafficked for cheap labor, etc. So, we have corresponding substantive law in our constitution, in our domestic law, and this Article 23 is important article which has statutory law as well. So I have told you that we have Bonded Labor Act, we have contractual Prohibition of Child Labor Act, we have Contractual Labor Act, we have the ITPA, that is for human trafficking, particularly women for commercial sexual exploitation. And if I talk about few case laws, we have Bandhwa Mukti Morcha case from the Supreme Court, which laid down that, the bonded labor not only have to be liberated, but they have to be simultaneously rehabilitated and reintegrated into the society, and for which state has to provide, resources, that is, fooding and lodging facilities. So, state would provide funds starting from 25,000 to 50,000 for making houses for them, and then the policy or the schemes which are available, central government schemes and state government scheme, for like under the Pradhan Mantri Awas Yojana, one would be provided housing facility, and then one would be provided livelihood facility in the law. So accordingly, by virtue of the judgment of Bandhwa Mukti Morcha, the state was bound to come up with a legislation, and the Bonded Labor Act had come in, and there are a lot of remedies available under the Bonded Labor Act. And so Article 23 is taken care of to some extent, but more has to be done. Implementation of law at the ground level is not sufficient enough, and we time and again come to know about this violation in the law, in practical field. Coming to the next provision, that is protection against detention in certain cases. That is, state takes into takes into custody people on the apprehension that they would be threat to the peace and the security of the state. And so in ICCPR, the provision was there is there in Article 9, Clause 2, 3, and 4. So we also in Constitution of India had this provision in Article 22. So that is, the state can take people into preventive detention, and so that would be, but the person would be having, redressal in the sense, say, if state has taken up a person under Article 22, they would not be devoid of all the other fundamental rights. Maybe their freedom of movement is restricted for the time being, but then they would be getting facility of all the other articles, fundamental rights which they have. Now, coming to the issue under Article 22, if I take again the judgment of A.K. Gopalan, A.K. Gopalan wanted to publish a manuscript which he had written while he was in preventive detention. Now, state did not allow him to publish it on the ground that, if that manuscript is published and it goes into the hands of the common people, then that would be a law and order problem, and state would not be able to control. So in that case, the A.K. Gopalan was not allowed to publish that manuscript till that period he was in the custody. And that time it was considered, I told you Article 21 was negatively interpreted, and it was not considered that, he would be allowed to, and they said that, according to the procedure established by law, by virtue of Article 22, one could be taken into preventive detention, but the publication of the manuscript could not be allowed. So on this issue, now when we talk about preventive detention, that there can be writ of habeas corpus under Article 32 against the state. So state has taken the person into custody under preventive detention, Article 22, no doubt, but his whereabouts have to be told to the near and dear ones. So the relatives, friends, have right to know the well-being of the person in preventive detention. So on this, the ground, many a times there are a lot of Supreme Court judgments available where, this right to habeas corpus under Article 32, that this remedy is there, that people say if state takes into custody, I mean, the police have taken into custody a person but not arrested him. So the police has taken into custody the person under Article 22, preventive detention, but has not registered any case against him. So the well-being of the person has to be known to the near and dear ones. So that it means if he has not been arrested or if he has been arrested, in both ways, the near and dear ones have to be known. So, in D.K. Basu versus State of West Bengal, there was a Supreme Court judgment where Supreme Court laid down guidelines, 11 guidelines, which the police have to follow while they are effecting the arrest provision. Now, on that case, the one of the ground is that when he has been arrested, someone has to be informed, near and dear ones, according to the offender whom he informs that this person. So, or even a lawyer can be given information that he has been arrested by so-and-so police station for so-and-so charges. Or even if he's not, he's not been arrested, he's taken into preventive detention, but he has to be, reason for the preventive detention has to be made known to a near and dear ones. Otherwise, it would be violative of Article 22. Coming to the next article, that is freedom of movement. Freedom of movement, and a citizen of a country can move around inside the country free without any restrictions, and would also move around worldwide without any restriction, but with proper paperwork. That the visa of the country, one should have passport of its own country, and then he has to have proper travel documents. So with that, one can actually be allowed to move around freely worldwide. There could not be any restrictions on anyone, and that is laid down in ICCPR in Article 12, Clause 1. And simultaneously, Constitution of India under Article 19, Clause 1D, you will find that this article finds place. So everyone has right of freedom of movement, but you must have seen that, sometimes the political leaders want to visit a particular place where there is maybe some crime had happened, or riot had happened, or say rape had happened, like in case of Hathras case, this Gandhi family was stopped from entering into that jurisdiction. Sometimes, the state government do not allow political leaders to organize, say, rallies and all. So, this Article 19, Clause 1, Clause 1, Subclause D is been violative or not. But in the name of the security and situation, handling the situation of law and order, state can actually prevent people from entering into certain jurisdiction, and that is allowed as a restrictions and limitations which are there in Article 19. So what happens is that the people can also be, common citizens and people of high stature can also be stopped on the ground that there are certain law and order problem for which the permission was not granted. Otherwise, freedom of movement is available. But this freedom of movement is not available again to the persons who are accused of crime and or convicted of a crime, and they would be behind the correctional home. So when they are incarcerated, during the period of investigation, when custody trial is going on, or during conviction, after conviction, in this situation, this right is not available to the prisoners or the people who are accused of crime, or they are undergoing custodial trial, or they are convict people. Coming to right to equality, right to equality finds place in Article 14, Clause 1. And simultaneously Article 14 I've discussed earlier. So I've just mentioned it here that in ICCPR you find this Article 14 Clause 1 dealing with right to equality, and in a Constitution of India we have this article in Article 14. Now coming to the next article, that is right not to be compelled to witness against own self, that is self-incrimination. This right finds place in ICCPR Article 14 Clause 3 Subclause G. In Constitution of India, we find this article in 20 Clause 3, that one cannot be witnessed against oneself. So if anyone is made, that means, this is a Mirinda right provided under the Constitution of India, that when the police is investigating, during investigation, when he is interrogating the offender or interrogating the witnesses to the crime, the police is going to be informed in the very beginning that you will not be, you can actually remain silent. This is right to silence. You can remain silent if anything would go against you. So you may not disclose that to the police. So similarly, when the accused is giving 161 statement or 164 statement before the magistrate, at that time also, when the magistrate, when an accused becomes an approver, at that point of time also, this right not to be compelled to witness against himself, this right to silence has to be mentioned by the magistrate to the person who becomes an approver. So that he knows that he has this right. And under Article 20, Clause 3 of the Constitution of India, this right is a fundamental right given to the accused person, and they can remain silent. So that what if they speak, that would go against them. That would be self-incriminatory. So, and in this situation, what happens that the person would be allowed only to speak whatever they want to speak, and they should not be forced to speak. Now, this was challenged in Selvi versus State case. All those kinds of narco analysis test and the lie detector test and brain disorder test, all these tests which were done by the investigating agency to get evidence was considered as violative of Article 20, Clause 3. But, police could not do it on their own. But if they take the permission of the court and would explain before the court the emergency and the exigencies required, like in Arushi murder case, you will see that it was used. And in many of the CBI cases, they use these tests, narco analysis test, lie detector test and all. So in that case, this the CBI and the specialized agency get permission from the court to do it, and with the consent of the offender. So offender's consent has to be taken for the that is for the purpose of right to self-incrimination. Right against self-incrimination is available, and if the willfully one consents for such kind of test, then it would not amount to violative of Article 20, Clause 3. So that the people have to be made known about the accused persons, the witnesses have to be made aware of this right which is available in the Constitution, and then the investigation can proceed. Now, with regard to whatever, if there is a discovery, that means, in that test, he discloses that, I use so-and-so weapon. After using the weapon, I kept the weapon in so-and-so place. So to that extent, if there is a recovery of a weapon, or if there is a recovery of evidence, there is an evidence corresponding to it, that would be admissible in the court of law. So that this much we must remember. I've already talked about double jeopardy earlier. So that is, Article 20, Clause 2. And protection against ex post facto law is Article 20, Clause 1. That means, one criminal law cannot be applied retrospectively. So it will always be prospectively applicable. So from the date of enforcement, that is, from the date when the president or the governor put signature to the law, assent to the law, and the date of gazetted notification, on the date when the enforcement, that notification is done, from that day onwards, the law will be applicable, not passed. So, you will see that TADA was repealed, POTA was repealed, and then we had brought in the UAP Act by way of amendment. So today's time, there can be no case registered under TADA or POTA, but there are already cases registered under TADA and POTA where trials of those cases are still going on. And when we talk about UAPA law, so UAPA law came into effect after the second Mumbai bomb blast case. And so that means subsequently, Unlawful Activities Prevention Act will be applicable prospectively. Now I'll give you here one more example. Criminal Law Amendment Act 2013. In case of Criminal Law Amendment Act 2013, you will find that it has a retrospective effect. Now, the date of the applicability of the law and the date in which the president had given assent to it are two different dates. The reason is that the Criminal Law Amendment Act we have a small history of it. That is, in 2012, later part of it, towards the December, we find that Verma Committee had submitted its report, and the Parliament was not sitting, and therefore debate on the recommendation could not take place. And as the Parliament was not sitting, the ordinance was passed by the recommendation submitted by the Verma Committee was in toto. Accordingly, ordinance was passed on the basis of that. Now, when the Parliament came in session, subsequently happened, and the law was debated. The ordinance was debated in the Parliament, and then it was passed by the Parliament, Lok Sabha and Rajya Sabha, and finally got the assent of the President. So ordinance was passed by the signature of the President, no doubt, when in absence of Parliament sitting. But you will find the date which is there is later on. But in that case, when there is a law, ordinance is as good as law. So the date of applicability of the law, that is Criminal Law Amendment Act 2013, is, you will see that it is retrospectively applicable, but it does not violate Article 20, Clause 1. You should remember this. Coming to right to freedom of conscience and to practice, profess and propagate any religion. So freedom of religion is there in our country, and that is protected under Article 25, Clause 1 and 25, Clause 2, Subclause A. Corresponding article in ICCPR is Article 18, Clause 1. Now, coming down to freedom of speech and expression, I have discussed in detail. I'll just now mention here the article. In ICCPR, you will find in Article 19, Clause 1 and 2. And in Constitution also, we find this same freedom of speech and expression in Article 9, Clause 1, Subclause A. Then right to assemble peacefully under Article 21. And Article 19, Clause 1B. I just now talked about, that people can have association and people can assemble peacefully without arms, any place they want. And but peaceful assembly can turn out to be an unlawful assembly, keeping in mind that the permission is required to be taken and a declaration to be given by the organization organizing this peaceful assembly that there would not be any kind of unlawful activity in that assembly. And if a lawful assembly turns out to be an unlawful assembly, state has the authority to actually take action. So that is why you will find many a times the security personnel comes with hard hand when the assembly becomes unruly and unlawful. Coming to right to form union and association. So yes, please. Yes. Okay. Thank you then. Coming to the right to form union and association under Article 22, Clause 1 in ICCPR, and Article 19, Clause 1, Subclause C takes care of it. That so, a citizen of the country are right to form union and association, and this union and association is a right. But you will see that under the Unlawful Activities Prevention Act, there is a schedule. In the schedule, there are certain organizations who are banned by virtue of, putting it in that schedule, when it is found that this association or this organization is indulging into terrorist activity, or they are getting funds from the terror organization within the country or outside the country. And when there are information of such a nature, or then in that case, those associations can be banned also. So this banned associations list you can get in the Unlawful Activities Prevention Act schedule mentioned therein. There are certain associations, in the so state has right to the common people have right to form union and association, but this right is having limitations and restrictions, and state can actually ban certain organizations and unions considering that they are threat to this nation, or they are threat to the internal security of the country. So on these grounds, state has authority, and that would not be violative of Article 19, Clause 1C. Coming to the equality in opportunity of public service, we have already discussed this earlier in when we were discussing UDHR. So corresponding article is there in Article 25, Clause C, and 16, Clause 1 in the Constitution of India. Coming to the equality and equal protection before law and no discrimination on the basis of any ground such as race, color, sex, religion, language, etc. This right to equality finds place in ICCPR Article 26 and Constitution of India Article 14 and 15. 15 Clause 1. Now 14 I have discussed in detail. Coming to the one point that is under Article 15 Clause 1, state is empowered to make special law for the vulnerable section of the society. Now, who all fall in the category of vulnerable section? Women, children, aged people, people coming from socially, economically, politically backward class. So state can come up with special laws for these class of men. And that would not be violative of Article 15 Clause 1 or Article 14. I'll give you some examples of this law. That is, Dowry Prohibition Act, Prohibition of Child Marriage Act, Domestic Violence Act, Immoral Trafficking Prevention Act. So these are a few laws where you will find like a Bonded Labor Act. You have this, we have a lot of laws which have come under Article 15. These are special statutes where special laws are there, like for example, Prenatal Pre-Diagnostic Techniques Act, that is where sex determination could be done. So regulating that, stopping sex determination. And fortunately we would find that this year 2021, last year, the Ministry of Health and Family Welfare's annual report shows that there is the sex ratio which was very pathetic state, in very pathetic state. That means it was initially 826 girls to 1,000 boys. Now the statistics which was published in 2021 shows that there was per 1,000 boys 1,005 girls. So the statistics have improved because of the stringent implementation of law and also the government's policy like what? Beti Bachao, Beti Padhao, or providing lot of schemes where if parents save 100 rupees for the girl in account, there are a lot of schemes in the bank where the state is going to again provide 100 rupees. So that there is certain limits to it. So these kind of schemes and policies helped in increasing the sex ratio or improving the girl-child sex ratio in the country. So this is a positive a positive change which we are seeing because of the law the policy which the government of India is taking by virtue of Article 15 Clause 1. Coming to protection of interest of minorities, I have already discussed this in brief earlier. Just mentioning the Article 27 that takes care of it in ICCPR, and Article 29 Clause 1 and 30 talks about in the Constitution of India. So this was my third part of the discussion. Coming to the last part of my discussion, that there are some rights which were not earlier included in the fundamental rights, but were available in ICCPR. They were considered as fundamental rights by various judicial pronouncement. Some of them are right to fair trial, right to privacy, right to legal aid, right to travel abroad. And now I will be dealing with them in the details in later part of this article. So right to fair trial, it is by itself a very important fundamental right. When we are having right to equality, right to life and personal liberty, and we are having Article 20 and Article 22 in place, so automatically right to fair trial is a fundamental right now. So what do we mean by fair trial? I'll give you one example here. One example is that when Kasab was arrested after the second Mumbai blast case, the Bar Association took the decision that nobody is going to represent Kasab in the court, because Kasab is a Bangladeshi terrorist and Pakistani terrorist, and has come to India and killed people randomly. So Bar nobody wanted to stand on behalf of Kasab for his trial or bail during investigation. So at that point of time, state owes a responsibility that if there has to be a fair trial, then the accused have to be represented. Accused have to be represented, and we already have the provision as a fundamental right, that is legal aid. Article 39 capital A was added by virtue of amendment, and we also have under this legal aid provision to implement the fundamental right of Article 39 capital A, we have Legal Services Authorities Act in place. So Legal Services Act provides for two fora in particular, that is National National Commission for that is Legal Services Authorities, and State Legal Services Authorities. And state at the district level, we have District Legal Services Authority. So this legal authority, institution, takes care of having a panel of lawyers who would represent the accused in the state district fora, in the high courts, and in the Supreme Courts. Apart from that, the Legal Services Authority provide, through the compensation which has to be paid to the victims of criminal justice administration, is been routed through the legal services authorities. So the money is being given by the central government to the state government, and the authorities, legal services authorities, take care of disbursement of that compensation to the victims of crime. In particular, we have victim compensation schemes, and that victim compensation schemes which are come up by the state, this also came up with because of the Supreme Court judgments and judicial pronouncement, there was a movement throughout. And so the disbursement of the compensation is done from the legal services authorities. So, right to fair trial. Coming to right to privacy, in right to privacy under Article 21, long time back in Madhukar Narayan Mandekar case, Supreme Court laid down that women of easy virtue also has right to privacy. And later on, the latest case is the Puttuswamy case, where you will find that the Supreme Court laid down that, the Puttuswamy case is the big data case, or Aadhaar case, where you will find that, Supreme Court laid down that people have right to privacy, and state cannot take away this right, and state has to see via way how the right, right is not protected, and still the work has been done, will be taken care of. So these are few new rights created by the Supreme Court, which was not there in the Constitution when in the chapter fundamental rights, but we find these laws have come into existence. So I was talking about the fourth part of my discussion is the economic and social and cultural rights, which were there in the directive principles in part 4 of the Constitution. And, the Supreme Court had lifted it from the directive principles of state policy and incorporated or interpreted those rights under Article 21. So I'll do it very briefly. Now, India ratified this convention in 10th April 1971, and most of the provisions of this economic and social and cultural rights found place in the directive principles. But due to the judicial activism, we find that that has been incorporated as fundamental right as well, some of them. So we will talk about that. Right to work. Now, right to work was there in Article 6 of economic and social and cultural rights. In Constitution, we had it in Article 41. So right to work, that there are certain Government of India scheme and policy whereby 100 days work has been provided to the people, and it would be given routed through the state mechanism, and everyone who wants to work will have this opportunity availed in that particular scheme. So that was not, that was the policy of the government, and now you find it placed in the system. Equal pay for equal work. This was challenged in the Supreme Court, and then Supreme Court, interpreted or said that the people would have to be paid equally for equal work. Earlier, what happened? Women and children were paid less, and for male adults, the payment was more. So this was considered as discrimination, and because of that, Supreme Court had to come with hard hand. This right is protected under the ESC in Article 7, Clause A, Subclause 1, and this finds place in the Article 39, Clause D. And you will find that Article 39, Clause D has been interpreted under Article 21, and the Supreme Court has made this a fundamental right in today's time. So there cannot be discrimination if the work has been taken by anyone, an adequate number of hours. Then in that case, equal payment has to be made. So children cannot be taken into hazardous work. So in that case, when children are taken into work apart from school hours, then in that case, for the number of hours equally, the amount has to be calculated and payment has to be made. So this policy decision has been taken, but we find that this is not been implemented in the field adequately, because contractual workers are paid separately. We have Contractual Workers Act, and the permanent workers are paid separate wages. So there is discrimination, no doubt, but that is discrimination on the ground that the number of working hours are taken less in contractual setup, and in permanent setup the number of hours are more. That is what the organizations claim, and that is why they get away with it. If that could be proved in the court of law that the number of hours were not equal, then in that case they would not get away for it. So labor organization has penalties and punishments for it, and even the organization could be blacklisted also. That is also there. Coming to the next article, that is right to living wages and decent standard of life. So the minimum wages have to be such that a person can maintain a standard of life. That is mentioned in Article 7, Clause A, Subclause 2 and D. So in ICESCR, but in Article 43 we have the similar provision in the directive principle of state policy. Coming to human conditions of work and maternity leave, we have in Constitution of India Article 42, and in economic and social and cultural rights we have in Article 7B and 10(2). Now on Article 42, Government of India has come up with the Maternity Benefits Act, and recently Maternity Benefit Act has been amended. It has been extended to contractual workers as well. And if an organization removes the women from service, from contractual work, if she is pregnant, then the woman has right to sue the organization and get payments of the entire period of her pregnancy, and restoration of her job can also be done. So this is a new change to the law. Coming to the faculties and opportunities to children, facilities and opportunity to children for prevention against exploitation, that I have told you, Prohibition of Child Labor Act we have, so by virtue of Article 39, Clause F, and Article 10, Clause 3 of economic, social and cultural rights. Coming to improving public health and raise level of nutrition and standard of living, that is under Article 11 of Economic and Social and Cultural Right. Corresponding article in Constitution of India is 47. So, state is going to provide public health services. And, that on this ground, you will find that, state has come up with schemes that is, Jan Aushadhi schemes, and lot of, their cards, medical cards have been provided by the state, and a lot of facilities are given to the common people with the West Bengal government has come up with Swasthya Sathi card. Central government has come up with such kind of schemes. So state is responsible under Article 47 to have these provisions of schemes and policies in the system to take care of the public health and raise level of nutrition and standard living. So raising level of standard nutrition in the Food Security Act also, you have provision whereby, state is going to take care of the women who is pregnant and, provide proper adequate nutritious food, or if state is not able to provide the food, state is going to make payments to these pregnant women who register under these schemes, and they would get benefit under the Food Security Act. Similarly, for the children who are going to the school, having the midday meal, the food which is provided has to be nutritious, and at least, they would take care of the nutrition level of the children of that particular age. And that is because of the schemes under Article 47. Coming to the compulsory education for children, that was there in Article 45, I told you, of the Constitution, and then it became a fundamental right under Article 21, capital A. So discussion we have done. The corresponding article in Economic and Social and Cultural Rights is Article 13, Clause 2, Subclause A. Coming to the protection of interest of minorities, we have already discussed earlier. So in the economic, social and cultural rights also, it finds place in Article 27, and so corresponding article is Article 29, Clause 1 and Article 30. So these were the corresponding articles in economic, social and cultural rights. So there are unenumerated fundamental rights. A number of rights that were made available in the Covenant were not available in fundamental rights at the time when the Constitution was enacted. But you will find through the judicial pronouncement, we have them in the law in present time. One judgment here is, ADM Jabalpur versus Shivkant Shukla. Here, Apex Court held or observed that law of the land does not recognize any natural or common law rights other than specifically provided in the Indian Constitution. So it was, it was negatively interpreted, but that was positively interpreted in Menka Gandhi versus Union of India. So I told you Menka Gandhi was denied, to leave the country, and her passport was seized by the agency. So what happened was that she went to the Supreme Court under Article 32, claiming that her fundamental right to travel has been violated, and her personal liberty has been violated or curtailed by not allowing her movement and seizing her passport. So in this case, Supreme Court Justice Bhagwati made an expression that personal liberty in Article 21 is of a widest amplitude, and it covers a variety of rights which go to raise the status of constitute the personal liberty of man, and some of them have been raised to the status of distinct fundamental rights and given additional protection under Article 19. So no person can be deprived of this right to go abroad unless there is a law made by state prescribing the procedure for so depriving him, and the deprivation is effected strictly in accordance with such procedure. So this was the judgment of Menka Gandhi. I kept on talking about Menka Gandhi. The Supreme Court has taken an approach of theory of emanation, and in order to make fundamental rights active and meaningful. So, I told you that, that there were certain cases where Supreme Court had relaxed this locus standi, and anyone could go to the Supreme Court under Article 22 and go to High Court under 226 and would get redressal of the violation of fundamental rights. So some of the cases, I'll just give a reading. I don't think so I will have much time, but I'll just give a reading. These are the case laws: right to live with human dignity, that is PUCL versus State of Maharashtra; right to clean air, MC Mehta versus Union of India. This is Taj trapezium case. In this case, the color of the Taj was becoming yellowish because of the industries which were there in the surroundings of the Taj Mahal. And so Supreme Court wanted to take, MC Mehta filed this case asking to clear the give this right clear air. Right to clear air is a fundamental right of the citizens of the country, and so Supreme Court came with hard hand in this case. Right to clean water. That means, the drinking water should be potable water, and the river Ganga should be pollution free. Then right to freedom of noise pollution, so noise pollution case. But in pollution, noise pollution, you will have to understand that if it is a railway station, the security of the people are more concerned. So I'll not take much time. Some of the cases I have already discussed. Hossainara Khatun, speedy trial and legal aid. Khatri versus Union of India. This is the Bhagalpur blind case on which you have a cinema also. Then Olga Tellis, Bombay Municipal Corporation case, that is right to livelihood, right to food, right to medical care, right to clean environment, and right to privacy. These are few cases, and at the end, I would say that Supreme Court has taken a proactive role in creating new rights. In creating new rights through interpretation of Article 21. And so by this, I would end my discussion. I am thankful and grateful to the participants patiently listening to me, and now I am open for questions. In the middle, I had to say thank you to my students because they were also live in my class. There was another, I had actually asked them to attend this session. So thank you.
Thank you, Kavita ma'am, for a very comprehensive session. It was really interesting, and your students can also watch the live because this is it's already going live on YouTube as well.
Some of them I had asked them to register, and but they have other classes as well. So they can do it later on. Yes. I know you have shared the link with me.
Yes, they can watch it later. Ma'am, due to the paucity of time, dear participants, we will take up only 1 or 2 questions because already the second resource person has joined.
I'm so sorry.
It's okay, ma'am. It's okay. Because this is a training program, and the way you have explained, it was really in an elaborate way. And I would say you completed a module. It was like that. So those who have any questions, we'll take up 1 or 2 maximum. They can unmute their audio and please ask the questions.
I can also suggest that you can write to me. My email ID, I'll write it in the chat box. So you can give the query to me through my email also. 1 or 2 will take up. Yes.
1 or 2? Yeah, 1 or 2.
You want to go first?
Directly.
Yeah. Hello? Am I audible, ma'am?
उनका mic mute हो गया शायद. हाँ, mic is mute.
Oh, I had muted because there was an echo coming, no?
It's okay, ma'am.
Yeah, ma'am, I had a question about UAPA. So you mentioned UPA quite often in this session, right? So my question was, is state using UPA Act too liberally right now? If yes, how that can be countered, if at all? If no, why you feel so?
Why do you mean? What do you mean by liberally?
So some time back, I read that in past few years, 7 years to be precise, around 10,552 cases of UPA were like people were
accused of
filed for UPA. So my question is isn't that too liberal? Don't you think that?
If you see the population, country's population, and you compare it with the terror activities which are going on, okay, and this terror activity by itself is very difficult to be investigated by the investigating agency, right?
Okay.
And, no criminal would come and say that I have committed the crime. Do you expect this? It is very difficult.
So do you think?
No,
Yeah.
so let me complete it.
Yeah.
So there may be people who are apprehended just on the basis of suspicion.
Okay.
Okay. Now, it is a, it is for all the pillars of criminal justice system, say the court, the prosecution, the investigation, to take care of that, protection of human rights of the accused persons are there, not violated. Okay. Now, to start with an investigation, the investigating agency is randomly picking up people and booking them. That may not happen because they also have to face the human rights organization. Because human rights activists are there, and now people are more aware of the human rights.
Okay.
Even the accused people are aware of. So randomly people cannot be picked up under UAPA. If you are saying that 10,000 or more people have been apprehended, there might have been suspicion on them and some prima facie evidence against them to actually comprehend them. Otherwise, court will not take cognizance. And these courts, UAPA courts, are special courts. They are not normal courts. Had you said that, cases of rape randomly filed, cases under POCSO is misused, cases under, the Dowry Prohibition Act is misused, domestic violence is misused, I could have actually accepted your approach. But when it comes to offenses under UAPA, we have a specialized agency investigating. What is that specialized agency? National Investigating Agency. We have a specialized prosecution. Those people who have 10 years more experience of trial, they are taken as special prosecutors under UAPA. So, the judges who sit in these courts, UAPA courts, they are special courts. So they are also having experience of more than 10 years sessions trial cases. So that way, they would not take cognizance if there is cognizance only on suspicion. There has to be some material evidence.
So, just a small follow-up question. I got what you're saying, the crux of it, but a case that comes to my mind right now, right at the top of my head, is Father Stan Swami. So, do you think that in that case there were enough evidences to go forward with that case? And
okay, so let me tell you, this is a sad state of situation where there was a custodial death.
Yeah.
Custodial death per se is a crime, and people who are involved, if there is a custody death, there is a whole procedural safeguards available, and there would be a committee set up to inquire. And the people who have been made responsible, who are responsible for the death, would be taken care of. Okay. Now this is one incident. You cannot compare it with the entire system. Okay.
Yeah, but
apart from that, what happens, in the UAPA, say I am teaching terrorism, right? And I have lot of materials on terrorism, and I keep, say, researching on it, suppose. Then in that case, I may be apprehended under the law. I have a chance, because when I was doing my PhD, I got threat calls from terrorist organization that why I am so much interested in researching. Even from the investigating, state agencies, I got threat that why are you so, and I was being followed in my researches by authorities. Okay, so the reason is that state is having a surveillance system to see that people are, or to take care of that people do not indulge in such kind of activity. So there may be one or two situation, or there may be, say, 1% cases where apprehension is based on these kind of evidences. There will be a raid in my house. They say the the law enforcement agency, NIA, will come to search and seizure in my house. They will find lot of materials on terrorism, terrorist activities, and terror-related materials. So then I may be initially apprehended for it. And then I have to justify that, I am a researcher, I am a activist, I am working for the people who are victims of terror. And therefore, I have to satisfy the investigating agency that I am not indulging in terror activities, but I am, on the other hand, trying to study the law, and on the other hand, trying to help the victims of the terrorist activities. So there may be chances.
Yeah.
Getting my point? That is the situation.
Thank you so much, ma'am. You explained it fully and elaborately. Thank you for your time. Thank you.
So I may be permitted to leave?
Yeah, sure.
Ma'am, just a minute. Just kindly wait. Diana, over to you.
Thank you, ma'am, for giving us an elaborate insight into human rights in context to constitutional provisions and international instruments, and frequently juxtaposing it with the respective cases and their verdicts. I specifically would like to mention Article 13(3)(g), wherein a perpetrator cannot be forced to be a witness against own self. I believe many of us were not aware of it in Indian Constitution, because in US law, since we are so familiar with series and all, so we know more about US law, and we come across when we are watching series, like they plead the Fifth Amendment. So that kind of was a new information for me. And once again, I thank you so much for your time and expertise. Special thanks to NHRC for sponsoring today's training program. Thank you, ma'am.
Thank you all.
Thank you, Kavita ma'am, on behalf of the entire BSS family. Looking forward to have a long association with you. And thanks to Anurupa for connecting us with you. Thank you, ma'am. Have a good day.
Okay, thank you all.
Dear participants, you are requested to kindly fill the feedback form for the first session. We are going to begin the second session in a minute. Good morning, sir. Sir, kindly unmute your audio. It is muted.
Good morning, Dr. Shiva.
Very good morning, sir. Hearty welcome to the session. Diana, I would request you to accord the welcome speech.
Over to you, Annie.
Session 2 of this training program is on human rights institution in India. For this session, we have our expert speaker, Professor R.R. Patil from Department of Social Work, Jamia Millia Islamia, New Delhi. Professor Patil has around 14 research publications, articles, journals, and academic conferences to his credit. He has received funding from a number of UGC programs. In addition, he has made a significant contribution to the empowerment of vulnerable indigenous groups. He has also been invited to participate in a number of national and international conferences and workshops. I welcome you to the program, sir, with great pleasure and honor.
Thank you, Dr. Shiba, the organizer of this one-day national training program on human rights. I also thank Father John PJ for arranging this training program for the students. As Dr. Shiba requested me to speak on Protection of Human Rights Act 1993, initially I was saying that it's not my area, but then on her insistence only I could able to take this invite to at least deliver a talk on this particular topic. Ideally, I feel that for this, am I audible to all?
Yes, sir.
Ideally, for this particular topic, especially the act and the legal aspect related to human rights, the legal person or any advocates or the practicing lawyer, or for that matter the high court judge and the justices are the I think better people to talk about it. But then I think this program is uh, for the students of the Bhopal School of Social Sciences, Department of Social Work. I thought I should give my um views about what is this human rights all about, and this institution called National Human Rights Commission, how they are empowered to take action in terms of to handle the different issues of human rights. How does this particularly workshop has been conducted? It's in interactive mode or it's a lecture mode, Dr. Shiba?
Sir, it's a participatory approach. You can explain, and then we can, request the participants to raise the questions.
Okay, fine. That's fine. So total, I can see that there are 50 participants. I hope that these are again the all student as well as the faculty members of your institutions. Is it?
Yes, hardly 2 to 3 faculty members, and rest all are students.
Okay, so I have few questions, and then then I can begin with my session. Basically, I had designed my session in the light of first giving you what is this all human rights about, what is this right-based approach in general. At the same time, I may talk about that what are the factors responsible for the human rights violation in the Indian context. And then I will talk about objectives and different chapters, as well as the sections of the National Human Rights, the Protection of Human Rights Act. Then what is the composition of NHRC? This is what Dr. Shiba insisted me to speak on. And then what are the achievements of National Human Rights Commission, and what is the relevance of this particular National Human Rights Commission from the social work point of view. But before going into detail, let me know from the participant, what do you think about the human rights? What is it? Anybody can start, at least.
Basic rights that a human being is entitled to.
Okay. What else? Any other things comes in mind?
Which gives value.
Which gives?
Value to human being.
Value to human being. Okay. Basic rights, value to human being. What else?
The basic right without which a human being can't function. And if human rights are violated, the very fabric, the humanity, that is violated. So that's the basic, those are the basic rights that each person must have, human rights.
Okay, fine. Can we also take in the terms of the human rights, or the rights are something called as the normative? Human rights are more in terms of ethical point of view. Human rights are also something called as more from the values point of view. These are more inherent in the context.
Right. We totally agree with it.
Okay, fine. So in this particular context, what I'll do, I'll just ponder upon the content which I had designed for this lecture. I'll start with what is this human rights, how human rights has been considered as the important for the human life, liberty, equality, and the dignity in the society. What are the factors of human rights violation in the context of India? And then I'll take it further discussion towards the Protection of Human Rights Act as a legal instrument which has come into the existence. What is the reason behind this particular act, why this act has come into the existence in 1993, and what are the different provisions under this particular act, and what are the achievements of this particular act so far, from the point of view to understand as a social scientist and then social work educators, as well as for the importance of it for the student social worker. When I look at it, the human rights or the right per se as something called as a normative kind of aspect, where it has been considered as being born as a human being. It is the inherent right of the individual. It's a very essential for any human being to have certain basic rights to live in the society. So it means that the human rights is basically talks from in the context of the norms, what are the values, what are the normative kind of framework one should have for the society. And this normative framework basically visualize that the society should be based on the equality, liberty, and on the basis of the other's dignity, as well as it is more talking in the context of the life of the individual should be respected in the society. So it is probably, if I can say, that the normative society or normative framework, if you can look at, then only you can find that there is the something, there is a kind of practice should any society should believe in or practice it, where the other's rights should not be violated. Otherwise, if you don't look at it from the normative point of view, it has been the very different situation that even if you are doing any kind of human rights violation or the killing, or in that context, if you are harming the other, it is more like an acceptable concept. So entire logic of having the rights or the human rights, it is remain in the one particular kind of normative framework where one respect the other's rights. At the same time, the others are getting equally accepted in the society with the way he or she is in the society. And suppose any society doesn't believe in this particular aspect, doesn't make any sense for them what is the rights and human rights per se in the society. So one has to understand this particular framework first, that this entire the rights as the framework, or rights as the one particular aspect, it is all based on the kind of society you are living and how the society is respect to your rights in the society in the context of the norms set by that particular society for their own citizen, or for that matter, for their own people in the society. So
yes. Sorry to interrupt. Sir, are you sharing a PPT?
No, I won't be sharing. Rather, I said that I will be going with the more extempore as a class discussion, and the PPT I will be sharing with you later.
Okay, sir. Thank you.
Is that fine?
Absolutely okay.
Okay.
I was just trying to make sure that because it was not visible, so I thought I'll ask you.
No. I'll be sharing my thoughts, and then probably I'll share you the updated PPT later.
Okay, sir. Thank you.
Okay. Yeah. So basically, one needs to understand the rights in the context of the norm. At the same time, I also feel that when you talk about the rights, it's also something as the more inherent for any individual who is existing in the society, or who is living and surviving in the society, and it is his certain inherent right to live, right to freedom, liberty, in his dignity in the society. At the same time, the kind of equal treatment he should get into the society. So second aspect one can look at about the human rights. It is the inherent rights of the individual, which is given to the individual as being a human being. But then that doesn't mean that it should not be also extended to the animal, because they also have their own existence in the society. But since we are talking here in the context of the human right, I feel that it is more one has to look at the normative framework of the any society. And the second, it is also in the context of the inherent rights of the individual or the human being in the society. While taking this particular kind of framework, I will further proceed and will say that human rights is also been considered as something called as the more constitutive relevance, or it has its more constitutive relevance. That is, it is essential for the survival of the human society, its survival of the individual, and without this particular human rights observation, the people cannot live in the society. At the same time, one has to also believe that the human rights is also an instrument, has also an instrumental relevance, that it is agents of the one particular situation, or it is the situation in which one lives, which makes that particular thing is possible. Now, if I can give an example of that, what is the constitutive relevance as well as what is the instrumental relevance of the human right, I will say that there is the situation of right to livelihood is basically the constitutive relevance of the any human being to survive in the society. Because if he has right to livelihood or right to employment, obviously his right to food will taken care of. So it means that the human rights approach has the interconnection between constitutive relevance and the instrumental relevance. And when we achieve our constitutive relevance of the rights, it means that automatically our instrumental relevance is taken care of. So if I give an example of that, if there is a right to life is secured in the society, it means that many other socio-cultural, civil, economic and political rights will be taken care of. If I give an example by saying that if there is a right to employment, it is ensured in the society, obviously the individual right to food is also automatically ensured in the context in the society. So this is what the again another way one can look at it when we draw ourselves from the entire concept or conceptualization of the rights. That is from the one is from the normative framework. Second is, as I said, from the point of view of the that inherent rights of the individual. Third, it is how the human rights has its own constitutive relevance as well as the instrumental relevance. One has to also think in the context of the rights also having the potential to liberate people from the situation of their own vulnerability. So it means that if you are protecting the rights of the some people or protecting the rights of the people, those who are into the vulnerability, you are also in a way uplifting them from that particular situation of drudgery, or the uplifting them from the situation of vulnerability or the deprivation. So it means that the right-based approach or the human rights approach is also something indicating about that you are doing the well-being of the society. You are also doing the welfare and the empowerment of the society by helping or extending the hand to the people to come out of that particular situation. And hence it has also the meaning, it has also the essence of empowerment of the people or the welfare of the people. When I go a little further from this particular social conceptualization, and when I look at it in the framework of the country or its legal system, or for that matter, the kind of the rules and then regulation under which we are governed, it means that the human rights approach is also provides a legitimacy to us, or it is basically legitimacy to demand for making the certain kind of rights under the policy making or under the rules of the government. If suppose one or other particular group is suffering because of some or other kind of deprivation, or for that matter the vulnerability, or for that matter for the certain kind of issues, they can demand for their rights or demand for the certain kind of protection from the government. So it means that the human rights are basically providing the legitimacy to the deprived sections as well as providing the legitimacy to those who are suffering in the society to claim certain kind of rights, to claim certain kind of entitlements in the society because they are there into the situation of vulnerability. Like if I give an example of the Article 21 of the Indian Constitution, which provides right to life. And when I see that right to life in the context of the people, those who suffer because of not having the proper home, or those who are on the payments, or the homeless population, and they are suffering because of, during the winter season, especially in the Delhi, because of the severe cold, if they are suffering and if they are dead because of the severe cold. And if somebody is asking for the night shelters or the rain baseras for these homeless population, so it means that it is legitimate demand from the certain sections of the society, because they are suffering in the society because of the situation. So Article number 21 is basic under the Indian Constitution. It basically protect you from the certain kind of adverse situation or vulnerable situation. Or for that matter, take another example. If people are dying because of hunger, and if they don't get the proper food, or if they don't have the proper food with them, and if they die because of hunger, it means again under the directive principle of state policy, it becomes any government, and the Supreme Court gave the direction to the government to protect the rights of to protect the right to food of the people, those who are dying because of hunger. So it means that the rights also provide the legitimacy to the people to basically to get the attention from the policymakers to the government, and accordingly certain entitlements and certain kind of assistance can be created from the government side. When I see this particular context, and then when I look at it from the point of view of which I discuss about that, how it is basically giving us the legitimacy, it is basically also makes the vulnerable population, if I take the discussion further from the legitimacy towards the what is the claim making kind of situation of the people, that every person, those who are not having their rights in the society, he can also be the claim making individual, and holding the equal members or position in the society from the legal point of view, that any constitutions of the country or any government can also give the justice, or they give the right to that particular vulnerable section from the point of view of as a citizen, irrespective of his age, race, sex, religion, ethnicity, religion. It became the citizen, and the citizen's rights considered to be more important, and it is recognizing that every citizen under the constitution, every citizen under the government has its own rights in the society, and that is important for the larger development of the individual, his human rights protection, as well as in general developmental process. Then the last aspect, which is in the context of the human right, is basically it is the responsibility of the government and the different developmental institutions, policies, and programs to take into account the human rights of the people, and how this human rights situation in the one particular society or in the one particular kind of geographical context. So it means that it is also the government take largely the initiative, because they are the governing the larger citizen, and then they basically protecting the people from the all kind of vulnerability. It is in the context of that the governments and the different institutions, whether the national or even for that matter sometimes the international institution, and different policies and programs, it became their responsibility to take care of the citizen and minimize their vulnerability. So when I look at it, all these conceptualization, as I talked from the point of view of the normative framework, then again inherent rights of the individual, when I talked about the constitutive relevance, instrumental relevance, how it is empowering the individual, how this rights itself is make the kind of legitimacy or the claim making individual in the society, or for that matter, when I talked about that, how the rights of the vulnerable group, it becomes the role and the responsibility of the government to protect those people, those who suffers because of the human rights violation, and then the further institutions and the different policy and programs generated for the protecting the human rights of the population. It means that when we look at it in the context of the individual and then conceptualization of the human rights for him, it basically gives us the vast information related to the how the human rights tradition or the human rights process, which is started from the inherent rights toward the normative process towards one particular institutions or the government should take care of it, take care of the individual's right. So it also means that if there are the individual who are there in the society and his human rights include the civil and political rights are also been taken into consideration by the government. At the same time, his socio-cultural and economic and political rights also been taken into the consideration. But what basically happens within the society, there are the one particular aspect which is basically considered to be more complementary for the human rights, and that is socially inclusive society. And if you don't have the socially inclusive society, then it is in that context you will find that there is the chances of the human rights violation happens in the society. And it is in this context, as a social work student, one should understand that whether human rights are the more inherent right, value-based, it is more normative framework, but then suppose our social environment, our society is not inclusive, it is not accepting the diversity, if it is not accepting the others, if it is not taking care of the individual group or communities with its cultural differences, if it is not taking care of the individual group and communities with its socio-economic differences, or if it is not giving the opportunity to the people to participate into the various aspects of the democracy, then there you will find there is a violation of the human rights in the society, and it became more systematic violation in terms like it is the individual civil and political rights getting violated, at the same time individual socio-cultural, economic and the other aspect getting violated because of the social exclusion which is practiced in the society. Do you think that the social exclusion can be the one aspect which one should considered as the one of the factor for the human rights violation in the society? Do you feel that the social exclusion has the relation with the human rights violation in the country?
Yes. Yes, I think that. Am I audible? Yeah. So yeah, I feel that social exclusion is an important component that needs to be considered.
Okay.
Yeah.
Any other any example?
Any example? So, what happened in Myanmar with Rohingya Muslims, right? And elsewhere also, like for Jews also, right? So that was exclusion to some extent, to a great extent actually, right?
Okay. Any example from the country?
From the country. So yeah, recently I was thinking about churches being like question for religious conversions, and they had to go through a lot recently, right, when they were celebrating Christmas. So that comes to mind. So there is the segregation, and when you were pointing out that there's this exclusion, social exclusion that results in human right violation, I was thinking, yes, so it is embedded in the society. That is what you're saying. So when we are countering that, we need to counter that on a social level, right? That is what you were saying, getting at.
Okay, okay. Any other people you have talked about the church and how the church has been facing this a kind of different kind of situation in the country. Any other example if we can talk in the social cultural context of India, where the social exclusion is equally affects the people's functioning, their rights.
I'd like to share a incident that happened with my friend recently. So that's an incident that happened with my friend. I can't say that it has social repercussions, but I have been really disturbed by it. So I'll share that with you. So she was trying to find a home in the city in Bhopal, and I won't mention the religion, right? Because that's not the point here. But because on the basis of her religion, she was not given accommodation. So like people were not renting out apartments to her because of her religion. So that is exclusion, right?
Okay, good. Okay, so some of these things I'll be discussing in this lecture is basically I'll try to relate that if the background, if it is provided and more inclusive background is provided in the society, then you will find there would be the less chances of human rights violation. But then suppose if there is a social background, it is more socially exclusion, based on the socially exclusion. In that context, you will find there would be many chances, or there would be many incidences of exclusion and many incidences of the discrimination one can find in the society. And this is what I say, that how the situation becomes more conducive for the protecting the dignity, right, dignity, life, equality, as well as the individual's liberty and in the society. But at the same time, there is a situation itself, or the social fabric itself is based on the heterogeneity or the social exclusion. You will find that the human rights violation takes place more in that particular society. And the India could be the best example to find this kind of social exclusion based human rights violation, because of the different practices we have in the society. It is the practices based on the caste system, practice based on the religious differences, practice based also on the multi-religious kind of country, multicultural kind of aspect are there. And it is in this context one needs to understand this particular social exclusion and how the social exclusion largely affects it. Now, when I talk about the social exclusion, one needs to understand this is the process, or the social exclusion is the process where the certain number of people or the some community have been deliberately excluded from this society, or for that matter, the certain community are kept away from the certain services or the certain facilities of the society. So it means that the social exclusion is where individuals' social identity, social class position, his living standard, and the other socio-cultural aspect becomes the hindrance for his inclusion into the larger society. And this is what in the broadest sense, when I talk about social exclusion, is basically the process through which the individuals or the groups or the community are wholly or the partially get excluded or kept away from the society in which they live. And this very much practice you can find in the Indian society, where you will find that the one particular community being discriminated, one particular community has been deliberately kept aside from the services of the society. Certain community has been kept away from the certain civil, political, cultural, socio-economic rights of the society. So it means that this particular social exclusion has, one can understand it from the multi-dimensional point of view, and this multi-dimensional point of view has its own genesis in the discrimination which is practiced in the society, or the social exclusion is practiced in the society on the basis of the gender. The girl who had shared the example that probably the gender is the one element of the exclusion, or for that matter, the not only the gender, but then the religion of the individual is must be the one element of the social exclusion. So discrimination and the social exclusion is practiced on the basis of the gender, sometimes based on the ethnicity, also based on the race. In the context of India, probably the race may not be that relevant, because we all have the different mixed kind of color. And moreover, one can never see that discrimination takes place on the basis of race. Only in the context of the Northeast and then the mainland people, there you will find the racial kind of discrimination takes place because of the kind of features and figure individual has from the different region. But then in that way, there is no racial as kind of discrimination is there. Discrimination and the social exclusion also take place on the basis of the color. Again, in the context of the color, I may not say that the color really makes that kind of social exclusion discrimination. Yes, especially in the context of the female, at the time of marriage, this particular color is become the dark color is become always the problem from the bridegroom side. So this, again, I will find that the color and the race may not be that relevant in the Indian context. But yes, the caste, gender, ethnicity, religion, individual social status can lead to the social exclusion, and thus it's also violate the human rights of the people in the society. So one has to look at this particular aspect in the context of the human rights violation, and especially the social work student, that how the caste becomes the elements for the social exclusion, and then the human rights violation. How the ethnicity or the tribal background becomes the elements for the social exclusion, and then the human rights violation. How individuals' religious status becomes the elements for the social exclusion, and then it is in more human rights violation of the individual. So it means that one needs to understand the human rights approach in the context of the social exclusion, and then one has to understand whether this particular the social exclusion provides equal opportunity, or it is the social exclusion itself become the one of the factor for the human rights violation in the country, which not only affect the individual survival, but it also affects on the other basic rights, like the right to work, right to education, right to health, right to various other kind of developmental facilities, right to shelter, right to leisure or the entertainment, right to different kind of civic amenities or the different services and facilities. So it means that the social exclusion, which creates human rights violation and affect the many other basic human rights of the individual, it is basically preventing the individual who is the part and parcel of the one particular socio-cultural society, or who is the part and parcel of the one particular state as a citizen, who is not getting or who is not obtaining the different kind of services, just because he has been discriminated, just he has been socially excluded from the society, and hence he is not getting all his basic rights in the society. So it means that one needs to understand the caste, tribe, and minority as the one of the aspect which is affects in the Indian society. Now, when I look at this particular approach, and and look at this right-based approach in understanding the social, cultural, and economic situation in the Indian context, I feel that there are different kind of stigmatization or discrimination, or for that matter, as I talked about, the social exclusion has created the human rights violation in the society. And this human rights violation, one needs to understand in the context of India, that how different factors responsible, and what are these factors in the Indian context. The Professor T.K. Uman, basically, when he is a sociologist, when he talks about the the four features of the Indian society. In this, basically, he talks about there is the situation called the stratification, which is there in this society. Now, the stratification is something like which is the unequal division in the society, and this unequal division in the society based on the class, gender, age groups. It is, although it is the universal phenomena, when you look at this particular unequal division within the society or inequality in the society, which creates a different kind of disparity in the society. So stratification in very sociological terms, it is something called the classification of the society, but this classification of the society is become the responsible for the disparity because it creates the haves and have not. It also creates the class-based division. It also creates the something which has been said that this is the one particular gender suffers more because of if she is not been economically having the livelihood or the self-sufficient economic aspect with her. Or the people who are there in the society, they suffers because the distribution of the material resources is not equal. It is also that their prestige, power, or for that matter, their dignity in the society is not again the same when you compare to the other. So it means that they become the victims of the inequality, and especially the poor, unemployed, unorganized sector labor, the women, children, elderly people, or for that matter, mentally challenged people or mentally handicapped people becomes the victims of this inequality or this particular disparity. So in larger sense, it is when it is there that the stratification is basically more acceptable in and the more universal phenomena, but then the deliberate kind of inequality or the having the possession over the certain kind of resources by few people, it creates the situation of victimization, or it creates the kind of situation of disparity for the other, and this is how the homeless population or the poor or unemployed and the other people suffers in the society. So first situation, first factors of the Indian society, that is stratification, create the disparity in the society, and this disparity creates the further human rights violation of the people belong to the poor section or unemployed, unorganized sector, even for the women, children, elderly population, physically and mentally handicapped people. Now, the second situation or the second factor, that is the heterogeneity which is there in the society, and the most contemporary societies you will find there is heterogeneity. Now, there is something called as the homogeneity, where the similar kind of people are there, and there is something called as heterogeneity, where you will find that the multi-religious, multi-caste, multi-group, multi-community people are there. So basically, heterogeneity is basically more in terms of by the race or again the religion and language you will find in the in the larger society. In the Indian context, you will find that there is a heterogeneity on the basis of the caste, again on the basis of religion, on the basis of language, on the basis of region. You will find largely in the Indian context. What is this heterogeneity? One way to understand heterogeneity, that the heterogeneity gives us the different kind of color, tradition, views, values, and it also been considered as the one of the assets for any of the country, like the unity in diversity, and we always respect this particular diversity because we are from the different socio-cultural background. But then in some of the time, this heterogeneity itself again create the discrimination in the society, and this heterogeneity also it makes the other person the outsider in the society. Other people's rights are not protected in the society. The one particular dominant group belong to the one particular socio-cultural background, or the socio-religious background, or one particular linguistic background, or one particular regional background, is try to keep aside or keep away the other person who try to intermingle or who try to be part of it. So it means that the heterogeneity is the situation where the other people are not largely accepted. Rather, they get very less chance to be part of it. Rather, this heterogeneity, it creates the problem for the people, those who are considered as an outsider. And this particular situation of the outsider is basically affects the larger community's fabric and the violation of the rights of the people in the society. Now, what does it further mean if I give the further example that how heterogeneity create the discrimination in the society? Largely, if I have seen in the context of Delhi, the people, those who comes from the Bihar to the Delhi as a migrant labor or who settles here as the labor, they have been looked down upon by the others or the local people. Although the Delhi is a part and parcel of the many mixed culture here, but then the term which has been generally originates in the social context, that is probably the somebody calling as the Bihari, or for that matter the North Indian migrant who goes to the Mumbai or the Maharashtra, they have been termed as the Bhaiya. So it means that there is a something cultural chauvinism or cultural strangers are there in the society, and the feelings of the sons of soil becomes more dominant, where you will find there is one particular kind of homogeneous group doesn't accept the outsider or considered the fellow citizen of the same country as the outsider. So this heterogeneity is basically creates the discrimination on the basis of the sons of the soil and many other movement which has been came up in India, which is a party line that itself is which promote the one or the other particular kind of geographical area, one or other particular kind of linguistic group, one or other particular kind of socio-cultural group. But then largely heterogeneous nature of the Indian society has created more discrimination within the society because there is a very less opportunity for the others to intermingle in the fabric of the society. It has been more less equal. It is more prejudiced towards the other, more different kind of stereotypes you have towards the other people, those who comes from the outside. So heterogeneity creates the discrimination in the society. Now the third factors of the Indian society, and that is the hierarchy. And it means that again the hierarchy in the context of class, one can say that the poor and the rich, or one can say that it is something largely more privileged and the underprivileged. But then when this particular class gets combined with the hierarchical structure, and hierarchical structure I will talk in the context of here the caste system, you will find there is the exploitation of the people under the caste system. It becomes the most severe because the caste system or the caste-based discrimination, it has its own conceptualization of the purity and the pollution, and this purity and pollution itself is basically are become the reason for to whom to be included in your group and whom should not be included into your group. It means that we are so bound by our caste system or the caste values that the other varnas or the other caste it becomes impure for you. And that is what they say that this particular hierarchy, especially in the caste system, has created more exploitations of the Dalits in the country, or the backward sections of this in the country, or for that matter, especially the Dalit women's in the country. And this particular the hierarchy is basically based on, as I said, that more low and the high status. It is more based on the ritualistic status. It is more on the basis of the individual power in the society. So it means that hierarchy is another factor which is one needs to understand how this creates the caste-based discrimination in the society. And despite of the numerous efforts from the government and various social reformer and social movement and various other groups who fights against the caste-based discrimination, you still find one or other day in the newspaper there is a news related remove caste-based discrimination, practice of untouchability. And then for your information, Madhya Pradesh is again the state which comes in the five major states among 5 major states where the practice of caste discrimination and practice of untouchability is more prevalent, as well as the atrocities are more prevalent in the rural areas of Madhya Pradesh. So it means that it is again the role of social worker. It is more important to understand this hierarchy and hierarchy based kind of exploitation in the society, and how this hierarchy create the caste-based discrimination within the society. And that is one needs to understand again from the human rights perspective, that how your ritually so-called high status and ritually so-called low status creates the exploitation, and this exploitation are affecting the one particular community, that is Dalits, and then again the tribals, and violating their civil rights, cultural rights, political rights, socio-economic rights, and make them more deprived in the society. The fourth aspect of the factors of the Indian society, and that is the externalization. And this externalization one needs to understand from the point of view that the externalization, again, it has been more the process where the one particular religious group is considered as the outsider. They are not part and parcel of the Indic religion. They are not part and parcel of the Indian values which has been originated. And this is what it said, the externalization create the collective alienation of the group. And particularly you will find this collective alienation. It means that keeping that group aside, and somebody shared here that how there is the churches face the problems in the recent past, or how the issues related to minority comes because of the collective alienation of that group. It is considered keeping that particular group aside, or considering that particular group is the outsider. And this is what one has to understand. Particularly if I talk about the externalization process, you will find in Indian context, there is the communities, Muslims and the Christian are considered the subject of this externalization in more intense way. And this because there is a cognitive kind of thinking, or the cognitive way of understanding the community, that they are the outsider. They are not part of their religion, is not somewhere. It is more ingrained in the Indian soil or Indian tradition. So it means it has been said that the Muslims are the conquest of the Mughal. The Christians are the product of the colonization. And this is what the thinking. It is basically keep the community away from the various other kind of aspect. Although understanding, although the facts and figure is that the Christians' education has been far better than the many other minorities in the country. But then you will find that on and off there is the news around, there is the issues related to Muslims, issues related to Christians in the country, and it is because of the collective alienation which has been created in the society, and that it's the one of the reason one can understand that the more minority status, you will find that the chances of there is a discrimination which exists in the society. Similarly, there is a minority status also has its own vulnerability, because largely your recognition in the Indian identity or Indianized identity becomes very less, and your identity becomes more misrepresentation in the society. And that's the reason why you will find that various reports related to the minority, which we say that the social development indicators as well as issues related to safety, security of the community is not good, and hence there is a lot of human rights violation or human rights violation related news takes place about the community. So these 4 aspects which I had discussed about, that one is the stratification create the disparity in the Indian society, your hierarchy create the exploitation in the society, your heterogeneity create the discrimination, and externalization create the collective alienation of the society. It basically gives us the understanding that the Indian socio-cultural reality is very different. And this all stratification, heterogeneity, hierarchy, and externalization is basically responsible for the human rights violation. And that's the reason why the right-based approach is more relevant for the social work student to understand Indian socio-cultural situation. It is basically also tells us about that our problems are basically more related to socio-cultural discrimination, more related to socio-cultural exploitation, more related to alienation of the group in the larger mainstream society, and we need to evolve our strategy also in the context of it. But by saying all those things, now we need to understand that how this entire background of the Protection of Human Rights Act 1993, which has come into the existence, and my later part of this discussion would be more on this particular aspect, that our entire conceptualization of human rights is altogether in the context of the normative framework. It is based on the value framework. It is also based on the one can understand what are the inherent rights of the individual. And then in the context of the Protection of Human Rights 1993 Act is basically has developed in the context of some other human rights violation, and which is more because of the kind of police and the other paramilitary force which are involved into the human rights violation of the some or other community in the different states of the India, and that is what the larger emergence is that. So Protection of Human Rights Act 1993, basically it has been again amended in 2006 as well as 2019. And here I'll be discussing about why this Protection of Human Rights Act and what is its emergence. So for your information, the Protection of Human Rights Act enforced on 28 January 1993, and it has been enacted in 8 January 1994 all over the India. When I see that what are the why this Human Rights Act and why this particular act came into the existence, despite the fact that we were having so many other provisions, which is more community specific provisions for the dowry prohibition, widow remarriage, and SC/ST Prevention of Atrocities Act, and Anti-Untouchability Civil Rights Protection Act. So many other acts are there, but then we were not having this particular Protection Human Rights Act, and this particular act basically came into 1993. That is because again the certain Western countries, and especially in America in particular, that is what the literature talks about, that we criticize on the violation of human rights by the Indian armed forces as well as the paramilitary forces, especially in the state of Jammu Kashmir, where that this particular armed forces and paramilitary forces are in a way violating the human rights of the local people, and that is what the Western countries were talking about. And it is in this particular context, basically the need has been arose to have this particular Human Rights Protection Act, where all the political unrest as well as the violence in Punjab and the Jammu and Kashmir, Northeast, and the other states need to be monitored. And that is how the origin of Human Rights Protection, which Human Rights Protection Act came into the existence. If you look at the details of the Human Rights Protection Act, you will find the Act contains 8 chapters and 43 sections. Chapter number 1, which is particularly talks about preliminary aspect, that is definition, contains 2 sections. Chapter 2, that is on the National Human Rights Commission, it has the 9 sections, and this particular section which largely discuss about the composition and other aspect of the commission. I'm not going to go into detail about it. Chapter 3 talks about the functions and powers of the commission, and it contains the 5 sections. Chapter 4, it is about the procedure of the Human Rights Act, and it contains 4 sections. Chapter 5 talks about the State Human Rights Commission, which contains the 9 sections. Chapter 6, which is on the human rights courts, which contains 2 sections. Chapter 7 is on finance and then accounts and the audit, which contains 4 sections. And the last chapter, that is the chapter number 8, miscellaneous, which contains the 8 sections. So altogether, you will find that under the Protection of Human Rights Act, there are the 8 chapters and 43 different sections are there, and these different sections are regulating the human rights protection in the country by National Human Rights Commission as well as State Human Rights Commission, and different kind of composition of this particular National Human Rights Commission. So more particularly, if I can talk about the chapter number 2, that is which under this chapter, the National Human Rights Commission has been defined under the section 2 subclause C and established under section 3 of the Act. The commission, basically National Human Rights Commission, shall be constituted of the members as laid under the provision of section 3 subclause 2, which lay that there shall be a chairperson and who shall be retired Chief Justice of India. Along with the chairperson, there are 2 members who have been judged in the Supreme Court, and other members shall be the Chief Justice of High Court. Apart from this, there shall be 2 other members who have worked in the field of human rights. So this is the composition of the National Human Rights Commission. Apart from that, the commission, there shall be National Commission for the Minorities and the National Commission for the Women, where there would be representation from this particular commission. Members of the commission shall be appointed by the president, and after obtaining the recommendation from the Prime Minister for the appointment of the chairperson, and the members shall be appointed in consultation with the Speaker of the House of the People, Ministry in charge of the Ministry of the Home Affairs, Leader of the Opposition in the House of the People, Leader of the Opposition in the Council of the State, and the Deputy Chairman of the Council of the State. So chairperson holds the office till the period of 5 years or till obtaining the 70 years of the age, whichever is the earlier, and the member shall be hold to office for the 5 years and shall be eligible for the reappointment. So this particular act also regulates the condition of the services, salaries, allowances of the appointment of the additional staff members of the National Council for Human Rights. At present, if you can look at it, there is hello.
Yes, sir. Yes, sir, you are audible. Yes, sir, you are audible.
Okay, fine. At present, if you can see, chairperson of the National Human Rights Commission is Justice Arun Kumar Mishra, and he is the 8th chairperson of the National Human Rights Commission. So when I talk about this particular chapter number 3, the chapter 3 of the Act deals with the powers and functions of the Commission, dealt in section 12 to 16. Where the commission is granted powers to suo motu. It means that action taken by the court by its own, look into the matter concerning the violation of the human rights. The commission shall also take action in the case where the victims has filed an application for the violation of the human rights. The commission shall be deemed to be a civil court for all the purposes of the section 195 and chapter 26 of the Code of Criminal Procedure of 1973. So it means that the commission is bestowed with the investigation power. So it means that if any case goes to the National Human Rights Commission, it is bestowed with the investigation powers while taking up the help from the government officers under the section 14. Chapter 4 is basically deals with the procedure after the complaint has come into the notice of the commission, and that is commission shall after the receiving the notice of violation of human rights shall inquire into the matter. So it means that if any kind of complaint goes to the commission by anybody, any public spirited person, the court, the Human Rights Commission will initiate the action against the or initiate the inquiry regarding that particular matter. So National Human Rights Commission, if you per se look at the National Human Rights Commission and its main functions, it is like section 3 of the Act provides that the central government shall constitute a body known as National Human Rights Commission to exercise the powers conferred upon the assigned to it under the Protection of the Human Rights Act. The National Human Rights Commission in India is the autonomous public body constituted on the 12th October 1993 under the Protection of the Human Rights Act. It was given a statutory basis by the Protection of the Human Rights Act. The NHRC, that is National Human Rights Commission, is the national human rights institution responsible for the protection and promotion of the human rights defined by the Act as the rights relating to life, liberty, equality, and dignity of the individual guaranteed by the Constitution of the India. Okay, there are certain tasks performed by the there are certain functions of the National Human Rights Commission that I'll be discussing here. Basically, it inquire on its own initiative on the petition presented by it by a victim or any person on his behalf into the complaint of. So it means that any public spirited person, any individual can initiate a complaint regarding the victims or any persons on behalf in order to know the action against the human rights violation. So first functions of the National Human Rights Commission is inquire on its own initiative or on a petition. It means that either commission after observing the situation or on a petition presented by it by any victim of the human rights violation or any person on his behalf into the complaint of it. So it means that the violation of human rights or any kind of abatement, that is abatement means indirectly participating in the offense or the crime, not directly but indirectly participating in the offenses. It has been the commission take action against it. Second, the negligence in the prevention of such violence by the any kind of public servant, where the commission has its own function to intervene. Then intervene in the any proceeding involving any allegations of violation of human rights pending before the court with approval of such court. So many of the time the human rights violation cases are pending in the different court, and if it is not, the results are not coming out. So in that case, the Human Rights Commission take its own intervention. Visit under the intimation to the state government, any jail or any other institutions under the control of the state government where persons are detained or lodged for the purpose of treatment, reformation or protection, to study the living condition of the inmates and make recommendations. So it is again more related that if suppose any jail where the situation of the prisoners are not good, or probably the proper services are not given, or for that matter there is a illegal detention is there. So it is in that case also the Human Rights Commission can take the action, suo motu action. Then the review the safeguards by or under the Constitution or any law for the time being enforced for the protection of human rights and recommend measures for the effective implementation. So after understanding the any particular area or the institutions and then social situation where human rights commission, National Human Rights Commission can review the situation and suggest the safeguards to the government. It has also been said that the functions of the Human Rights Commission also to review the factors including the act of terrorism that inhibit the enjoyment of the human rights and recommend appropriate remedial measures in that particular territory. It is also the functions of the Human Rights Commission is also to study treaties and other international instruments on the human rights and make a recommendation for the effective implementation, and especially it is in the context of the refugees and the refugees situation in the country. It also undertake and promote the research in the field of human rights, and this is what again the probably the newer training program is also the one particular outcome of this particular initiative from the National Human Rights Commission, because the National Human Rights Commission also promote research training in the field of human rights in the various universities set up and the various educational institutions in order to promote the human rights education. At the same time, National Human Rights Commission spread human rights literacy among various sections of the society and promote awareness of the safeguards available for the protection of these rights through the publications, the media, the seminars, and other available means. So it means that the Human Rights Commission not only take the suo motu action against the human rights violation, but then it also promote the culture of awareness about the human rights violation, and at the same time they also do the documentation related to different kind of issues of the human rights violation, and in this way it generates the information, it generates the awareness among the people about the human rights violation. National Human Rights Commission also encourages the efforts of the non-governmental organization and institution working in the field of human rights by giving the projects for the implementation of for the protection of the human rights. So it means that the National Human Rights Commission has this approach towards the collaborating with the non-governmental organization and civil society organization for promotion of the human rights in the society. Similarly, other such function it may consider necessary for the promotion of human rights. It means that it is at the various ministry level also the Human Rights Commission try to align and try to make it that human rights violation should not take place in the society. So it means that the National Human Rights Commission has its own power to function in the society, and it takes its more initiatives in order to prevent the human rights violation or intervene into the human rights violation in the society. At the same time, it is more involved into the promotion of human rights in the society. Now, when you look at the NHRC members and its powers, I already talked about at present. Justice Arun Kumar Mishra is the chairperson of the National Human Rights Commission. Along with him, there is one member who's been the judge of the Supreme Court. There is another member who has been the Chief Justice of High Court, and two members to be appointed among the persons having knowledge and practical experience in the human rights issue. That may again either the NGO personnel as well as the people those who work in the areas of human rights violation. In addition, there is a chairpersons from the 4 national commissions, also the part of the NHRC composition. That is one chairperson from the National Commission for the Minorities, another from the National Commission for the Scheduled Caste, another third member is from the National Commission for Scheduled Tribes, and the 4th member from the National Commission for the Women. So as serve as the ex officio member. So altogether, you will find that the composition comes around 8 to 9 members of the National Human Rights Commission, which operate the National Human Rights Commission and its day-to-day affairs in the commission. So when I look at this particular aspect and particularly powers of the National Human Rights Commission is basically powers of the civil code while trying to understand the entire human rights violation. So it means that the National Human Rights Commission has this particular independent power if they can intervene into some of the issues related to human rights violation, irrespective of the other socio-cultural issues in the society. It has also been said that there is various aspect related to inquiry has been conducted under the National Human Rights Commission. So while inquiring into the complaint under the Act, the Commission shall have all powers of the civil code trying to suit under the Code of Civil Procedure of 1908, and in particular the following, namely like summoning and enforcing the attendance of witness and examining them on oath. Second, the discovery and production of any documents for the inquiry purpose, receiving evidence on affidavits, requisitioning any public record or copy thereof from any court or the office, issuing commission for the examination of the witness or the document. So this is also the basically the role of the commission, that it has more power as the civil court for the protection of the human rights. Now, when it comes to the type of complaint dealt by the National Human Rights Commission, you will find that there is a vast different types of complaints has been dealt by the National Human Rights Commission. So in respect of the police administration, like failure in taking any kind of action where they're supposed to take action in the public during the public issues, or for that matter, unlawful detention of any individual, or the false implications on individual, illegal arrest or custodial violation, and or for that matter, the violence against the people, those who are in the custody. So this is the in respect of the police administration, where the largely complaint dealt by the National Human Rights Commission. There are also issues which has been again highlighted by the National Human Rights Commission, or which comes under the purview of the National Human Rights Commission, that is custodial death or encounter deaths, atrocities on the scheduled caste and scheduled tribe. Again, the issues of the child labor, monitoring of the child labor in the society, dowry demand, abductions, rape and the murder, sexual harassment and indignity to women or exploitation of the women. So these are also the cases which has been dealt by the National Human Rights Commission. The another aspect which is very important in this act, and that is nature of complaint and the language. And from the social work point of view, it is also important to understand the complaint may be in English or in Hindi or any other language from the 8th schedule of the Constitution. So it means that anybody can directly make a complaint in the Human Rights Commission. Complaints are to be self-contained. Second, no fee is for submitting the complaint, and complaint may be made by any means, by letter or telegram or fax, or also on the mobile number of the commission regarding the human rights violation. So when it comes to understand what are the achievements of the Human Rights Commission so far, and there are major achievements. It's been said in the context of it is because of the Protection of Human Rights Act and National Human Rights Commission, the independent stand on the issues of the caste-based discrimination at the World Conference Against the Racism, Racial Discrimination, Xenophobia and Related Intolerance held at Durban in 2001. So the Commission has taken the independent stand on it, and especially the kind of caste-based discrimination which is there in the country, which has been taken into consideration by the National Human Rights Commission. At the same time, various economic, socio-cultural rights violation in the country is regularly intervened by the National Human Rights Commission. Right to life, right to health care. Then again, it is related to establishment of the central monitoring mechanism to emergency services, preventing the repeal of the Infant Milk and Substitute Act of 2003. Moreover, in the cases of the HIV/AIDS, HIV/AIDS recommended to the inbuilt mechanism for the consent and the testing and the non-discrimination in the healthcare and the employment regarding the HIV/AIDS patients. Public hearings for access to healthcare facilities, recommended to formulate plan to action to tackle the various issues, and especially issues related to right to health and the drinking water. Similarly, various civil and political rights where the National Human Rights Commission has intervened into, that is systematic reform in the police. Police reform is considered to be a major issue by the National Human Rights Commission because it is said that the police is always remain for practicing or maintaining the law and order in the society, and in that context, that systematic reform of the police should be taken so that the violation of human rights doesn't take place. So establishment of the human rights cell in the police in police headquarters, and at the same time, many of the time you will find that there is also this human rights cells are there in the police cells, where directly the intervention can be made by the social worker and the public spirited person. Improvement in the infrastructure in the forensic lab, visit to the prisons, mental hospitals and government run homes. If there is a situation of these prisons, mental hospitals and the or the care homes are not good, where a commission can intervene. And monitor non-discrimination in rehabilitation, relief, reconstruction to victims of the violence and the displacement. So again, this also been the area where the National Human Rights Commission has made an achievement in terms of they can intervene that in term where there is an disaster, or if there is any kind of issues related to relief distribution, where commission can intervene. And so other like monitoring the prison condition, custodial deaths, hospital for mentally ill patients, status of bonded and the child labor, homes run by the government, rights of the internet displaced persons, and then also the situation of the workplace, where the basically sexual harassment issues takes place, encounter death or the deaths of the deaths of the children in the protection home. So these are the areas where the National Human Rights Commission has made its intervention, and at least because of their intervention, there are various improvement has happened in those institutions, and that is itself that the major achievements of the National Human Rights Commission. Last one, what I feel, and that is from the social work point of view, that there are the vast number of human rights issues in the country, and then institutions like National Human Rights Commission or the Protection of the Human Rights Act is basically the legal system we have, or legal instrument we have, through which we can intervene in the area or arena of the human rights protection. And when I look at it from the point of view of the kind of institution setup and its intervention in the various areas of the human rights violation, I find that this institution help us to help our intervention more stronger, because it has more legal system with us. And it is in that context, I will say, that the National Human Rights Commission and then Protection of Human Rights Act 1993 is basically, it provides the most strength to the intervention to the either social workers as well as the civil society organization. So with this, I'll stop here. If you have any question, please go ahead.
So, students, if you have any questions, you can ask, sir.
Okay. Sir, first, I really enjoyed your session, how you started it and how you questioned it on the wider things, on the wider concepts. I really found that invigorating, like really energizing. Now, I had a question, and it might appear that I'm digressing a bit, but give me a minute to explain. So, in the initial talk, you talked about mechanism and structure and segregation, right?
Yeah.
So that was the mechanism part, right? But I've been thinking about this from some time now, that this divisive, that this need to divide, right? What's the psyche behind it? Because it's not confined to just India, right? If you see, world over, we have endless examples where people have tried to divide. And I know I'm making it oversimplistic, but sometimes you need to oversimplify things to understand them. So I have been thinking about the psyche behind this, the need to divide. Have you thought about it? Have you given it a thought?
See, basically, when I talk about the kind of cultural alienation, or if I can talk in the context of the collective alienation about one or other community, or for that matter, there is the kind of exploitation against the one or other community because we are hierarchical, hierarchy in that way as a caste system. This is what largely I feel in the context of not a larger society is responsible. Rather, I feel that we in the family setup, how we behave with our female folk, okay, what kind of values imbibed on the individual, young child or young person in the family, how socialization take place, that needs to be corrected, that needs to be somewhere improvised in order to we have respect for the other, or respect or having the respecting the dignity of the other. So unless and until this particular mechanism of socialization makes more stronger at the family level or in the home setup, probably we may not able to counter the kind of discrimination what happens outside the family or outside the community. Reason being, individual who is the part of the society as a social being, he first get all socialization learning from the home. So home environment is more based on the equitable terms. It is more based on the respecting the others, respecting the multicultural society, the respecting the diversity of the society. And unless and until it is taught in the family as well as in the school, probably I won't find that there is any other solution for it. This is one. Second, also I feel that there is still more for education to do a kind of effective work in order to change the mindset of the people. But then again, the education you will find and the situation of the education in the country, it is basically again the one particular kind of privileged sections could able to access the education probably above secondary level of schooling. Rest other probably people get dropped out. So I feel that education has its maximum role to play to change the mindset of the people, as well as also make them more civilized in the society. Unfortunately, these two things, the family socialization, I always feel are responsible, also indirectly or directly to create this particular human rights violation in the society against gender or against any other socio-cultural group. And at the same time, there is the lack of education, or probably if I can say that the educational backwardness, or if the education doesn't reach to the maximum number of people, that is also the another reason you will still find this particular kind of disparity, or for that matter discrimination which exists in the society, and that itself creates the further exclusion of the other and the human rights violation.
Yeah, great.
I hope I responded to your question.
Yeah, you did. Thank you so much.
Thank you, sir. Students, are there any more questions for sir? You can unmute yourself and speak. In that case, Alan, over to you.
Thank you, ma'am. Thank you, sir, for your valuable session on protection of human rights acts, their provisions and achievements under these acts, composition of functions of NHRC and SHRCs, objectives, functions, relevance, and achievements of NHRCs and SHRCs, and other national and state commissions. Thank you, sir, for your valuable time and expertise.
Okay. Thank you very much. Thank you, Dr. Shiba, and thank you to all the participants and the students.
Thank you very much, sir. It was indeed very insightful. Thank you very much.
Now we'll have a short break of 15 minutes. All of the students are requested to join back using the same link by 1:30. Thank you.
Did you inform the participants?
Yes.
I haven't registered.
Prashant sir, good afternoon.
What is happening? Oh.
गुड आफ्टरनून मैम, कैसी हैं?
सर ठीक है। अभी 1:30 को हम सेशन रिज्यूम करेंगे। हमने ब्रेक किया था बिकॉज लाइक 9:45 से चल रहा था लेक्चर।
जी जी जी, कैसा रहा मैम?
अच्छा गया सर। एक सेशन तो फर्स्ट सेशन वाज पैक्ड विद इंफॉर्मेशन because that was taken by a professor. Second also was taken by a professor. First वाला फिर हमें doubts पूछने के लिए टाइम नहीं मिला था इतना. Then we took up only one question. Then she gave the email ID so we can write back to her. Second session उन्होंने PPT use नहीं किया. It was more on an trying to make it interactive. Estamp type का.
जी जी जी.
So we are looking forward to your session with a lot of examples and case studies from your experience.
कोशिश करूंगा मैम, बिल्कुल वैसे ही रखने की.
Thank you.
तो मैम अभी कितना 1:24 अपन 1:30 बजे शुरू करेंगे?
हाँ 1:30 बजे हमने स्टूडेंट्स को yes,
मैं इस पे हूँ मैम, जैसे ही चालू करेंगे आप बता दीजिए, मैं जुड़ा हुआ हूँ जी.
Okay, thank you.
थैंक यू.
Exactly. Prashant sir, can we start? It is 1:30.
Yes, ma'am, I'm ready.
Yes, sir. Thank you.
A very good afternoon to all the esteemed guests present here today for this insightful session on human rights. This is Lama Abbas from MSW first semester batch, and I'm delighted to introduce the speaker for this session, Mr. Prashant Dubey, Director and founding member of Awaaz, an organization working for child and youth development. He has been working tirelessly in the field of social development for almost 18 years. With a strong understanding of issues such as human trafficking, child sexual abuse, child rights, and youth development, he is presently working with 75,000 young enthusiasts to enhance their understanding on child protection and its intervention. He has been awarded with National RTI Award 2009, Young Indian Leader Award 2011, National Reach Award 2016 and 2019, along with 5 national fellowships. We are pleased to have you with us, sir, and eager to listen to your words of wisdom.
Thank you so much. मेरी आवाज आप तक पहुंच रही है?
जी सर।
जी, तो मुझे 2-3 मुद्दों पर बातचीत करनी है। एक तो है UNCRC, यूनाइटेड नेशन कन्वेंशन ऑन द राइट्स ऑफ द चाइल्ड, दूसरा सीडा, और तीसरा बाल श्रम वाले जो मुद्दे हैं, चाइल्ड लेबर के जो इश्यूज हैं, उन पर बातचीत करनी है। तो मैंने जैसे मैडम से कहा था कि मैं हिंदी में बात कर सकता हूँ, तो मैं अपनी बात हिंदी में रखूंगा और एक प्रेजेंटेशन के थ्रू अपनी बात रखूंगा, और फिर हम लोग कोशिश करेंगे कि हमारी जो प्रेजेंटेशन के बाद एक 10-15 मिनट का समय बच सके, ताकि आप लोगों के जो सवाल जवाब है उसको हम लोग ले सकें। साथ ही मैं ये भी कोशिश करूंगा कि जैसे डॉक्टर कविता ने किया कि ईमेल आईडी या फोन नंबर वगैरह छोड़ दें, ताकि आप लोगों साथियों के जो सवाल होंगे उनको हम बाद में भी एड्रेस कर सकते हैं। लेकिन मुझे लग रहा है बहुत हेक्टिक डे है आज का आप सबके लिए, क्योंकि सुबह से हम सब राइट्स की बात कर रहे हैं। मैं कुछ सेशंस को थोड़ा समय के लिए अटेंड किया था और मैं देख रहा था कि बहुत एक प्रकार से बहुत भारी भरकम विषय है, और स्वभावतः है भारी भरकम विषय है, लेकिन मैं कोशिश करूंगा कि मैं कुछ जमीनी अनुभवों के साथ इस भारी भरकम विषय को थोड़ा सरल भाषा में रखने की कोशिश करूं, ताकि आप सब इससे जुड़ भी सके और हम लोग इन विषयों पर थोड़ी और समझ अपनी पुख्ता कर सके। तो मैं यहाँ से अपनी बात शुरू करता हूँ, और सबसे पहले हम सीडॉक के साथ ही शुरू करते हैं, और फिर उसके बाद हम लोग बीच बीच में कोशिश करेंगे कि इसके बाद सीडॉक के बाद जो दूसरा वो होगा वो UNCRC पे बातचीत करेंगे, और फिर उसके बाद तीसरे हिस्से में हम लोग चाइल्ड लेबर के मुद्दे पर बातचीत करेंगे। मैं एक एक विषय को यहाँ पर लेने की कोशिश करता हूँ। सॉरी, कुछ प्रॉब्लम हो रहा है। क्या आप स्क्रीन देख पा रहे हैं?
Yes, sir.
Yes.
ग्रेट। तो नाम है सीडा, और फुल फॉर्म भी आपके सामने दिख रहा है, द कन्वेंशन ऑन द एलिमिनेशन ऑफ ऑल फॉर्म्स ऑफ डिस्क्रिमिनेशन अगेंस्ट वीमेन। अब ये तो इसका एक नाम है, और नाम से भी हमें इसका काम बहुत हद तक स्पष्ट समझ में आता है कि सीडा की जरूरत क्यों पड़ी। लेकिन जरा हम कुछ आंकड़ेबारी में देखें तो हम बहुत चौंकते हैं, या हमको लगता है कि इस तरह के कन्वेंशंस की जरूरत क्यों पड़ रही थी देश और दुनिया के स्तर पर। और जब हम कुछ आंकड़े में अभी आपके सामने रखने की कोशिश करूंगा, जिससे हम थोड़ा रिलेट कर सकेंगे कि सीडा जैसे कन्वेंशन की जरूरत क्यों पड़ी। कन्वेंशन मेरे ख्याल से आप सब मित्र समझते ही हैं, ह्यूमन राइट डिक्लेरेशन और इन सब की बातचीत हमने की ही है। कन्वेंशन अलग अलग समय पर अलग अलग विषयों को लाकर किए जाने वाले अंतर्राष्ट्रीय स्तर पर संधियां हैं, जिसमें हर एक देश, कई बार यूएन की तरफ से जो संधियां सामने आती हैं उसमें हर एक देश जो यूएन का पार्टनर है वो उसको अडॉप्ट करता है, उसको रेटिफाई करता है, और फिर उसके बाद अपने देश में उससे जुड़ी जो स्थितियां हैं उसको बदलने की कोशिश करते हैं अलग अलग तरीकों से। तो ये मोटा मोटा एक कन्वेंशन है। तो ये जो सीडा है, सीडा को लाने की जरूरत क्यों पड़ी हमारे देश और दुनिया में, क्यों महिलाओं के जो ह्यूमन राइट्स हैं उनको अलग से डिफाइन करने की या उन पर अलग से चिंता जताने की क्यों जरूरत पड़ी? यदि आप पहले ही आंकड़ा देखें जो बड़ा चौंकारा है, वो कहता है कि पूरी दुनिया में यदि हम देख रहे हैं कि जो गरीबी रेखा से नीचे रहने वाले जो लोगों की संख्या है, उसमें यदि हम देख रहे हैं तो 70% वीमेन है, जितनी भी संख्या उसमें। अपने आप में ये आंकड़ा बता रहा है कि हमारे देश, प्रदेश या दुनिया के स्तर पर क्यों इस तरह के संधियों की जरूरत पड़ी जब हम महिलाओं के राइट्स के संदर्भ में ये आंकड़ों को देखते हैं। आप दूसरा आंकड़ा देखेंगे कि जो हमारे आप अलग-अलग डेवलपमेंट प्रोजेक्ट्स देखें, मैं इन सब आंकड़ों को हमारे देश संदर्भ में यानी मध्य प्रदेश के संबंध में और देश के संबंध में भी आपके बीच में रखने की कोशिश करूंगा ताकि हम रिलेट कर सकें कि कहीं बात ऐसी तो नहीं है कि दुनिया की बात हो रही हो, बल्कि क्या हमारे आसपास भी ऐसी स्थितियां हैं क्या? जैसे आप सेकंड डेटा देख रहे हैं, बिटवीन 75 to 80% ऑफ द वर्ल्ड्स 27 मिलियन रिफ्यूजीज आर वीमेन एंड चिल्ड्रन। जो अलग-अलग देशों से निकलकर दूसरे देशों में शरण लेने वाले रिफ्यूजीज जो हैं, वो शरणार्थी जो लोग हैं, उसमें से 75 to 80% महिलाएं और बच्चे हैं। अब यदि हम भारत के अंदर के परिस्थितियों में देखें, जिसमें रिफ्यूजीज का परसेंट बहुत कम है, लेकिन हम डिस्प्लेसमेंट के साथ यदि इसको रिलेट करके देखें, आप सब जानते हैं हमारे यहाँ पर शहरी क्षेत्र में भी डिस्प्लेसमेंट है, हमारे यहाँ ग्रामीण क्षेत्र में भी अलग-अलग डेवलपमेंट प्रोजेक्ट्स के चलते भी डिस्प्लेसमेंट है। जैसे यदि आप मध्य प्रदेश के संदर्भ में देखें तो बहुत सारे डैम्स बने हुए हैं, डैम्स के चलते बहुत डिस्प्लेसमेंट हुआ है। बहुत सारे डेवलपमेंट प्रोजेक्ट्स आए हैं, सेंचुरीज आई हैं, टाइगर रिजर्व्स आए हैं, उसके चलते भी बहुत बड़े पैमाने पर डिस्प्लेसमेंट हुआ है। बहुत बार शहरों को अत्याधुनिक बनाने के नाम पर भी बहुत बड़े पैमाने पर डिस्प्लेसमेंट हुआ। जिस भोपाल में बैठकर मैं और आप ये बात कर रहे हैं, उस भोपाल में भी डिस्प्लेसमेंट के बहुत बड़े पैमाने पे प्रमाण हैं। ऐसा भी नहीं है कि डेवलपमेंट प्रोजेक्ट्स मतलब लाना जरूरी है तो डिस्प्लेसमेंट होगा, लेकिन उस डिस्प्लेसमेंट को कैसे देखा जाए कि कैसे हम उनकी आशंकाओं को कम कर सकें या उनकी जो वंचितता बढ़ती है ऐसे लोगों की, उसको कैसे कम किया जा सके, वो एक अलग विषय है। लेकिन फिलहाल हमारे यहाँ पर भी जो डेवलपमेंट प्रोजेक्ट्स आए हैं, उसके चलते जो लोग डिस्प्लेस्ड हुए हैं, उसमें वीमेन एंड चिल्ड्रन की संख्या बहुत बड़े पैमाने पर है और बहुत ज्यादा है। यदि आप मध्य प्रदेश के पूर्वी वाले हिस्से में देखेंगे तो बरगी बांध वहां पर एक है। बरगी बांध के जो डिस्प्लेस्ड लोग रहे हैं वो दूसरी जगहों पर जाकर जो बड़े बड़े किसान रहे हैं, जिसमें महिला किसान भी शामिल हैं, बच्चे भी, बच्चे किसान नहीं है, बच्चे परिवारों के हैं, वो सब अलग अलग जगह तितर बितर हुए हैं। परिवार टूटा है, कल्चरल एक्सप्रेशंस टूटे हैं, बहुत सारी चीजें टूटी हैं। तो एक बड़ा आंकड़ा तो ये है पूरी दुनिया के स्तर पर। लेकिन अब जो तीसरा आंकड़ा आ रहा है वो बहुत महत्वपूर्ण है कि जहां पर नीति निर्धारण होता है, जहां से चीजें तय की जाती हैं, यानी जहां पर डिसीजन मेकर्स बैठते हैं, वहां पर जिस समय का ये आंकड़ा है वो कह रहे हैं कि 28 वीमेन ऐसी रही हैं जो स्टेट या गवर्नमेंट स्तर पर जहां नीति निर्धारण होते हैं वहां पर इस सेंचुरी में आई हैं, जो अपने आप। सर जी सर,
सॉरी टू इंटरप्ट सर, ये स्लाइड मूव कर रहे हैं क्या आप? आपने स्लाइड चेंज किया?
कर रहा हूं मैं मैडम। वन बाई आ रहा है, नहीं आ रहा है क्या आपके पास?
नहीं, वो इनिशियल स्लाइड ही दिख रहा है, फर्स्ट स्लाइड जहां
अच्छा,
जिसमें किरदार लिखा है।
एक मिनट में मैं अभी चेंज करता हूँ।
ओके, हाँ, अभी सही है। सेकंड स्लाइड है सर।
अभी दिख रहा है क्या मैम?
हाँ जी, दिख रहा है सर। तो
ठीक
फुल स्क्रीन में कर सकते हो सर? फुल स्क्रीन
किया मैम?
अच्छा, ओके। लेकिन
अभी दिख रहा है क्या मैम?
हाँ, अभी दिख रहा है सर। वो नीचे एक वो ट्रॉफी वाला सिंबल है ना, वहां पे अगर लगा दोगे तो फुल स्क्रीन में आ जाएगा।
हाँ मैम, वो मैंने किया।
अच्छा,
मुझे तो फुल स्क्रीन दिख रहा है, दिस वन।
ओके, हाँ, फिर ठीक है सर, ठीक है। थैंक यू।
अभी दिख रहा है क्या मैम? कुछ डेटा दिख रहा है क्या?
हाँ, स्क्रीन दिख रहा है, लेकिन वो फॉन्ट साइज थोड़ा छोटा है ना, तो इसलिए मैंने रिक्वेस्ट किया था।
ओके मैम,
हाँ, यस सर। अभी हाँ, इट्स विजिबल।
ग्रेट, तो मैं ऐसे ही करता हूँ। सो सॉरी, मैं हाँ, हम थे जहां नीति निर्धारण कर रहे हैं लोग, मैंने जहां पर ऐसी जगहों पर मतलब हैं जहां से पॉलिसी को इन्फ्लुएंस कर सकते हैं, उस पर यदि हम देखते हैं तो हमारे यहाँ पर पूरी सेंचुरी में 28 यदि ऐसे रहे हैं महिलाएं जिन्होंने जो प्रभावित कर सकती थी चीजों को। अब यदि हम भारत के संदर्भ में देखें या हमारे लोकल संदर्भ में देखें, भारत और मध्य प्रदेश के संदर्भ में, तो आप देखेंगे कि अभी हमारे यहाँ पर महिलाओं का प्रतिनिधित्व पंचायत लेवल पर तो हो चुका है। त्रिस्तरीय पंचायती राज में जिला स्तर की पंचायत, ग्रामीण स्तर की पंचायत या ब्लॉक लेवल की जो पंचायत, वहां पर तो बहुत बड़े पैमाने पर महिला साथी चुनकर आ रही हैं। लेकिन अभी भी हमारे यहाँ पर एक रिजर्वेशन बिल है जो अटका हुआ है, जिसमें महिलाओं की 33% के आसपास की जो उपस्थिति है वो संसद और विधानसभाओं में होने का संदर्भ में। तो ये ऐसा नहीं है कि ये पूरी दुनिया के संदर्भ की हकीकत की हम बात कर रहे हैं, ये मध्य प्रदेश और देश में भी उतनी ही लागू है। और हम जब लिटरेसी की बात कर रहे हैं तो उसमें भी आप देखेंगे कि बड़े पैमाने पर महिला साथी ऐसी हैं कि जो लिटरेट नहीं है, इलिटरेट है। और बहुत पूरी दुनिया में यदि 130 मिलियन बच्चे ऐसे हैं जो स्कूल नहीं जा रहे हैं, उनमें से 2/3 ऐसी हैं जो लड़कियां हैं। वैसे यदि हम देख रहे हैं कि जो घरों में हमारे यहाँ कामकाज हो रहा है या हमारे आसपास जो महिला साथी कामकाज करते हैं और पुरुष साथी काम करते हैं, उसके बनिस्बत उनको पैसा कम मिलता है। हालांकि शासकीय प्रोग्रामों में तो अभी देखने को मिल रहा है, शासकीय कार्यक्रमों में कि समान वेजेस दोनों को मिलते हैं, लेकिन अधिकांश जगह पर जब खेतीहर मजदूरों की बात करते हैं या फिर घरों में काम करने वाली बहनजियां हैं, उनके संदर्भ में हम बात कर रहे हैं, तो ये पुरुषों के मुकाबले अभी भी वेतन बहुत विसंगतियां हैं। और एक और जो लास्ट वाला जो डेटा है वो बहुत चौंकाता है। वो ये भी कर रहा है कि पूरे जो महिलाएं घरों में कामकाज कर रही हैं, हम अपने घरों में जाके इसको देखें, इस डेटा को कहीं और देखने की जरूरत नहीं है। हम अपने घरों में यदि देख रहे हैं तो हमारी माताएं बहनें जो घरों में कामकाज करती हैं, सुबह से लेकर रात तक का कामकाज, वो अनपेड वर्क की तरह पर ये है और उसका कोई मूल नहीं है। हालांकि उसका मोल किस तरीके से लगाया जाए नहीं लगाया जाए, इस पे बहुत बहस चल रही है, लेकिन फिर भी उसका कोई मोल नहीं लगाया जाता। हम ग्रामीण क्षेत्रों में देखें तो महिलाएं सुबह से लेकर रात तक लगातार काम करती हैं, क्योंकि वहाँ पशुधन भी है, मतलब हमारे पास कैटल्स भी हैं, वो भी करना है, खेती का भी काम है, बहुत सारी चीजें एक साथ चलती हैं, लेकिन उसका कहीं पर कोई श्रम का कोई मूल्य नहीं है। तो ये सब जो चीजें हैं वो बताती हैं, वो बात कर रही हैं कि क्यों महिलाओं के अलग से मानवाधिकारों के संदर्भ में बात करने की जरूरत है, क्योंकि अलग अलग स्तर पर अलग अलग तरीके का भेदभाव सामने आता रहा है। चाहे वहां नीति निर्धारण की बात हो, वहां भेदभाव है क्योंकि महिलाओं का वहां प्रतिनिधित्व नहीं है। जहां पर गरीबी रेखा से नीचे जूझने वाले जो लोग हैं, अधिकांश महिलाएं उसमें से हैं। जो रिफ्यूजीज या डिस्प्लेसमेंट के शिकार जो लोग हैं, उसमें से महिलाएं और बच्चे ज्यादा हैं। तो तमाम जगहों पर हम देख रहे हैं कि महिलाओं की स्थिति थोड़ी बद से बदतर है, और इसके चलते अलग से उनके मानवाधिकारों के संदर्भ में एक घोषणा करने की या एक तरह की संधि करने की जरूरत पड़ रही थी, जिसमें ये कह सके कि पूरी दुनिया महिलाओं के अधिकारों पर एक मत है, और वो अपने अपने देशों में जो यूएन के अंतर्गत आने वाले जो देश हैं, वो अपने अपने देशों में जाकर इस स्थिति से निपटने के लिए या इस स्थिति को बेहतर करने के लिए अपने अपने यहाँ पर भूमिकाएं निभाएंगे। तो ये एक संदर्भ बन रहा था कि क्यों सीडा जैसे उसकी जरूरत पड़ रही है। मैं इसको फिर से आगे बढ़ाता हूं ताकि वो आप सब मित्रों को देख सके। तो सीडा का जैसे हम फुल फॉर्म की बात कर रहे थे, तो सीडा आया है कन्वेंशन ऑन द एलिमिनेशन ऑफ ऑल फॉर्म्स ऑफ डिस्क्रिमिनेशन अगेंस्ट वीमेन, और ये इंटरनेशनल ह्यूमन राइट्स ट्रीटी है जो कि एक्सक्लूसिवली डिवोटेड टू जेंडर इक्वेलिटी के संदर्भ में है। और ये कब आई? यूएन जनरल असेंबली ने इसको पास किया 18 दिसंबर 79 को, और फिर 2 सितंबर 1981 से ये प्रभाव में आई। और अभी हम यूएनसीआरसी की बात करेंगे, ये दोनों ऐसी ट्रीटीज हैं जो अधिकांश देशों द्वारा जिसको रेटिफाई किया गया। अभी तक जो जानकारी है उसके हिसाब से 189 स्टेट्स ऐसे हैं या देश ऐसे हैं जिन्होंने सीडा कन्वेंशन को अपने यहाँ पर लागू किया है, सीडा कन्वेंशन को रेटिफाई किया है। और इसमें ये भी है कि ये सीडा एकमात्र ऐसी ट्रीटी है जो सभी तरह के जो ह्यूमन राइट्स है उनको कवर करती है, चाहे वो सोशल ह्यूमन राइट्स की बात करें, इकोनॉमिकली राइट्स की बात करें, कल्चरल राइट्स की बात करें। तो ये एक ऐसी ट्रीटी के रूप में सामने आई जो अलग अलग तरीके के तमाम जो ह्यूमन राइट्स हैं उनको एक साथ करने की बात करती है। इंडिया ने 1993 में इस सीडा जो कन्वेंशन है उसको रेटिफाई किया है। हमने कुछ समय लगाया, हमने देखने समझने की कोशिश की कि हम अपने यहाँ पर कौन कौन सी ऐसी स्थितियां हैं उन स्थितियों को हम इस सीडा के जो कन्वेंशन के जो अलग अलग आर्टिकल्स हैं उनमें से कितने आर्टिकल्स को हम अपने यहाँ देख सकते हैं, कितने आर्टिकल इंडिया के संदर्भ में प्रासंगिक हैं, कितने आर्टिकल्स पर इंडिया अपनी तरफ से पहल कर सकता है, नहीं कर सकता है। ये सब तमाम पहलुओं पर विचार करने के बाद 1993 में इंडिया ने इस कन्वेंशन को रेटिफाई किया। और इस कन्वेंशन में आप आगे में देखेंगे, मैं आगे आपसे बातचीत करूंगा कि इस कन्वेंशन में लगभग 30 आर्टिकल्स हैं। तो इंडिया ने 16 आर्टिकल्स के साथ इस कन्वेंशन को साइन किया है, यानी बाकी आर्टिकल्स जो इंडिया के संदर्भ में प्रासंगिक नहीं थे या इंडिया जिन संदर्भों में अभी पहल नहीं कर सकता था उनको छोड़कर बाकी पर इंडिया ने अपने हस्ताक्षर किए। अब एक तरफ हम जब इस तरह के कन्वेंशन की बात करते हैं तब बहुत सारे विरोधाभास हमारे सामने आते हैं। इसमें से एक विरोधाभास है कल्चरल डाइवर्सिटी का। एक तरफ भारत का जो गौरव है वो कल्चरल डाइवर्सिटी के साथ आता है कि देखिए हमारे यहाँ कितनी तरह की भाषाएं हैं, कितनी तरह की बोलियां हैं, कितनी तरह की जातियां हैं, कितने अलग अलग संप्रदाय हैं, कितने अलग अलग समुदाय हैं। लेकिन जब हम सीडा के साथ उसको देखने की कोशिश करते हैं और सीडा के साथ हम देखने की करते हैं, मान लीजिए हम दहेज प्रथा की बात करें तो दहेज प्रथा को हम कैसे समझेंगे, क्योंकि अलग अलग समुदायों में अलग अलग संदर्भ के साथ दहेज प्रथा सामने आती है। कुछ जगह पर वधू मूल्य चुकाना होता है, कुछ जगह पर लड़कियों को शादी जब की जाती है तब लड़कियों को दहेज दिया जाता है या एक इस तरीके की चीजें दी जाती हैं, और कुछ जगह पर लड़की से शादी करने के लिए लड़कों द्वारा कुछ पे किया जाता है। ये अलग अलग कल्चरल डाइवर्सिटी और देश के अलग अलग जनजातीय हिस्सों में या अलग अलग संप्रदाय और समुदायों में ये अलग अलग स्थितियां हैं। तो एक प्रकार से जब हम देखते हैं इस तरह के कन्वेंशन के साथ अपने भारत की स्थितियों को, तो सीडा कहता है कि हम किसी भी तरह का डिस्क्रिमिनेशन जो महिला साथी के साथ हो रहा है उसके खिलाफ ये बात करता है। लेकिन जब हम अपने कल्चरल डायमेंशन के साथ, कल्चरल डाइवर्सिटीज के साथ इसको देखते हैं तो ये एक चुनौती दिखती है हमारे भारत जैसे देश में कि हम उसको कैसे देखें, कहाँ कहाँ पर देखें और किन किन संदर्भों में देखें। क्योंकि एक तरफ यदि हम देख रहे हैं तो महिला के साथ विवाह करने के लिए पुरुष को वधू मूल्य चुकाना हो रहा है और दूसरी तरफ विवाह करने के लिए महिला साथी को डाउरी जैसी परिस्थितियों का सामना भी करना पड़ रहा है। तो कन्वेंशन तो अपनी बात करता है क्योंकि कन्वेंशन यूनिवर्सल है, वो पूरी दुनिया के संदर्भ में बातचीत करता है। वैसे ही भारत में आते आते जब हम देखते हैं तो इसमें बहुत सारी हमको विसंगतियां तो नहीं कहना चाहिए लेकिन बहुत सारी चुनौतियां हमारे सामने आ जाती हैं क्योंकि जिस तरह की स्थितियों के साथ हम भारत में हैं। इंडिया ने ऐसे ही 16 आर्टिकल्स के साथ इसको रेटिफाई किया है। और अब सीडा जो कैसे डिस्क्राइब किया जा रहा है वो ये सीडा ऐसे डिस्क्राइब किया जा रहा है। शायद स्क्रीन चेंज हुई कि नहीं?
नहीं सर।
मैं करता हूँ
जी सर, अभी चेंज हो रही है।
अब हुई जी। सीडा को डिस्क्राइब किया गया है बिल ऑफ राइट्स फॉर वीमेन, और ये इक्वल एक्सेस और इक्वल अपॉर्चुनिटीज दोनों ही तरह के पॉलिटिकल और पब्लिक लाइफ में इक्वल अपॉर्चुनिटीज की बात भी कर रहा है और इक्वल एक्सेस की बात भी कर रहा है। तो ये एक इसको ऐसे डिस्क्राइब किया जा रहा है बिल ऑफ राइट्स करके। दूसरा ये देख रहे हैं महिला और पुरुष के बीच के जो अलग अलग मुद्दे हैं। कन्वेंशन प्रोवाइड्स द बेसिक फॉर रियलाइजिंग इक्वलिटी, समानता बिटवीन मैन एंड वीमेन, though ensuring women's equal access to and equal opportunities in political and public life। लगभग वो समान चीजें हैं, लेकिन ये इकोनॉमिक, सोशल एंड कल्चरल डायमेंशन जो भेदभाव महिलाओं के खिलाफ होता है उन सबको कवर करने की कोशिश करता है ये कन्वेंशन। और यदि अब हम इसको थोड़ा समझने की कोशिश करेंगे कि इसमें किस किस तरह के अभी आर्टिकल्स हैं, तो यदि आप स्ट्रक्चर देखेंगे सीडा का, तो आर्टिकल 1 to 5 जो इसमें, जैसे मैंने कहा कि 30 आर्टिकल्स इसमें हैं, तो आर्टिकल 1 to 5 है वो नॉन डिस्क्रिमिनेशन और स्टेट ऑब्लिगेशंस के संदर्भ में है, और नॉन डिस्क्रिमिनेशन को अलग अलग तरीके से उसमें परिभाषित किया गया है। लेकिन आर्टिकल 6 to 16 जो है वो बहुत महत्वपूर्ण है और वो अलग अलग सब्सटेंसिव एरियाज की तरफ हमारा इशारा करते हैं। जैसे यदि आप 6 नंबर के आर्टिकल को देखेंगे तो वो ट्रैफिकिंग एंड प्रोस्टिट्यूशन के संदर्भ में देखेगा। भारत जैसे देश में, भारत जैसा देश जो कुछ समय पर सोर्स स्टेट की भूमिका निभाता है ट्रैफिकिंग में, कई जगह पर डेस्टिनेशन की भूमिका निभाता है ट्रैफिकिंग में। इंटरनेशनल लेवल पे देखेंगे तो हम सोर्स स्टेट के रूप में सामने आते हैं। यदि हम देश के अंदर देखेंगे तो देश के अलग अलग हिस्से हैं जो ट्रैफिकिंग के संदर्भ में ही कभी सोर्स होते हैं, कभी डेस्टिनेशन होते हैं, कभी ट्रांजिट होते हैं, क्योंकि कहाँ से कई बार महिला साथी यहाँ से निकालकर दूसरी जगह पर ले जाई गई, बेची गई या भेजी गई, वो स्थितियों पर स्पेसिफिक एरियाज पे बात करता हुआ आर्टिकल 6 है। 7 आर्टिकल है वो पॉलिटिकल और पब्लिक लाइफ के संदर्भ में बातचीत करता है कि राजनीतिक प्रतिनिधित्व कैसा होगा और निजी जीवन में प्रतिनिधित्व कैसा होगा उस पर। 8वां आर्टिकल है वो पार्टिसिपेशन के संदर्भ में बातचीत करता है कि पार्टिसिपेशन कब होगा, कहाँ होगा, किस स्तर का होगा। वो नेशनैलिटी, एजुकेशन के संदर्भ में, एम्प्लॉयमेंट के संदर्भ में, हेल्थ के संदर्भ में, इकोनॉमिक एंड सोशल बेनिफिट्स के संदर्भ में, महिला जो खासकर ग्रामीण क्षेत्रों की महिला साथी हैं उनके संदर्भ में अलग से एक सेक्शन की बातचीत की गई है। क्योंकि हम देख रहे हैं कि जब हम वंचितता का स्तर देखते हैं तो शहरी क्षेत्र की महिलाएं और ग्रामीण क्षेत्रों की महिलाओं के बीच में एक अलग से एक अंतर समझ में आने लगता है बहुत सारी स्थितियों के साथ साथ। तो उस सेक्शन को एक अलग सेक्शन के रूप में लिखा गया है। एक और यह है कि कानून के सामने इक्वेलिटी बिफोर द लॉ, वो एक अलग सेक्शन है। मैरिज एंड फैमिली लाइफ को एक अलग सेक्शन के रूप में रखा गया। तो यदि हम दोहरा लें तो आर्टिकल 1 to 5 नॉन डिस्क्रिमिनेशन और स्टेट ऑब्लिगेशंस पे बातचीत करते हैं। 6 to 16 में कुछ स्पेसिफिक एरियाज हैं जिन पर बातचीत करने की जरूरत पड़ रही थी और इसलिए देश और दुनिया के लोग एक मत हुए और उन्होंने इतने एरियाज को चिन्हा कि जिस पर यह बातचीत की जा रही है। वैसे यदि आप देखेंगे आर्टिकल 23 to 30 जो है वो एडमिनिस्ट्रेशन के संदर्भ में, इंटरप्रिटेशन के संदर्भ में है कि किस किस तरह से ये कन्वेंशन काम करेगा, कैसे इसकी रिपोर्ट्स की जाएंगी, कैसे ये कन्वेंशन आगे बढ़ेगा और इसको अपने देश के स्तर पर जिन जिन देशों ने इसको रेटिफाई किया है वो कैसे इस पूरे कन्वेंशन के संदर्भ में बेहतरी की चीजें करेंगे। तो ये एक मोटा मोटा स्ट्रक्चर है। हम इस स्ट्रक्चर के एक एक एरियाज के अंदर नहीं जा रहे हैं क्योंकि उतना वक्त नहीं है। कभी विस्तार से और सीधा पे बातचीत करेंगे तो हम एक एक एरियाज को और समझने की कोशिश करेंगे, लेकिन फिलहाल इसके स्ट्रक्चर को अभी हम इस तरीके से देखते हैं। अब इसके बाद इसके जो प्रिंसिपल्स हैं, सीडा के जो प्रिंसिपल्स हैं, वो प्रिंसिपल को भी समझना बहुत जरूरी है। एक प्रिंसिपल है सब्सटेंटिव इक्वालिटी एंड नॉन डिस्क्रिमिनेशन। अब जब इसमें वो कह रहे हैं कि इक्वालिटी की बात कर रहे हैं या नॉन डिस्क्रिमिनेशन की बात कर रहे हैं तो वो कह रहे हैं कि इसका इक्वल का मतलब क्या है। एक इक्वालिटी ऑफ अपॉर्चुनिटी, लॉ, पॉलिसी, प्रोग्राम्स और इंस्टीट्यूशनल अरेंजमेंट्स के थ्रू हम एक इक्वालिटी की बात तो करें या अवसरों की समानता की बात तो करें, लेकिन दूसरी तरफ मैं इसको एक उदाहरण के साथ आपके बीच में रखना चाहता हूं कि मान लीजिए हमारे यहाँ पर एक स्कूल खुला या स्कूल खोलने की बात की गई। अब जब स्कूल खोलने की बातचीत की गई तो ये भी कहा गया कि ये स्कूल लड़के और लड़कियों दोनों के लिए होगा, पहली बात। दूसरी बात ये हुई कि ये स्कूल लड़के लड़कियों दोनों के लिए तो होगा, दोनों के लिए निःशुल्क भी होगा, दूसरी बात। यानी दोनों ही जगह पर अभी तो समता या समानता हमको एक साथ दिख रही है कि लड़के लड़कियों दोनों के लिए ये स्कूल है। दूसरा, दोनों के लिए निःशुल्क शिक्षा की यहाँ प्रावधान है। अब तीसरा ये है, यहां से ये बात समझना की जरूरत है कि सब्सटेंटिव इक्वालिटी का मतलब क्या है कि अब ये स्कूल है कहाँ, ये स्कूल स्थित कहाँ होगा। क्या ये स्कूल समुदाय के करीब में होगा, पहली बात। यदि समुदाय के करीब में होगा और जहां तक बच्चियों की एक्सेस आसानी से हो पाएगी, एक्सेस यानी पहुंच हो पाएगी, तो शायद बालिकाएं उसमें पढ़ेंगी। देखिए, कानून के स्तर पर या प्रावधान के स्तर पर तो हमने समान कर दिया कि लड़के लड़कियों दोनों के लिए स्कूल है, लड़के लड़कियां दोनों के लिए निःशुल्क शिक्षा की यहाँ प्रावधान है। लेकिन जब बात थोड़ी और लेयर हम जब अंदर अंदर जाने की कोशिश करेंगे तब हमें ये सब्सटेंटिव इक्वालिटी को समझ थोड़ा ज्यादा आएगा कि ये स्कूल बना कहाँ है। पहली बात, हो सकता है कि मेरा गांव यहाँ पर है और ये स्कूल यहाँ से 3 किलोमीटर दूर बना है, तो पहले ही हमने एक लेवल पे बच्चियों की जो एक्सेस है वो एक्सेस को थोड़ा कम कर दिया है या एक्सेस उनकी कम हो गई है, जानकर या अनजाने। दूसरा, ये जो पूरा रास्ता है उसमें सिक्योरिटी के क्या प्रावधान है, क्या बालिकाएं वहां तक जाने में सुरक्षित महसूस करती हैं या नहीं करती हैं, ये दूसरा प्रावधान है जब हम सब्सटेंटिव इक्वालिटी को समझने की बात करेंगे। तीसरी स्थिति ये है कि उस स्कूल का इंफ्रास्ट्रक्चर कैसा है। क्या उस स्कूल के इंफ्रास्ट्रक्चर में यदि हम बालिकाओं की विशेष उपस्थिति को देखें तो बालिकाओं के लिए सेपरेट टॉयलेट्स जैसी व्यवस्थाएं वहां पर हैं कि नहीं। यदि वो नहीं है, यदि स्कूल उस बच्चियों की एक्सेस में नहीं है, यदि उस स्कूल तक पहुंचने में बच्चियां अपने आप को सिक्योर फील नहीं करती हैं, तो ये तमाम दोनों तीनों चीजें मिलकर ये तो हमको बताएं। अच्छा, फिर वहां पे स्टाफ कैसा है, महिला स्टाफ है, पुरुष स्टाफ है। पुरुष स्टाफ है तो वो चाइल्ड प्रोटेक्शन के जो इश्यूज हैं, खासकर सिक्योरिटी और इस तरह के जो इश्यूज हैं, उनको कैसे देखता है, उसकी ट्रेनिंग कैसे हुई है, फिर वो बच्चा, उसमें क्वालिटी एजुकेशन का भी एक मापदंड आता है। और फिर जो स्टाफ है जो बच्चों के साथ डील कर रहा, उसकी ट्रेनिंग कैसे हुई है, क्या वो जेंडर बायस तो नहीं है। नहीं तो कई बार जब बच्चियां स्कूल पहुंचती हैं तो आमतौर पर हमारे यहाँ पर ग्रामीण समुदाय में देखने को मिलता है कि बच्चियों के साथ ये कहा जाता है कि अच्छा अब आप भी पढ़ेंगी क्या, हालांकि ये स्थितियां पिछले 2 दशकों में बहुत बदली हैं, लेकिन फिर भी ये है सब्सटेंटिव इक्वलिटी के मायने। यानी एक लेवल पर हमने स्कूल खोला और ये भी कह दिया कि बालिका और बालिकाओं दोनों के लिए है, और साथ में हमने ये भी कह दिया कि ये निःशुल्क शिक्षा है। लेकिन बाद में मैंने आपसे 3 कारक और के साथ शेयर किए कि यार इसमें एक्सेस है कि नहीं, दूसरा एक्सेस है तो वहां का इंफ्रास्ट्रक्चर कैसा है, और बच्चियां वहां तक जाने में सिक्योर फील करती हैं कि नहीं, और चौथा जो बच्चों के साथ डील करने वाले लोग हैं, लड़कियों के साथ, वो कैसे हैं, वो क्या जेंडर बायस तो नहीं है। नहीं तो ये जो पूरी कवायद है जिसको हमने इक्वेलिटी के नाम पर रखा, वो पूरी खत्म हो जाती है। रिजल्ट के रूप में यदि हम देखें या इम्पैक्ट के रूप में देखते हैं तो हमको वो इक्वेलिटी नजर नहीं आती, क्योंकि ऐसे में फिर ड्रॉप आउट रेट बढ़ने लगता है। पहली बात तो बालिकाएं स्कूल ही नहीं पहुंचती, जाती भी हैं तो फिर ड्रॉप आउट रेट धीरे धीरे बढ़ने लगता है, और एक समय में बालिकाएं स्कूल के बाहर बड़े पैमाने पर बालिकाएं हमको दिखती हैं। तो जब हम कह रहे हैं सब्सटेंटिव इक्वालिटी, ये जो प्रिंसिपल है, वो प्रिंसिपल इस तरह की पूरी चीजों को साथ में लेकर, यानी एक व्यापक सोच के साथ सामने आया है। और उसमें भी ये भी कहते हैं कि नॉन डिस्क्रिमिनेशन, बच्चियों के साथ किसी भी स्तर पर भेदभाव ना किया जाए, ना हो। अब इसमें यह भी है कि कम्युनिटी कैसी है, क्या हमने कम्युनिटी के बिहेवियर को देखने की कोशिश की है। फिर बहुत सारे समुदाय, यदि भारत के संदर्भ में हम देखें तो घुमंतु समुदाय हमारे आसपास बहुत हैं, जिसको हम डिनोटिफाइड ट्राइब्स के रूप में कहते हैं, या एक जगह से दूसरी जगह चलते रहने वाले जो समुदाय हैं, उनके संदर्भ में यदि हम स्कूल की कल्पना करें तो क्या हमने उन बच्चियों के लिए भी स्कूल की कल्पना की है। यदि वो लोग जो लगातार डेरे पर एक जगह से दूसरी जगह, दूसरी जगह से तीसरी जगह जाते रहते हैं, तो क्या हम उन बच्चियों के संदर्भ में भी उस स्कूल को देख रहे हैं या नहीं देख रहे हैं। जैसे जिस स्कूल का मैंने आपसे उदाहरण दिया, उस स्कूल में हो सकता है कि एक समुदाय जो उसके आसपास है उसकी बालिकाएं तो आ सकेंगी, लेकिन वो समुदाय जो घुमंतु समुदाय है, उस समुदाय के संदर्भ में क्या हमने उस स्कूल को देखा है या नहीं देखा है। तो ये जो सारी चीजें यदि हम इस नजर से देखते हैं, ये प्रिंसिपल कहता है कि आप जब इस तरह की नजर से देखें और किसी तरह का भेदभाव ना हो, तो फिर ये प्रिंसिपल अपना काम करेगा। आशा करता हूं कि ये बात शायद आप तक पहुंची होगी कि हम सब्सटेंसिव इक्वालिटी को कैसे देखते हैं, कैसे समझते हैं, या इस कानून के संदर्भ में या इस अंतर्राष्ट्रीय संधि के संदर्भ में जो प्रिंसिपल है वो कैसे इसको समझने की बात करता है। यही बात यदि हेल्थ फैसिलिटीज के संदर्भ में देखें तो अब कहने को हमने कहा कि हमारे यहाँ पर एसएचसी है, यानी सब हेल्थ सेंटर है। अब सब हेल्थ सेंटर है कहाँ, उसके नॉर्म्स क्या है। जैसे अभी हमारे यहाँ नॉर्म्स 100 एंड 100 पॉपुलेशन पर एक सब हेल्थ सेंटर होगा। अब पॉपुलेशन 20 गांव के बीच में भी हो सकती है, उतना पॉपुलेशन वो 50 गांव के बीच में भी हो सकती है, या हो सकता है 10 गांव के बीच में भी हो। तो उसकी एक्सेस कितनी है, वहां पर स्टाफ कैसा है, स्टाफ महिलाओं के साथ काम करने के लिए ट्रेंड है कि नहीं है, ये तमाम बातें सब्सटेंसिव इक्वालिटी के साथ जुड़ती हैं। यही तो हम यदि कागजों में देखेंगे तो हमारे पास हॉस्पिटल्स तो हैं, और हॉस्पिटल में सबकी एक्सेस भी है, ऐसा हमारी नीतियां कहती हैं। लेकिन जमीनी स्तर पर वो नीतियों को इस नजर से कैसे देखा जाए, कैसे समझा जाए, तब जाकर वो सब्सटेंसिव इक्वालिटी का जो प्रिंसिपल है वो काम करता है। और इसलिए सीडा के जो प्रिंसिपल्स हैं उसमें सब्सटेंसिव इक्वालिटी को बहुत महत्ता दी गई है कि वो तमाम तरह की एक्सेस को भी उसमें देख सके और उसको इंश्योर कर सके। वैसे स्टेट ऑब्लिगेशन, जो स्टेट्स जिन्होंने इसको रेटिफाई किया है वो इस पूरे कन्वेंशन को रिस्पेक्ट कर सकें, इसको प्रोटेक्ट कर सकें, और इसको प्रोटेक्ट करने के साथ साथ इसके जो नॉर्म्स हैं या इसके जो संदर्भ में चीजें हैं उनको प्रमोट कर सकें, और अपने यहाँ फिर नीति, नियम, कानून, कायदे, प्रोग्राम्स इस तरीके से डिजाइन करें कि वो जो ये जो प्रिंसिपल्स हैं, जो सीडा जिसको कहता है, जिसमें नॉन डिस्क्रिमिनेशन का पूरा भाव आया है महिलाओं के साथ अलग अलग तरीके के डिस्क्रिमिनेशन का, वो चीजों को अपने यहाँ पर फिर एड्रेस कर सके। तो ये प्रिंसिपल ऑफ स्टेट ऑब्लिगेशन भी है। अभी जरा हम देखेंगे कि जब हम सीडा आया तो हमारे पास कब सीडा आया है, 1979 में, इंडिया ने 1993 में रेटिफाई किया है। लेकिन ये जो सेकंड प्रिंसिपल है, प्रिंसिपल ऑफ स्टेट ऑब्लिगेशन, इसको हम कैसे समझें, इंडिया ने क्या किया इसके बाद। क्या हम केवल रेटिफिकेशन करने के बाद ही चुप हो गए, या हमने इसके बाद भी कुछ किया, और रेटिफिकेशन के बाद किस तरह की स्थितियां बनी हैं, या जो ऑप्शनल प्रोटोकॉल आए हैं वो किस तरह की स्थितियों पे बातचीत करते हैं, वो मैं आगे आपसे बात कर रहा हूँ। मैं आशा कर रहा हूँ कि मैं शायद हिंदी में तो बात कर रहा हूँ, लेकिन शायद कठिन हिंदी में बात नहीं कर रहा हूँ, कि आप सब तक थोड़ा पहुंच पा रहा होगा, ऐसी मैं आशा करता हूँ। अब ऑप्शनल प्रोटोकॉल जो हैं, यानी ऑप्शनल प्रोटोकॉल क्या होते हैं, पहले जरा अपन इस पे बात कर लें कि ट्रीटीज के समय बहुत सारी बातें आती हैं, लेकिन हो सकता है कि कुछ बातें छूट गई हैं या कुछ बातें समय के साथ साथ इस तरह के कन्वेंशन में सामने आती हैं, वो ऑप्शनल प्रोटोकॉल के रूप में सामने आते हैं कि इनको भी ऐड किया जाए। तो वो ऐड किए गए, जैसे 2000 में ऑप्शनल प्रोटोकॉल इसके संदर्भ में आया सीडा का, इसको 90 के आसपास स्टेट्स ने इसको अपने अभी तक की मान्यता दी है, इस पर मोहर लगाई है। इसमें दो तीन चीजें बहुत महत्वपूर्ण तरीके से आई। एक तो यह है कि थर्ड पार्टी कंप्लेंट्स हो सके स्टेट वायलेशन पे, यानी मैं एक देश हूं, मान लीजिए हम भारत देश हैं, भारत देश ने इसको रेटिफाई तो कर लिया, लेकिन भारत देश में यदि अभी भी ऐसी स्थितियां बन रही हैं जहां महिलाओं के खिलाफ अलग अलग तरीके के भेदभाव या हिंसा के मामले लगातार सामने आ रहे हैं, तो इसमें थर्ड पार्टी कंप्लेंट्स की जा सके। अब थर्ड पार्टी कौन होगी? यूएन के संदर्भ में यदि हम देखें तो यूएन ने साइन कराया, यूएन के अपने जो अपने सहयोगी देश हैं उन्होंने साइन किया, दो पार्टी वो हो गई। तीसरा हम जैसे एनजीओज, आप जैसे जो कॉलेजेस या इस तरीके के जो लोग हैं वो थर्ड पार्टी के रूप में हैं, और वो इंस्टीट्यूट्स, वो एनजीओज, ये सब मिलकर अपने स्टेट्स के संदर्भ में कोई वायलेशन यदि ऐसा हो रहा महिलाओं के खिलाफ, उसकी रिपोर्ट भी वहां पर कर सकते हैं, इंडिपेंडेंट इन्वेस्टिगेशंस भी कर सकते हैं यदि इस तरह की स्थितियां होती है, और उसको सबमिट करें। वैसे यहाँ पर एक कमेटी और बनी है, जो कमेटी ऑन द एलिमिनेशन ऑफ डिस्क्रिमिनेशन अगेंस्ट वीमेन है, जिसमें 23 एक्सपर्ट्स जो हैं वो अलग अलग मेंबर स्टेट्स की तरफ से चुनकर आते हैं, और वो मेंबर स्टेट्स के जो कमेटी मेंबर्स हैं, वो कमेटी मेंबर्स इस पूरे सीडा कन्वेंशन के बाद जो देशों में चल रहा है उस देशों को देख सकें, उस पर नजर रख सकें, और ये भी कई बार उनको सुझाव दे सके कि देखिए आपने अभी तक ये नहीं किया, इसको ऐसा ऐसा किया जाना चाहिए, फलाने देश ने ऐसा किया, उस देश ने ऐसा किया, आपने अभी तक ऐसा कुछ नहीं किया। तो ये एक कमेटी का रोल बहुत महत्वपूर्ण हो रहा है। और इसी में एक और महत्वपूर्ण चीज कही गई है कि हर समय कुछ एक निर्धारित अंतराल पर हर 4 साल के बाद जो भी मेंबर देश है, जैसे इंडिया एक मेंबर देश है, उसको अपनी एक रिपोर्ट प्रस्तुत करनी है कि सीडा कन्वेंशन को रेटिफिकेशन के बाद अभी तक हमने अपने देश में क्या क्या किया है, ऐसी कौन कौन सी प्रोग्रेस की है जो सीडा कन्वेंशन के प्रिंसिपल को फुलफिल करने की दिशा में हम आगे बढ़ रहे हैं। तो ये दो ऑप्शनल प्रोटोकॉल के रूप में है। और यदि अब हम देखें, क्योंकि मेरे पास वक्त कम है इसलिए मैं थोड़ी गति आगे बढ़ा रहा हूं, अभी यदि हम देखें कि इंडिया ने जो अपनी पीरियोडिक रिपोर्ट प्रस्तुत की है, फोर्थ और फिफ्थ रिपोर्ट एक साथ 2014 में भेजी है, उसमें उन्होंने जिक्र किया है कि देखिए जब हमारे पास मतलब बहुत सारे प्रावधानों के बाद जब सीडा आया, सीडा के बाद जब हम फोर्थ और फिफ्थ रिपोर्ट में उन्होंने जिन चीजों का उल्लेख किया है वो जरूर मैं आपके सामने रखता हूं ताकि थोड़ी स्पष्टता आपको सामने आएगी। उन्होंने कहा है कि हमने नेशनल फूड सिक्योरिटी एक्ट बनाया। अभी डॉक्टर कविता का सत्र जब मैं अटेंड कर रहा था तब मैं उसमें भी सुन रहा था, उन्होंने भी इस बात का जिक्र किया था कि एनएफएस हमारे यहाँ पर आया है, नेशनल फूड सिक्योरिटी एक्ट, और इसमें विशेष रूप से महिलाओं और बच्चों के संदर्भ में खाद्य और पोषण सुरक्षा को एड्रेस करने की कोशिश की है। तो जब इंडिया ने अपनी रिपोर्ट सीडा कमेटी को सौंपी है, तो उस कमेटी की रिपोर्ट में उसने कहा कि देखिए हम महिलाओं और बच्चों के पोषण के संदर्भ में, खासकर जो महिलाएं एनीमिक हैं उनके पोषण के संदर्भ में एनएफएसए में हमने कैसे प्रावधान किए हैं। वैसे ही उन्होंने ये भी कहा है कि जब हम एक तरफ आंकड़ा हम लोग देख रहे थे कि गरीबी रेखा के नीचे अधिकांश महिला साथी हैं और बच्चे हैं, तो उन गरीबी रेखा के नीचे रहने वाली महिलाएं या गरीबी रेखा के नीचे रहने वाले परिवारों के लिए हमने फूड सिक्योरिटी कैसे इंश्योर करने के लिए एनएफएसए को लेकर आए। इस तरीके से अलग अलग चीजें डिफाइन की जाती हैं इस तरह की रिपोर्ट्स में, ताकि मेंबर देश बताते हैं कि हमने देखिए इस कन्वेंशन के बाद अपने यहाँ पर क्या क्या किया है अभी तक। वैसे ही एक और दूसरा कानून के जिक्र है इस रिपोर्ट में। उन्होंने कहा है कि काम करती हैं उस वर्क प्लेस की जो जगह पर सेक्सुअल हरासमेंट एट वर्क प्लेस के संदर्भ में सेक्सुअल हरासमेंट एट वीमेन एट वर्क प्लेस प्रिवेंशन, प्रोहिबिशन एंड रेड्रेसल एक्ट 2013। यानी अब महिला साथी जब बड़े पैमाने पर काम करने के लिए बाहर निकल रही हैं तो अलग अलग उनके जो कार्य क्षेत्र हैं, चाहे वो मजदूर साथी के रूप में हो वो भी एक कार्य क्षेत्र है, वो किसी ऑफिस में चारदीवारी के अंदर बैठ के काम करते हैं वो भी एक कार्य क्षेत्र है, वो महिला साथी किसी घरेलू कामकाज की तरह पे आ रही हैं, मान लीजिए हमारे यहाँ घरों में काम करने वाली बहनजियां आती हैं, वो भी एक कार्य क्षेत्र के रूप में इसमें डिफाइन किया गया है। तो कहीं पर भी वो महिला साथी घर से काम करने के लिए बाहर निकली हैं और जहां पर वो काम कर रही हैं वहां पर उनके साथ प्रिवेंशन, प्रोहिबिशन और रेड्रेसल के संदर्भ में, खासकर सेक्सुअल हैरेसमेंट के संदर्भ में हमने एक एक्ट लाए। तो इस तरीके से पीरियोडिक रिपोर्ट में अपने अपने देशों की प्रगति रखी जाती है और इसको वो कमेटी देखती है, ऑब्जर्व करती है, फिर कुछ सुझाव देती है, या हो सकता है कि कई बार ये पीरियोडिक रिपोर्ट नहीं पहुंचती है तो वो मेंबर देशों को बहुत कड़ाई से इसका पालन करने के संदर्भ में निर्देशित भी करती है। वैसे ही इस रिपोर्ट में एक और जिक्र किया गया है, वो जिक्र ये भी किया गया है कि हमारे यहाँ पर आईपीसी, सीआरपीसी और इंडियन एविडेंस एक्ट जो पुराने रहे हैं उनमें संशोधन करते हुए भी क्रिमिनल लॉ अमेंडमेंट एक्ट 2013 आया है। आप सब मित्र जानते ही होंगे, निर्भया कांड जब हुआ हमारे देश में, 2012 की घटना है, वो बहुत नृशंस कांड रहा है। उसमें बलात्कार का केस था लेकिन बाद में वो बालिका की डेथ हुई। उसके बाद से बहुत सारी चीजें हमारे देश में बदली भी हैं। वो उसके बाद क्रिमिनल लॉ अमेंडमेंट एक्ट आया है 2013 में, इसमें बहुत सारी चीजें बदल के आई। जस्टिस वर्मा कमेटी के जो अनुशंसाएं थी उसके आधार पर ये बदला है। तो लेकिन ये भी सीधा रिपोर्ट में जिक्र किया गया है। वैसे ही मैनुअल स्कैवेंजिंग में आप देखेंगे जहां पर सिर पर मैला ढोने की प्रथा रही है या हाथ से मैला साफ करने की प्रथा रही है, हमारे बहुत सारे साथी देखेंगे कि कई बार हमारे देश में ये कहा जाता है कि अब मैनुअल स्कैवेंजिंग लगभग नहीं है, बहुत सारी जगहों पर नहीं है, प्रदेशों में कहा जाता नहीं है, लेकिन अभी भी बहुत सारी जगह प्रमाण दिखते हैं और जहां जहां प्रमाण दिखते हैं वहां पर अधिकांश जगह पर आप देखेंगे महिला साथी इस पूरी प्रक्रिया में बड़े पैमाने पर लगी होती हैं, खासकर ग्रामीण क्षेत्रों में। सो उसके लिए भी एक एक्ट लाया है। वैसे एक पॉक्सो एक्ट आया है जो हम सब ज्यादातर जानते हैं, और वो 18 साल से कम उम्र के बालक और बालिका दोनों के साथ होने वाले किसी भी तरह के सेक्सुअल वायलेंस, चाहे वो नॉन टच सेक्सुअल वायलेंस हो या टच सेक्सुअल वायलेंस हो, दोनों को एड्रेस करने के लिए ये कानून आया है, प्रोटेक्शन ऑफ चिल्ड्रन फ्रॉम सेक्सुअल ऑफेंसेस एक्ट। तो जब कानून कहता है कि सीधा कहता है कि सेक्सुअल ऑफेंसेस जैसे जो अपराध है उनको भी देखने की कोशिश करेंगे, तो हमारे इंडिया की जो रिपोर्ट जाती है वो कहती है कि हमने देखिए अलग से एक एक्ट लेकर आए हैं जिसका नाम है पॉक्सो एक्ट, जिसमें बालक और बालिका और दूसरा जो थर्ड जेंडर के भी साथी हैं उनको भी इसमें शामिल किया गया है। तो जब चूंकि हम कहते हैं जेंडर के बात करते हैं तो उसमें थर्ड जेंडर को भी शामिल करते हैं, इसलिए पॉक्सो का जिक्र करते हुए इस रिपोर्ट में ऐसा भी कहा गया है। वैसे ही अब आप देखेंगे अलग अलग स्कीम्स के बारे में भी। अब जब हमारे स्टेट ऑब्लिगेशन था उसमें क्या था, नीति भी बने, नियम भी बने, कार्यक्रम भी बने और कानून भी बने। सो वैसे ही कई सारी योजनाओं का भी इस तरह की रिपोर्ट्स में जिक्र होता है। तो आप देखेंगे हमारे यहाँ जननी सुरक्षा एक योजना है जो गर्भावस्था के दौरान महिला साथी जो उनको एंटीनेटल चेकअप से लेकर यदि वो इंस्टीट्यूशन में अपनी डिलीवरीज कराती हैं तो उनको एक आर्थिक सहायता भी दी जाती है और इंस्टीट्यूशन में डिलीवरीज कराने का जो पूरा खर्च है वो भी सरकार वहन करती है। तो इस स्कीम का भी सरकार ने उसमें जिक्र किया है। वैसे इंदिरा गांधी मातृत्व सहायता जो योजना है और सहयोग योजना उसका भी जिक्र किया है, जिसमें 6,000 रुपए तक की राशि एक गर्भवती महिला को दी जा सकती है, उसका जिक्र किया है। वैसे ही सरकार ने एक और बहुत महत्वपूर्ण बात की है। आप सब MSW के अधिकांश छात्र मुझे समझ में आते हैं, आप सब भी इस प्रक्रिया को शायद गौर से आप देख सकेंगे, सुन सकेंगे कि सरकार ने कहा है कि हम जेंडर बजटिंग करते हैं आजकल। यानी अलग अलग, अभी हम सुनते हैं कि यूनियन बजट आया, स्टेट बजट अभी आने वाला है, फेब में आएगा। तो वैसे जब बजट आते हैं स्टेट के या यूनियन बजट आते हैं उसमें जेंडर के लिहाज से यानी महिलाओं के लिहाज से उस पूरे बजट को देखने की प्रक्रियाएं भी भारत जैसे देश या अन्य देशों ने शुरू की हैं और उसको भी सीडा को रिपोर्ट कर रहे हैं कि देखिए सीडा के आने के बाद हमने इस नजर से भी महिलाओं के मुद्दों को देखना शुरू किया है कि हम जेंडर बजट जैसी चीजें अपने यहाँ पर लेकर आए हैं। सो ये ट्रीटीज के कुछ प्रभाव भी दिखते हैं और कि कैसे जब स्टेट ऑब्लिगेशन आता है तो फिर हमारे देश कैसे फिर उनको मतलब उसके संदर्भ में रिपोर्ट करते हुए बताते हैं कि देखिए हमने इसके बाद क्या क्या किया। वैसे अभी आप देखेंगे कुछ और नाम शायद हो सकता है आप सब युवा साथी आपके लिए कुछ नाम नए हों, लेकिन फिर भी मैं यहाँ जिक्र करना चाहता हूँ। जैसे राष्ट्रीय महिला सशक्तिकरण मिशन एक सरकार ने शुरू किया है जो विमेन एम्पावरमेंट के संदर्भ में है। वैसे आप देखेंगे निर्भया फंड करके एक आया है जो 2012 के बाद आया है। निर्भया फंड सेंट्रल का स्कीम है लेकिन स्टेट पर भी निर्भया फंड है। एंटी ह्यूमन ट्रैफिकिंग यूनिट्स की स्थापना की गई है क्योंकि ऐसा माना जाता है कि अधिकांशतया महिला साथियों की ट्रैफिकिंग के प्रकरण ज्यादा आते हैं, इसलिए एंटी ह्यूमन ट्रैफिकिंग को भी सीडा रिपोर्ट में बताया गया है। फिर ये भी कहा गया है कि हम जेंडर के समझ के हिसाब से ऐसे लोग जो महिला साथियों के साथ डील करते हैं, यानी चाहे पुलिस डील करती हो चाहे जुडिशरी डील करती हो, चाहे आप देखेंगे कि जो लेजिस्लेटिव असेंबली के लोग डील करते हैं, जो भी डील करते हैं, उनकी अलग अलग स्टेक होल्डर्स की ट्रेनिंग इस तरीके से की जा रही है कि वो जेंडर के लिहाज से चीजों को देख सके, जेंडर की तरह समझ सके, जेंडर को समझ सके और जेंडर के लिहाज से चीजों को देख सके और वो काम कर सके। वैसे ही सरकार ने यह भी कहा है कि हम विक्टिम कंपनसेशन स्कीम लाए कि यदि कोई पीड़िता है या पीड़ित है और उसके साथ यदि किसी भी तरह का दुर्व्यवहार हुआ है तो उसके लिए हम विक्टिम कंपनसेशन स्कीम लाए हैं। वैसे ही सरकार ने यह भी कहा है कि अब कोई भी महिला साथी जिसके साथ किसी भी तरह की हिंसा हुई हो, चाहे वो डोमेस्टिक वायलेंस की हिंसा हो, एसिड अटैक का कोई मामला हो, प्रेम प्रसंग में की गई कोई उसके साथ की गई कोई वारदात हो, अलग अलग तरीके की जो भी हिंसा है, उसके लिए भारत के हर जिले में अब वन स्टॉप क्राइसिस सेंटर करके सरकार ने स्थापना की है, जहां पर एक ही जगह पर वन स्टॉप क्राइसिस सेंटर में उस बच्ची को, उस महिला साथी को अलग अलग तरीके की सुविधाएं प्रदान की जा सके, जिसमें कानूनी मदद भी है। और सरकार ने यह भी जिक्र किया है कि देखिए, जब हम 2001 की सेंसस के हिसाब से थे तो उसमें हम 53.67% ऐसी महिलाएं थी जो साक्षर थी। अभी उनका दर 65.46% हुआ है। तो केवल एक पक्ष की तरफ नहीं देख रहे, जैसे हमने कहा कि वो इसमें सीडा में कहा गया है कि सोशल, कल्चरल, इकोनॉमिक सभी तरह के डायमेंशंस उसमें खोले गए हैं। वैसे ही जब रिपोर्ट जाती है उसमें सभी तरह के डायमेंशंस पे बात की जाती है। देखिए, अभी आपने यदि गौर किया हो, हमने गर्भवती माताओं के संदर्भ में भी बात की, हमने कुपोषित महिलाओं के संदर्भ में भी बातचीत की, हमने अभी देखा कि जो महिलाएं घरेलू हिंसा या किसी भी तरह के हिंसा का शिकार है उसके संदर्भ में भी बात हुई। हमने ऐसा भी देखा कि जो महिलाएं हो सकता है कि ट्रैफिकिंग का शिकार हुई तो उनके संदर्भ में भी बात हुई। यानी जितने डायमेंशन सीटा में बताए गए हैं उतने डायमेंशन पर सरकारें फिर अपनी रिपोर्ट करती हैं और बताती हैं कि देखिए, हमने अलग अलग डायमेंशन को कवर करने के लिए क्या क्या किया। वैसे इंटरेस्टिंग एक और चीज आई है, भारतीय महिला बैंक लिमिटेड, बीएमबी करके अब जो नए बैंक्स आए हैं वो भारतीय महिलाओं के संदर्भ में एसएचजीज को ध्यान में रखते हुए या भारतीय महिलाओं के संदर्भ में स्पेसिफिक बैंक्स हैं। वैसे ही आप देखेंगे एनआरएलएम यानी नेशनल रूरल लाइवलीहुड मिशन और एनयूएलएम नेशनल अर्बन लाइवलीहुड मिशन, ये सारे मिशंस में विशेष रूप से महिला साथियों की भागीदारी को देखा गया है। तो जब हम कहते हैं कि हमारे यहाँ पर अलग अलग तरीके से कैसे मतलब सीडा आया, सीडा आने के बाद हमने रेटिफाई किया, लेकिन रेटिफाई करने के बाद हमने इसके ऑप्शनल प्रोटोकॉल और इन सबको देखा और उसके बाद यानी मैं अभी इंडिया की बात कर रहा हूँ, फिर इंडिया उस पर समय समय पर रिपोर्ट करता है और जो मैंने 4th और 5th रिपोर्ट जो 2014 में गई है उसकी कुछ झलकियां आपके सामने रखी। तो मैं इस वाले सत्र को यहीं पर समाप्त कर रहा हूँ और इसमें मैं एक बार दोहरा देता हूँ आपको चीजें। सीडा आया, सीडा ने कहा कि किस किस तरीके का डिस्क्रिमिनेशन है महिलाओं के साथ और सभी तरह के डिस्क्रिमिनेशन को उन्होंने समाप्त करने के संदर्भ में यह अंतर्राष्ट्रीय संधि है और इस अंतर्राष्ट्रीय संधि में लगभग 189 कंट्रीज ऐसी हैं जिन्होंने अब यूएन के जो सदस्य देश हैं उन्होंने इसको रेटिफाई किया है और ये अपने आप में बहुत सफल संधि कही जाती है, क्योंकि इतने बड़े देशों ने, इतने बड़े पैमाने पर देशों ने इस संधि को हस्ताक्षरित किया है, अंगीकृत किया अपने यहाँ पर। और जब ये आई है तो हमने उसका स्ट्रक्चर को भी थोड़ा समझने की कोशिश की कि इसका स्ट्रक्चर कैसा है, कौन कौन सी तरह के इसमें आर्टिकल्स कहे गए हैं। इंडिया ने कब इसको रेटिफाई किया? 93 में किया। इंडिया ने 16 आर्टिकल्स के साथ इसको रेटिफाई किया। फिर इंडिया ने इसको अंदर जब अपने यहाँ पे इसको रेटिफाई किया, उसके बाद हमने अपने यहाँ पर कैसे महिलाओं की स्थिति के संदर्भ में परिवर्तन देखे हैं। आप सबके मित्रों के दिमाग में शायद ये सवाल चल रहा होगा और जो आना भी चाहिए, और वो सवाल ये है कि क्या अभी महिलाओं की स्थिति वैसी हो पाई है जैसी अभी हम मतलब इस सत्र के दौरान चर्चा में हम लोग बातचीत में लेकर आ रहे हैं। लेकिन अभी हम यदि पिछले 3 दशकों में, 4 दशकों में देखें और खासकर सीडा के आने के बाद यदि हम देख रहे हैं तो निश्चित रूप से ये बहुत उल्लेखनीय प्रगति हुई है, जिसका जिक्र मैंने अभी कुछ आपसे किया। हमारे यहाँ बहुत सारे एक्ट उस दिशा में बन रहे हैं। सबसे बड़ी बात यह है कि हमने जेंडर को जेंडर की तरह से समझने की कोशिश करना शुरू किया है और खासकर अभी नीतियों के संदर्भ में, कार्यक्रमों के संदर्भ में तो वो चीजें आना शुरू हुई हैं। हाँ, लेकिन शायद अभी 2035-40 में शायद हम कोई सेमिनार कर रहे होंगे, तब हम शायद और देख पाएंगे कि ये जो बातचीत अभी नीति, नियम, कार्यक्रम, कानूनों के संदर्भ में होना शुरू हुई है, ये धीरे से नीचे खिसक कर अगले 20-25 सालों में आप देखेंगे कि ये समुदायों तक भी पहुंचने लगेंगी, जहां मेरे और आपके घरों के भीतर भी शायद इस तरह से जेंडर को समझने की और उसकी बातचीत होना शुरू होगी। लेकिन उस दिशा में ये बहुत महत्वपूर्ण पड़ाव है और सीडा कन्वेंशन। सो मैं आशा करता हूं कि शायद सीडा कन्वेंशन से जुड़ी कुछ बातें आप तक पहुंची होंगी, शायद कुछ नई बातें।
सर
जी
नमस्कार। सर मुझसे आपसे ये सवाल है कि जैसे आपने अभी बोला कि लाइक हर जगह अपन
सवालों को हम सवालों को थोड़ा लास्ट में ले रहे हैं, क्या ये चलेगा? आप बचा के रख सकेंगे?
अच्छा, आपका एक और सेक्शन। ओके ओके सर, ओके।
अभी 2-3 है अपने, फिर उसके बाद अपन इकट्ठे उस पर बातचीत करेंगे।
ओके ओके।
वक्त कम है तो मैं थोड़ा अभी जल्दी भाग रहा हूँ, फिर उसके बाद अपन एक साथ सवाल लेते हैं।
जी
आप
सर।
बचा के रखिए।
Students, you can wait for the questions. We have 3 segments in this session as well. Okay?
Yeah.
Sir, sessions ले ले, उसके बाद you can ask your questions.
Fine.
आप please continue, sir.
अच्छा, बस मैं एक चीज यहाँ पर रुक के पूछना चाहता हूँ। हालांकि मैं हिंदी में बात कर रहा हूँ, हमारे केरल से जुड़े कुछ साथी, उनको दिक्कत हो सकती है, लेकिन बाकी मेरी भाषा आपको ठीक लग रही है? क्या मेरी भाषा समझ में आ रही है आपको?
हाँ जी,
यस सर, बिल्कुल समझ आ रही है।
ठीक है। सो अभी हमने एक कन्वेंशन के संदर्भ में बातचीत की है, वो कन्वेंशन था सीडॉल। अभी हम एक और दूसरे कन्वेंशन की तरफ बातचीत कर रहे हैं, और जिस पर मेरी थोड़ी समझ भी है क्योंकि मैं बच्चों के साथ काम करता हूँ। सीडा पर भी समझ है, लेकिन यूएनसीआरसी पर थोड़ी ज्यादा समझ है क्योंकि बच्चों के साथ लंबे समय से काम कर रहा हूँ। तो वो दूसरे कन्वेंशन की तरफ हम और बढ़ते हैं, और फिर उसके बाद थोड़ी स्थितियां हम चाइल्ड लेबर के संदर्भ में बातचीत कर लेंगे, और फिर आपके सवाल जवाब। तो मैं यहाँ से बगैर देरी के अभी मैं उसको निकाल लेता हूँ, फिर आपके पास आता हूँ। आपको स्क्रीन दिख रही है? आप स्क्रीन देख रहे हैं?
यस सर।
ग्रेट, ठीक, थैंक यू। सो ये वाला जो कन्वेंशन है, इसका नाम है यूनाइटेड नेशन कन्वेंशन ऑन द राइट्स ऑफ द चाइल्ड। हिंदी में इसको कहते हैं संयुक्त राष्ट्र बाल अधिकार समझौता। और जैसे हमने कहा कि पूरी देश और दुनिया के पूरे देश और दुनिया के जो देश, हमारा देश और पूरी दुनिया के जो देश बहुत सारे मुद्दे पर एक मत होते हैं, जिसमें महिलाओं के संदर्भ में अभी हमने एक अंतर्राष्ट्रीय कन्वेंशन को समझने की कोशिश की है, अंतर्राष्ट्रीय संधि को समझने की कोशिश की है। वैसे पूरी देश और दुनिया में ये बहस लगातार लंबे समय से चलती रही कि हम बच्चों के अधिकारों को कैसे देखें और बच्चों के अधिकारों को डिफाइन भी कैसे करें। और बच्चों के अधिकारों को डिफाइन करने के लिए भी एक तरह की ट्रीटी की बहुत जरूरत थी, और उसमें यह भी था कि हम पूरी दुनिया में, अभी तो हम बच्चों की परिभाषा पर एक मत नहीं थे इस कन्वेंशन के आने के पहले, कि अलग अलग देश अलग अलग तरीके से अपने यहाँ बच्चों की परिभाषा पर बात करते थे। और जो अभी भी हमारे यहाँ पर देश पे है, बहुत सारे कानून ऐसे हैं जिसमें अलग अलग परिभाषा है बच्चों की, लेकिन यूनिवर्सल लेवल पर एक परिभाषा की बातचीत बहुत की जा रही थी कि क्यों ना पूरे देश के स्तर पर, पूरी दुनिया के स्तर पर बच्चों की एक सर्वमान्य परिभाषा लाई जाए कि हाँ, अब हम पूरी दुनिया में एक उस व्यक्ति को बच्चा कहेंगे जिसकी उम्र इतने से कम हो, या इस व्यक्ति को ही हम बच्चा मानेंगे। तो सबसे पहले तो एक वो बात थी, लेकिन दूसरी बात ये भी थी कि बच्चे वो हैं जिनको थोड़े अलग तरीके से, जैसे बच्चे वल्नरेबल हैं, बच्चों का अपना कोई, शायद आप स्क्रीन देख पा रहे होंगे, नहीं तो मैं फिर से इसको शेयर करता हूँ।
यस सर, दिख रहा
है कि बच्चे वल्नरेबल हैं, बच्चों को प्रोटेक्शन की बहुत अलग तरीके की जरूरत है, अलग तरीके की उनकी देखभाल की जरूरत है। बच्चे अलग अलग ग्रुप से आते हैं और उनकी अलग अलग नीड्स और अलग अलग अधिकार हैं, वो दिए जाने की बात की जानी चाहिए। और बच्चों के स्पेसिफिक राइट्स हैं जो जिनको हम मानवाधिकारों के रूप में, बच्चों के मानवाधिकारों के रूप में देखते हैं, समझते हैं। सो बच्चों की अलग अलग जरूरतें हैं, इसलिए उनके अलग राइट्स भी हैं, और अलग अलग ग्रुप से आते हैं, इसलिए उनकी नीड्स और उनके राइट्स और उनकी आवश्यकताएं बिल्कुल अलग अलग हैं। उनको कैसे एड्रेस किया जाए, और चूंकि राइट्स अभाज्य हैं, ये किसी के साथ बांटे नहीं जा सकते, ये मौलिक हैं, और इसीलिए, और बच्चों के जो अधिकार हैं या किसी के भी जो अधिकार, उसमें कोई हायरार्की नहीं है कि ये अधिकार मिल जाए तो फिर ये वाला अधिकार बेहतर होगा या बड़ा होगा, या ये अधिकार बड़ा होगा या ये अधिकार छोटा होगा। सो इसलिए बच्चों के अधिकारों पर बहुत बड़े पैमाने पर देश और दुनिया में बहसें चल रही थी, और इसके चलते ये कन्वेंशन है जिसका नाम है यूएन कन्वेंशन ऑन द राइट्स ऑफ द चाइल्ड, यूएनसीआरसी। ये कन्वेंशन, जैसे हमने अभी सीडा को पढ़ा, वैसे ही इसमें भी यूएन के पूरे सदस्य देश एक साथ सामने आए, और सदस्य देशों ने इस कन्वेंशन पर अपनी मोहर लगाई। ये कन्वेंशन 1989 में हमारे सामने आया। इसको UNCRC कहते हैं, जैसे मैंने आपसे कहा। और ये कन्वेंशन 1989 में 20 नवंबर 1989 को ये यूनाइटेड नेशंस की जो जनरल असेंबली है उसने इसको पारित किया। और उसके बाद ये इस कन्वेंशन को अलग अलग देश, जो सदस्य देश हैं, उन्होंने अपने यहाँ पर रेटिफाई किया। जैसे अभी हमने सीडा को समझा, सीडा को किस तरीके से रेटिफाई किया, वैसे अलग अलग देशों ने इस कन्वेंशन को रेटिफाई किया। और अब आप देखेंगे, माफ करिए मैं सीडा में एक सितंबर की एक डेट बताना भूल गया, 3 सितंबर को अब हम सीडा डे के रूप में मनाते हैं पूरी दुनिया में। वैसे ही 20 नवंबर को चूंकि ये कन्वेंशन साइन हुआ था, जो कन्वेंशन पारित हुआ था, इसलिए अब 20 नवंबर को पूरी दुनिया में इंटरनेशनल चाइल्ड राइट्स डे के रूप में सेलिब्रेट किया जाता है। तो अब आप देखेंगे अक्सर हम लोग 14 नवंबर टू 28 नवंबर के बीच में एक वीक को सेलिब्रेट करते हैं। वो इंडिया के संदर्भ में बहुत मौजूद है, क्योंकि 14 नवंबर को हम पहले से ही बाल दिवस के रूप में मनाते हैं। लेकिन अब हमारे पास एक और नया दिवस है जो 20 नवंबर के रूप में है, जो इंटरनेशनल चाइल्ड राइट्स डे के रूप में है। इसलिए अब हम वो एक वीक सेलिब्रेट करते हैं 14 नवंबर टू 20 नवंबर, मतलब बाल दिवस से लेके बाल अधिकार दिवस के बीच में। तो वो बाल अधिकार दिवस यहाँ से आया है जब ये कन्वेंशन पूरी दुनिया के सामने आया। इसमें लगभग 190 कंट्रीज ने इस पे साइन कर दिए हैं, इसको रेटिफाई कर दिया है। अभी जैसे पिछले कन्वेंशन को हमने देखा, उसमें से अभी 4-5 देश ऐसे हैं जिन्होंने साइन नहीं किया था। ये कन्वेंशन में 2 देश ऐसे थे जिन्होंने इस पे साइन नहीं किया था, अमेरिका और सोमालिया। अभी सोमालिया ने भी इसको साइन कर दिया है। अब अमेरिका भर बचा है जिसने इस कन्वेंशन पर अभी तक साइन नहीं किया है। इंडिया ने 1992 पर इस कन्वेंशन को साइन किया है, यानी 3 साल हमने इस पे भी लगाए। हमने सोचा समझा कि क्या हम अपने देश में बच्चों की बेहतरी के संदर्भ में ये जो इंटरनेशनल प्रोटोकॉल आया है, जो इंटरनेशनल कन्वेंशन आया है, क्या हम उसके तहत अपने देश में भी बच्चों की परिस्थितियां बेहतर करने पर काम कर सकते हैं। 3 साल की हमारी समझ के बाद, हमारे यहाँ की जांच पड़ताल के बाद, हमने 1992 पे इस कन्वेंशन पर अपनी मुहर लगाई। और उस कन्वेंशन के बाद हमारे देश में भी चीजें बड़े पैमाने पर तेजी से बदली है। लेकिन ये कन्वेंशन कहता क्या है, कैसे ये कन्वेंशन काम करता है, इसके ऑप्शनल प्रोटोकॉल क्या है, और इसके साथ साथ ये कन्वेंशन में कितने आर्टिकल्स हैं, इसका स्ट्रक्चर कैसे है, ये कैसे बच्चों के अधिकारों को डिफाइन करता है, अपन जरा थोड़ा इसमें आगे समझते हैं। इसमें अब आप देखेंगे कि इसमें 54 आर्टिकल्स इसमें ओवरऑल हैं, जिसमें यदि हम 43 टू 54 के आर्टिकल के बीच में बातचीत करेंगे तो वो एडल्ट्स के संदर्भ में, यानी हम वयस्कों के संदर्भ में है, जो बच्चों के प्रति अपनी जिम्मेदारी कैसे निभाएंगे। और जब हम वयस्कों की बात कर रहे हैं तो उस वयस्क में मैं और आप भी शामिल हैं, समुदाय भी शामिल है, समाज भी शामिल है, और उसमें सरकारें और ऐसी संस्थाएं भी शामिल हैं जिसको हम बाल अधिकार संरक्षण आयोग जैसी संस्थाएं कहते हैं। यानी स्टेटूटरी बॉडीज भी शामिल है, गवर्नमेंट भी शामिल है, मैं और आप भी शामिल है, समुदाय भी शामिल है, समाज भी शामिल है। तो हमारी जिम्मेदारी की तरफ वो इशारा करता है कि हम एडल्ट की क्या जिम्मेदारी है बच्चों के अधिकार इंश्योर करने के लिए। ओवरऑल इसमें 54 राइट्स हैं। और वैसे ही जो जो सदस्य देश हैं जिन्होंने इसको इस एग्रीमेंट को माना है, वो अपने यहाँ पे जस का तस इसको लागू करेंगे और इस कन्वेंशन को गति देने के लिए अपने यहाँ के नीति नियम कार्यक्रम को भी ऐसे बनाएंगे कि वो बच्चों के संदर्भ में या बच्चों के अधिकारों को प्रमुखता से सामने ला सके। अब जब हम कहते हैं कि इसमें 54 आर्टिकल्स हैं, वो 54 आर्टिकल्स को भी मतलब जब हम अधिकारों की बात करेंगे तो उनको 4 मेजर राइट्स में उसको कन्वर्ट किया गया है। तो जो 4 मेजर राइट्स हैं उसमें से एक राइट है राइट टू सर्वाइवल। हम में से बहुत सारे साथियों, आपके साथ ये प्रक्रियाएं कई बार हुई हैं, BSSS कॉलेज में भी हुई है, तो आप सब जानते ही हैं इसको, लेकिन फिर भी आज हम दोहरा लेते हैं इसको कि जब हम राइट टू सर्वाइवल की बात करते हैं तो कई बार हम बहुत जल्दी में इसको राइट टू लाइफ के साथ देख लेते हैं, यानी जीवन का अधिकार की बात कर लेते हैं। लेकिन दरअसल ये थोड़ी और इतर बात है, ये राइट टू सर्वाइवल की है, यानी उत्तरजीविता जिसको हिंदी में कहते हैं, उसके अधिकार की बात है। यानी बच्चे के जन्म के पहले से इसमें काम होना शुरू हो, और बच्चे का जब जन्म हो तब हम उसको बेहतर स्वास्थ्य की स्थितियां दे सकें, बच्चे का जन्म सुरक्षित तरीके से हो सके, और बच्चा यहाँ जन्म लेने के बाद जिंदा रह सके, यानी उसको ऐसी परिस्थितियां दी जा सके, उसके सामने ऐसे अवसर उसके सामने हो ताकि बच्चा यहाँ पर जीवित रह सके। और उसको फिर जब जीवित है बच्चे के साथ न्यूट्रिशन यानी उसके पोषण के संदर्भ में बातचीत हो, उसको आवास, उसका शेल्टर के संदर्भ में बातचीत हो, और एक सामान्य व्यक्ति के लिए जो लिविंग स्टैंडर्ड है वो लिविंग स्टैंडर्ड और उसमें मेडिकल सर्विसेज के प्रति उसकी पहुंच। अभी मैंने जब सीडा की बातचीत की थी तब हमने हॉस्पिटल्स की या मेडिकल सर्विसेज की बात की थी, तो हम ये नहीं कह रहे हैं कि मेडिकल सर्विसेज हैं कि नहीं, हम ये कह रहे हैं कि मेडिकल सर्विसेज तक इस समुदाय की या इस बच्चे की पहुंच है कि नहीं। या अब चूंकि बच्चे की पहुंच की जब हम बात कर रहे हैं तो हम इसमें बच्चा खुद तो चलकर, शायद 1 साल या 2 साल के बच्चे की बात करें तो बच्चा खुद चलकर हॉस्पिटल नहीं जा सकता, लेकिन उस समुदाय की या उनके माता पिता की उस फैसिलिटी तक पहुंच है कि नहीं, वो सब राइट टू सर्वाइवल के अंतर्गत आएंगे। ये जीविता का अधिकार है, इसी अधिकार के साथ इसमें समाहित किया गया है। और इसलिए अभी आप यदि देखें कि हम सरल भाषा में समझने की कोशिश करें तो हम लोग आसपास, आप में से बहुत सारे साथी ऐसे होंगे जो रूरल एक्सपोजर पर जब जाते हैं, आप में से सब साथियों ने आंगनवाड़ी जरूर देखी होगी, हालांकि वो अर्बन सेटअप में भी है, रूरल में भी है। और आंगनवाड़ी में आप देखेंगे कि हम किस उम्र के बच्चों के साथ काम करते हैं आंगनवाड़ी में। तो आप देखेंगे कि हम वहां पर चलताऊ भाषा में कहते हैं 0 to 6 के साथ काम करते हैं या 0 to 5 के साथ काम करते हैं, लेकिन ये 0 शब्द मीन्स व्हाट, यानी जन्म के पहले की स्थितियां भी हम ऐसी बनाने की बात करते हैं ताकि बच्चा बेहतर तरीके से स्वस्थ बच्चा जन्म ले सके। और इसलिए आप देखेंगे आंगनवाड़ी में जिस वर्ग के साथ हम काम करते हैं वो एडोलसेंट एज का वर्ग है, यानी 14-12 साल या मतलब 12 से लेकर 13 से लेकर 19 तक की जो एडोलसेंट गर्ल्स हैं उनके साथ भी इस पूरी प्रोसेस में काम किया जाता है। क्योंकि यदि ये बालिकाएं सुपोषित होंगी, ये मालनरिश नहीं होंगी, ये न्यूट्रिशन के साथ होंगी, तो ये कल को जब माँ बनेंगी तब ये बेहतर बच्चे को, स्वस्थ बच्चे को जन्म दे सकेंगी, क्योंकि माँ के साथ बच्चे का जीवन भी जुड़ा हुआ है। तो जब हम सर्वाइवल को समझने की बात करते हैं तो इसका मतलब हम बच्चे के जन्म के पहले की परिस्थितियां भी ऐसी बनाने की बात करते हैं ताकि बच्चा बेहतर स्थिति में जन्म ले सके, स्वस्थ बच्चा जन्म ले सके, वो कुपोषित ना हो, उसको किसी तरह की कोई विकार के साथ ना आए, और फिर जब वो आ गया तो फिर उसके साथ किस किस तरह की स्थितियां वो मैंने आपसे शेयर की। तो पहला राइट तो हमारे सामने सबसे पहला ये है, जैसे मैंने कहा कि 4 मेजर राइट्स में डिफाइन किया गया, तो पहला है राइट टू सर्वाइवल। सेकेंड इज राइट टू डेवलपमेंट। अब राइट टू डेवलपमेंट में क्या है? राइट टू डेवलपमेंट में शिक्षा का अधिकार। सबसे पहले तो हम ये भी करें कि बच्चे को अपने अधिकारों का ज्ञान भी हो सके। जैसे आप में और मैं, मेरी वाली जो पीढ़ी और आपकी वाली पीढ़ी है, उसमें से शायद अभी हम जाकर इस तरीके के अधिकारों की बातचीत कर रहे हैं जब हम एडल्ट हो चुके हैं। जबकि बात ये होनी चाहिए कि जिस उम्र में बच्चे हैं, बच्चों को ये अधिकार पता होना चाहिए कि मेरे ये अधिकार हैं और इनको मैं ऐसे ऐसे एंजॉय कर सकता हूं, और इस अधिकारों को एंजॉय कराने के लिए, इन अधिकारों को पूरा करने के लिए सरकार और समाज की यह जिम्मेदारी है। अभी हमारे यहाँ इतर बात है, अभी हमारे यहाँ पर, अभी हम एडल्ट इसको समझ रहे हैं, अभी बच्चों तक तो बहुत दूर तक ये चीजें नहीं पहुंची हैं, लेकिन समय है, शायद अगले 10 सालों में, शायद पाठ्यक्रमों में, अभी हम लोग मध्य प्रदेश सरकार के लिए एक पाठ्यक्रम लिख रहे हैं, बाल अधिकार संरक्षण आयोग की पहल हुई है तो वो लिख ही रहे हैं, उसमें हम लोगों ने ऑलरेडी इस तरह के पाठ डिजाइन करना शुरू किए हैं कि बच्चे अपने अधिकारों को कैसे समझ सकें। तो ये कवायद चल रही है, शायद अगले 10 सालों में ये बच्चों के पास भी होगा। लेकिन तो एक तो इसमें शिक्षा का अधिकार है, बच्चों को खेल का भी मौका मिल सके, और जब हम खेल की बात करते हैं तो अगला जो सत्र आएगा हमारा जिस पर हम बातचीत करेंगे उसमें चाइल्ड लेबर भी है, यानी हर बच्चे को खेलने का अधिकार है। ऐसा नहीं कि कुछ बच्चों को अपना बचपन छोड़कर उनको काम में लग जाना पड़े, उनको अपनी कल्चरल एक्सप्रेशंस भी व्यक्त करने का अधिकार है। अलग अलग समुदाय हमारे यहाँ देखिए, हमारे यहाँ आदिवासी समुदाय, हमारे यहाँ दलित समुदाय अलग हैं, अलग तरीके के समुदाय हैं, और हर समुदाय का अलग अलग अपना कल्चरल एक्सप्रेशन है। ये कल्चरल एक्सप्रेशन अलग अलग स्थानों के आधार पर भी बदल जाता है। बुंदेलखंड का कल्चरल एक्सप्रेशन अलग है, बघेलखंड का अलग है, जिस क्षेत्र में भोपाल में हम बैठे हैं यहाँ का अलग है, यहाँ की भोपाल की तहजीब अलग है, टंग अलग है। ये जो सारे कल्चरल एक्सप्रेशन है, इसको बच्चे समझ सकें और अपने कल्चरल एक्सप्रेशन को उनको सामने लाने के मौके भी मिल सके, और इंफॉर्मेशन तक उनकी एक्सेस हो, किसी भी तरह की इंफॉर्मेशन तक एक्सेस हो, ताकि बच्चे फिर बाद में अपनी राय बना सके उस इंफॉर्मेशन के आधार पर, और उनको सोचने समझने की स्वतंत्रता हो। और ये सब राइट टू डेवलपमेंट के अंतर्गत आता है। और तीसरा है राइट टू पार्टिसिपेशन। राइट टू पार्टिसिपेशन में यह है कि जहां पर एक तो बच्चों को किसी भी तरह की उपेक्षा का सामना ना करना पड़े, और जहां जहां पर बच्चों के संबंध में निर्णय लिए जा रहे हैं, चाहे वो घर हो, चाहे वो स्कूल हो, चाहे वो कॉलेज हो, यानी जब 16-18 साल से नीचे के बच्चे हैं तब, और चाहे देश में बन रहे कोई नीति, नियम या कानून हो, जहां जहां बच्चे के संदर्भ में बातचीत की जा रही है, वहां पर बच्चों की राय लिया जाना बहुत जरूरी है। अब देखिए, बच्चों की राय लिया जाना है, इसके साथ साथ जुड़कर एक और शब्द आता है या एक और समझ आती है, वो ये है कि बच्चों को सुना जाना। दरअसल हम एडल्ट्स की अभी तैयारी नहीं है कि हम बच्चों को सुन सकें। हम बच्चों को सुनते तो हैं, लेकिन हम बच्चों की बातों को गुनते नहीं है। हम सुनते हैं, निकाल देते हैं। लेकिन जब हम नीति, नियम या कार्यक्रमों में बच्चों की बात सुनने की बात कर रहे हैं, तो उसके बहुत व्यापक पैमाने हैं कि हम बच्चों की बातों को सुने और नीति, नियम, कायदे, कानूनों को उसमें समाहित कर सके, उनकी बातचीत को। ये बहुत कठिन है, लेकिन इसको किया जाना चाहिए और पार्टिसिपेशन एंश्योर करना है, तो ये करने की कवायद होनी चाहिए। फिलहाल हम जिस देश में हैं, अभी यहाँ पर पार्टिसिपेशन राइट्स पे ज्यादा बातचीत नहीं होती है, क्योंकि अभी आप और हम जितने भी युवा साथी इससे जुड़े हुए हैं, खासकर आप हम सब देखेंगे कि हम में से कई शायद ऐसे होंगे जिन्होंने अपनी पसंद का सब्जेक्ट नहीं चुन पाए, क्योंकि मेरे और आपकी माता पिता की आकांक्षाएं बहुत अलग थी। जैसे मेरे पिताजी मुझे इंजीनियरिंग बनाना चाहते थे, संयोग से मैं बन नहीं पाया। मैं अभी सोशल डेवलपमेंट में काम करता हूँ, लेकिन ऐसे अलग अलग निर्णय जो केवल उनकी पढ़ाई लिखाई से संदर्भित नहीं, पहनावे से संदर्भित नहीं है, कहाँ जाना है, किस तरीके की बातचीत करना नहीं करना, ये सबके निर्णय भी एडल्ट कई बार लेते हैं, और इस मान्यता के साथ लेते हैं कि बच्चे क्या जानेंगे। लेकिन यदि आप और मैं थोड़ा से उदाहरणों की तरफ चलें, तो यदि कोई बच्चा, जैसे हमारे यहाँ कहते हैं कि बच्चा जब रोता है तो माँ दूध पिला देती है, यानी वो बच्चा अपना एक स्पष्ट संदेश देता है अपनी माँ को कि मुझे भूख लगी है, और बच्चा दूध पिला देता है। यानी उसकी उम्र के अनुरूप उसको जितने चीजें पता होनी चाहिए वो उस बच्चे को पता है, और उसके आधार पर वो अपना पार्टिसिपेशन वहां इंश्योर करता है। तो ये समझ कि बच्चे को अपनी उम्र अनुरूप चीजें पता हैं, लेकिन हम उनसे पूछेंगे तो अपनी उम्र अनुरूप हमारे सामने चीजें रखेंगे। और बच्चों की राय सुना जाना का मतलब ये नहीं है कि बच्चों की जो बच्चों ने कहा उसको मान लेना, बल्कि उनके सामने कई सारे ऐसे विकल्प रखना कि देखिए, यदि ये होता है तो ऐसा ऐसा होता है, ये होगा तो ऐसा होगा, ये होगा तो ऐसा होगा, ताकि बच्चा उन विकल्पों में से एक विकल्प को चुन भी सके और अपनी बात भी रख सके, और उसकी बात को हम सुन सके। दिस इज राइट टू पार्टिसिपेशन। और जब मैं हर बार एक उदाहरण देता हूं कि यदि आप देखें कि जब हम कहते हैं कल्चरल एक्सप्रेशंस करना है, उसको बच्चे को सामने लाना, बच्चे अपनी बातचीत रख सके, तो हम ये भी देखते हैं कि जैसे मैं स्कूल का एक उदाहरण देता हूं कि स्कूल में आप देखेंगे कि पोडियम कितने लोगों के पास होता है। पोडियम की एक्सेस किसके पास होती है? पोडियम की एक्सेस प्रिंसिपल महोदय के पास होगी, टीचर्स के पास होगी। वो बाकायदा ऐसा हाथ रखकर बहुत कॉन्फिडेंस के साथ अपनी बात कहते हैं। लेकिन हम और आपने कितने स्कूल ऐसे देखे हैं जिस स्कूल में बच्चों के लिए भी पोडियम है? यदि किसी टीचर को इस तरीके से पोडियम पे हाथ रख के बातचीत करने में कॉन्फिडेंस आता है, तो हम कैसे कल्पना करते हैं कि उस बच्चे को भी कॉन्फिडेंस आ जाएगा विदाउट पोडियम? वो कभी माइक सेट करता रहता है, कभी इस तरह से ऊपर मुंह करके बोलेगा, कभी नीचे मुंह करके बोलेगा। सो ये बहुत सामान्य उदाहरण है, लेकिन हम इस तरीके से पार्टिसिपेशन इंश्योर नहीं करते। और ऐसे में ऐसे बच्चे जो किसी भी तरह की अलग तरीके की क्षमता वाले हैं, यानी जिसको डिफरेंटली एबल्ड बच्चे कहे जाते हैं, हम उनको भी इस पूरी पार्टिसिपेशन की प्रक्रिया से बाहर कर देते हैं। जब हम स्कूलों में रैंप नहीं बनाते हैं, क्योंकि यदि वो बच्चे की एक्सेस ही नहीं उस स्कूल में, तो हम उसका पार्टिसिपेशन कैसे उस स्कूल में एंश्योर कर पाएंगे? तो ये तमाम चीजें राइट टू पार्टिसिपेशन के साथ है। फोर्थ राइट इज राइट टू, सॉरी दोनों में पार्टिसिपेशन लिखा है। फोर्थ राइट इज राइट टू प्रोटेक्शन। और राइट टू प्रोटेक्शन में हम सब जानते ही हैं कि बच्चे को हर तरीके के उसके साथ होने वाले जो हर तरीके के शोषण से उसको मुक्ति मिल सके, उसके साथ उपेक्षा ना हो, उसके साथ क्रूरता ना हो किसी भी तरीके की। और ये जब हम प्रोटेक्शन की बात कर रहे हैं, तो हम केवल सुरक्षा की बात नहीं कर रहे हैं, हम राइट टू सेफ्टी की बात नहीं कर रहे हैं, राइट टू सिक्योरिटी की बात नहीं कर रहे हैं। हम राइट टू प्रोटेक्शन का मतलब ये है कि बच्चों को तरह तरह के ये जो शोषण है उससे तो मुक्ति मिले ही, वो उसका शोषण ना हो, बल्कि ये जो पूरे नीति नियम कायदे कानून में व्यवस्थाएं भी ऐसी की जाएं कि बच्चा अपने आप को प्रोटेक्टेड फील कर सके। और जो व्यवस्थाएं की जाएं उसमें भी प्रावधान ऐसे किए जाएं कि बच्चे को प्रोटेक्टेड होने का भाव हर समय रहे। जैसे जब हम कहते हैं पुलिस, तो पुलिस के साथ जब हम डील करते हैं, तो पुलिस भी बच्चों के साथ ऐसे डील करेगी कि बच्चा अपने आप को प्रोटेक्टेड फील करेगा, ना कि किसी क्रिमिनल की तरह उस बच्चे के साथ डील करेगी। तो यानी ये जो स्ट्रक्चर्स हैं वो स्ट्रक्चर्स भी इस तरीके से डिफाइन किए जाएं कि वो बच्चे को प्रोटेक्शन दे सकें, सिक्योरिटी और सिक्योरिटी के अलावा। तो वो एक राइट टू प्रोटेक्शन का एक पूरा भाव है। तो ये 4 मेजर राइट्स हैं, राइट टू सर्वाइवल, राइट टू डेवलपमेंट, राइट टू पार्टिसिपेशन एंड राइट टू प्रोटेक्शन। अब इस यूएनसीआरसी में कुछ गाइडिंग प्रिंसिपल्स भी हैं, जो प्रिंसिपल्स इस बात की तरफ इशारा करते हैं कि बच्चे को हम कैसे देखें। तो एक तो जब मैं कह रहा था कि पूरी दुनिया के स्तर पर ये बहस चल रही थी कि हम किस व्यक्ति को बच्चा माने, तो इसने कहा कि हम अब दुनिया में हर उस व्यक्ति को बच्चा मानेंगे, इस संधि ने कहा, जिसकी उम्र 18 साल से कम है। तो एक तो ये। दूसरा, राइट टू लाइफ, सर्वाइवल और डेवलपमेंट की हमने बात की। एक और चीज कही गई है कि जब भी बच्चों के संदर्भ में फैसले लिए जाए, जब भी बच्चों के संबंध में बातचीत की जाए, वो है बेस्ट इंटरेस्ट ऑफ द चाइल्ड। यानी जितने भी मौजूदा विकल्प हैं उसके सामने, उसमें से जो बेस्ट विकल्प है वो बच्चे के लिए चुना जाए और वो बच्चे को उस विकल्प तक पहुंचने में मदद की जाए जो विकल्प हमारे पास मौजूद है। किसी भी स्तर पर किसी भी बच्चे के साथ भेदभाव नहीं होगा। यानी ऐसा नहीं हो सकता है कि राइट टू सर्वाइवल वाला जो मसला है वो इस तरह के समुदाय के बच्चों के लिए तो होगा लेकिन इन बच्चों के लिए नहीं होगा। वो सभी के लिए गैर भेदभाव के साथ उसको दिया जाए। और रिस्पेक्ट फॉर द व्यूज ऑफ द चाइल्ड, जिसकी बातचीत अभी मैंने पार्टिसिपेशन के समय की, कि बच्चों के जो व्यूज हैं उनका आदर करना भी, उनको सुनना, उसको आदर करना, उसको समझना, ये सब भी गाइडिंग प्रिंसिपल्स के साथ हैं। क्योंकि नहीं तो यदि हम गाइडिंग प्रिंसिपल्स को नहीं देखते हैं तो फिर हमारी आदतें भी आप देखेंगे। और खासकर जब हम देखने की बात कर रहे हैं तो इसमें हम देशों की बात कर रहे हैं। तो फिर अब जब नीतियां बनेंगी, नियम बनेंगे, कानून बनेंगे, तो बच्चों से राय मशवरा भी किया जाएगा और उनके जो व्यूज हैं उनको रिस्पेक्ट भी किया जाएगा। इसलिए आप देखेंगे अब जहां कहीं भी बच्चों के संबंध में गोष्ठियां होती हैं वहां बच्चे अपनी बात जरूर रखते हैं या बच्चों को बात रखने के लिए प्रेरित किया जाता है, क्योंकि हम उनकी नजर से वो चीजों को समझ सकें जो बच्चों के लिए चल रही है। अब इसमें भी ऑप्शनल प्रोटोकॉल है। जैसे मैंने कहा कि कन्वेंशन के समय बहुत सारी चीजें हो सकता है छूट जाती हैं, तो ऑप्शनल प्रोटोकॉल भी आए हैं। हाँ, मैंने एक बात का जिक्र करना भूल गया हूँ, माफी चाहता हूँ, कि जब हमने कन्वेंशन को साइन किया तो जैसे हमने सीडा की जब बात की तो सीडा में 16 आर्टिकल्स को ही के साथ हमने उसको रेटिफाई किया है। वैसे ही जब हमने यूएनसीआरसी को साइन किया, यानी भारत देश ने जब यूएनसीआरसी को रेटिफाई किया है, तब हमने आर्टिकल 32 पर को शिथिलता देते हुए बाकी कन्वेंशन के साथ हमने साइन किया। आर्टिकल 32 कहता है कि हमारे देश से बाल मजदूरी की जड़ से समाप्ति। अभी हम इस स्थिति में नहीं है, भारत सरकार ने ऐसा माना है कि अभी हम इस स्थिति में नहीं है कि बाल मजदूरी की जड़ से समाप्ति कर लें, इसलिए आर्टिकल 32 को शिथिलता देते हुए हमने बाकी पूरे उसको मान्य किया है। अब इसमें ऑप्शनल प्रोटोकॉल क्या थे कि बच्चों के सेल ऑफ चिल्ड्रन, चाइल्ड प्रोस्टिट्यूशन, चाइल्ड पोर्नोग्राफी के संदर्भ में एक ऑप्शनल प्रोटोकॉल आया है। एक ऑप्शनल प्रोटोकॉल और आया है कि इन्वॉल्वमेंट ऑफ चिल्ड्रन इन आर्म कॉन्फ्लिक्ट। हमारे यहाँ पर बहुत अलग अलग जगहों पर आप देखेंगे आर्म कॉन्फ्लिक्ट चल रहा है और उसमें बच्चों का बड़े पैमाने पर इस्तेमाल किया जाता है, बाल सेना के रूप में बच्चों को शामिल किया जाता है और फिर बच्चों का वहां पे अलग अलग तरीके से शोषण होता है। वैसे ये कम्युनिकेशन प्रोसीजर के संदर्भ में ऑप्शनल प्रोटोकॉल आया है। सो ये कुछ ऑप्शनल प्रोटोकॉल हैं इस कन्वेंशन के संदर्भ में। लेकिन जैसे हमने सीडा की बात की कि जब सीडा आया तो सीडा के आने के बाद, सीडा हालांकि सीडा इसके 10 साल पहले आया हुआ कन्वेंशन है और उसको 93 में हमने बाद में रेटिफाई किया इस कन्वेंशन के बाद। लेकिन इसके बाद इंडिया में क्या चीजें बदली, क्या हमने यूएनसीआरसी को साइन करने के बाद जो हमारी लीगल बाइंडिंग्स थी कि हमको ये करना है, इसमें भी पीरियडिकल रिपोर्ट सरकार को प्रस्तुत करनी होती है। सो उसके बाद हमने क्या क्या किया, क्या हमने वास्तव में कोई मेजर्स ऐसे लिए हैं कि जो बच्चों के अधिकारों को एड्रेस करने के संदर्भ में हैं। तो बहुत सारे कानून इस दौर में ऐसे आए हैं जिसमें बच्चों के अलग अलग अधिकारों को अलग अलग तरीके से एड्रेस किया गया है, जिसमें मैंने कुछ अधिकार या कुछ बातचीत का जिक्र किया जिनको आप लोग भी ज्यादा बेहतर तरीके से समझते हैं। राइट टू फ्री एंड कंपल्सरी एजुकेशन एक्ट है 2009 का, हम सब जानते ही हैं। जुवेनाइल जस्टिस एक्ट है 2015 का, इसके पहले भी 2000 में भी आ चुका है, 2006 में इसमें अमेंडमेंट भी हुआ था और 2015 में एक नए कलेवर के साथ ये एक्ट फिर से हमारे सामने आया है। और जुवेनाइल जस्टिस एक्ट ने बताया कि हम सीएनसीपी बच्चे यानी चिल्ड्रन इन नीड ऑफ केयर एंड प्रोटेक्शन के जो बच्चे हैं उनको हम कैसे देखेंगे, और ऐसे बच्चे जो चिल्ड्रन इन नीड और जुवेनाइल इन कॉन्फ्लिक्ट विद लॉ, ऐसे बच्चे जिन्होंने किसी भी रूप में कानून का उल्लंघन कर दिया है हो सकता है चोरी कर दी, हो सकता है किसी को ब्लेड मार दिया, हो सकता है किसी गिरोह के साथ रहकर किसी वारदात को अंजाम दे दिया। इस तरह की किसी भी स्थिति में यदि कोई बच्चा शामिल हुआ है तो उसके साथ हम किस तरह की प्रक्रिया करेंगे? क्या हम उस बच्चे को एडल्ट क्रिमिनल की तरह मानते हुए जेलों में डालेंगे या क्या प्रक्रिया करेंगे? ये सब चीजें हमने की हैं। हालांकि यदि आप सब साथी हमारे यहाँ पर हिस्ट्री ऑफ सोशल वर्क पढ़ते हैं, हिस्ट्री ऑफ चाइल्ड राइट्स पढ़ते ही हैं, तो आप देखेंगे कि उसमें 1919 में हमारे यहाँ पर जेल कमेटी आई थी इंडिया में, यानी लगभग आज से 103 साल पहले। और 103 साल पहले भारत देश ने कहा था कि हम एडल्ट्स को बच्चों के साथ अलग अलग, मतलब उस समय जेल थी, अलग अलग जेलों में रखें ताकि बच्चे एडल्ट क्रिमिनल के साथ प्रभावित होते हुए इस तरह की क्रिमिनल एक्टिविटीज में ज्यादा संलग्न ना हो जाए। बहरहाल अभी जो यूएनसीआरसी के बाद जो कानून बन रहा है उसमें बहुत स्पष्ट रूप से बच्चों के साथ अलग अलग तरीके के प्रावधान किए गए। उसके लिए जुवेनाइल जस्टिस एक्ट है, इसमें सीडब्ल्यूसी है, जेजेबी है, और कैसे दोनों तरह के बच्चों के साथ डील किया जाएगा, किस तरह के स्ट्रक्चर्स हमारे पास मौजूद हैं, वो सब इसमें डिफाइन किया है। वैसे आप देखेंगे चाइल्ड मैरिज एक्ट है, और चाइल्ड मैरिज एक्ट 1929 में पहली बार आया, लेकिन 2006 में और बीच में भी अमेंडमेंट हुआ, 2006 में भी इसमें अमेंडमेंट हुआ, और वो यूएनसीआरसी के बाद थोड़ा और प्रभावी होकर आया, जिसमें 18 साल से कम उम्र की बालिका और 21 साल से कम उम्र के बालक का विवाह कानूनन विवाह के रूप में मान्य नहीं है, उसको बाल विवाह की संज्ञा दी गई। पॉक्सो कानून का जिक्र मैंने आपसे सीडा के समय किया ही है कि किसी भी बच्चे 18 साल से कम उम्र के किसी भी बच्चे के साथ, चाहे वो लड़का लड़की या अन्य कैटेगरी का हो, किसी द्वारा यदि सेक्सुअल वायलेंस किया जाता है तो उसके लिए अब हमारे देश में एक स्पेसिफिक एक्ट है, दैट इज कॉल्ड प्रोटेक्शन ऑफ चिल्ड्रन फ्रॉम सेक्सुअल ऑफेंसेस एक्ट 2012। चाइल्ड लेबर एक्ट पे थोड़ी अभी हम और बातचीत करेंगे। इसमें 1986 का एक एक्ट है, इसमें संशोधन हुए हैं, अभी 2016 में भी इसमें अलग से संशोधन हुए हैं, वो भी हैं। ऐसे इंडिया ने यूएनसीआरसी आने के बाद बहुत अलग अलग मेजर्स लिए हैं, अलग अलग कानून हमारे सामने आए हैं, और उन कानूनों का, कुछ कानून का जिक्र मैंने किया, वैसे कुछ पॉलिसीज है हमारे पास। नेशनल चिल्ड्रन पॉलिसी है हमारे पास, अभी एनसीपी आई है, नेशनल एजुकेशन पॉलिसी आई है। तो ऐसी अलग अलग पॉलिसीज हैं, अलग अलग प्रोग्राम्स हैं। आईसीडीएस का प्रोग्राम हमारे पास पहले से चल रहा है 1975 से, जिसको हम आंगनवाड़ी के रूप में बहुत सरलता से जानते हैं। यूएनसीआरसी आने के पहले से भी कुछ मेजर्स थे, लेकिन उसके बाद भी बहुत सारे मेजर्स लिए गए हैं। एक हमने सीडा को देखा, सीडा के बाद इंडिया ने क्या क्या प्रगति की, वैसे ही हम यूएनसीआरसी की बात देखते हैं तो इंडिया ने बहुत सारे अलग अलग कानून लाए। मैंने कुछ कानूनों का यहाँ जिक्र किया है, बहुत अलग अलग कानून लाए हैं, और बच्चों की प्रगति के संदर्भ में वो बहुत हद तक प्रोसेस करी जा रहे हैं, बहुत हद तक प्रोसेस की जा रही है, और प्रोसेसेस बढ़ भी रही है। चूंकि वक्त की सीमा है तो मैं इसे यही विराम दे रहा हूँ इस वाले सत्र को, और अब तीसरा और अंतिम मेरे हिस्से का जो सत्र है उस पर मैं थोड़ा आगे बढ़ूंगा, लेकिन इसको 1 मिनट समाप्त करता हूँ। यूएन जैसे हमारे यहाँ से यूनाइटेड सीडा आया, जैसे हमारे यहाँ पर हमने अभी यूएनसीआरसी की बातचीत की, और यूएनसीआरसी में किस तरह के प्रावधान हैं, कैसे इंडिया ने उसके बाद अपने आप को रखा है, इसके अपने प्रोटोकॉल कैसे हैं, बच्चों के अधिकारों को।
हेलो सुष्मिता मैम,
आपका माइक चालू।
मैम आपका माइक चालू है।
सॉरी।
ओके,
थैंक यू मैम,
थैंक यू। हमने देखा कि यूएनसीआरसी में किस तरह से राइट्स को डिफाइन किया गया है। 54 आर्टिकल्स इसमें हैं, लेकिन जो बच्चों के अधिकारों के संदर्भ की बातचीत है, उनको 4 मेजर राइट्स में कैसे डिफाइन किया गया है: राइट टू सर्वाइवल, राइट टू डेवलपमेंट, राइट टू पार्टिसिपेशन एंड राइट टू प्रोटेक्शन। ये 4, और कैसे इसमें भी पीरियोडिकल रिपोर्ट्स कैसे जाती है, और इंडिया ने कैसे बताया है कि जब हम इस यूएनसीआरसी के कन्वेंशन को हमने रेटिफाई किया है, उसके बाद हमने कैसे अपने देश में बच्चों के अधिकारों को तवज्जो देते हुए कैसे कैसे अलग अलग तरह के कानून, कार्यक्रम, नीति, नियम लेकर आए। ये थोड़ी यूएनसीआरसी के संदर्भ में बातचीत है। और अब मैं अपनी एक अंतिम बातचीत, हालांकि डॉक्टर सुष्मिता जुड़ गई हैं, और मैं लेकिन 15 मिनट है मेरे पास, मैं थोड़ा 15 मिनट में चाइल्ड लेबर एक्ट के संदर्भ में जो मोटी मोटी बातें हैं वो आपके सामने रख देता हूं। आप स्क्रीन देख पा रहे हैं क्या अभी?
जी सर।
जी, चाइल्ड लेबर एक्ट वाली स्क्रीन दिख रही है क्या आपको? नो
Yes, sir. वो first
एक मिनट फिर से रुकिए। तो चूंकि 10 मिनट है तो मैं थोड़ा मोटी मोटी बातें इसमें आपको शेयर कर देता हूँ। एक तो ये है कि इस कानून के अंतर्गत, ये कानून भी देखिए यूएनसीआरसी के आने के बाद से इसमें बहुत संशोधन हुए और इस कानून में अभी 2-3 तरीके से बच्चों को डिफाइन किया गया है। एक तो ये कहा गया है कि इस कानून में 14 वर्ष से नीचे के जो बच्चे हैं, 14 वर्ष से नीचे के जो व्यक्ति हैं उनको बच्चे की श्रेणी दी गई है और 14 वर्ष से ऊपर और 14 वर्ष से ऊपर लेकिन 18 साल से कम उम्र के जो व्यक्ति हैं उनको किशोर की संज्ञा दी गई है। तो इसमें 2 अलग अलग तरीके से फिर स्थितियां भी बनी हैं कि 14 साल से नीचे के बच्चा इस कानून के अंतर्गत कहीं पर भी काम नहीं कर सकता, कहीं पर भी, यानी कहीं पर भी वो बच्चा कहीं काम नहीं कर सकेगा। और 14 साल से ऊपर और 18 साल से कम उम्र का जो बच्चा उसको एडोलसेंट या किशोर के रूप में यहाँ पर माना गया है। तो वो बच्चा काम कर सकता है लेकिन उसके साथ सर्टेन कंडीशंस हैं और वो बच्चा ऐसी परिस्थितियों में काम नहीं कर सकता जहां पर खतरनाक उद्योग जिनको डिफाइन किया गया है या ऐसी जगह पर है जो बच्चों के लिए खतरनाक स्थितियों में है, वहां पर बच्चा काम नहीं कर सकता है, जिनको किशोर कहा गया 14 साल से ऊपर और 18 साल से कम। लेकिन इंटरेस्टिंग बात यह है कि 14 साल से नीचे का बच्चा जहां कहीं काम नहीं कर सकता है उसको ये भी कहा गया है कि 14 साल से नीचे का बच्चा अपने पारिवारिक उद्यम यानी फैमिली इंटरप्राइजेज या फैमिली का जो बिजनेस है उसमें हाथ बटा सकता है। अब लेकिन वो कैसे हाथ बटा सकता है और इसमें फैमिली को कैसे डिफाइन किया गया, ये थोड़ा ट्रिकी है इसको समझना, लेकिन फिर भी हम थोड़े बातचीत करते हैं। मैं एक बार फिर से इस कानून की बारीकियां आपसे दोहराता हूं। इसमें 14 साल से कम उम्र का बच्चा कहीं भी काम नहीं कर सकता है, कहीं भी यानी कहीं भी। लेकिन उसमें यह भी कहा गया है कि इस कानून के अंतर्गत बच्चा अपने पारिवारिक व्यवसाय में हाथ बटा सकता है अपने माता पिता का या अपने उस, और उसमें परिवार को डिफाइन किया गया है माँ, पिता, भाई बहन और माँ के भाई बहन और पिता के भाई बहन। इस फैमिली को एक्सटेंडेड फैमिली माना गया है इस कानून के अंतर्गत। यानी यदि बच्चा अपने मामा की किसी शॉप पर भी यदि काम में हाथ बटाता है तो उसको चाइल्ड लेबर की कैटेगरी में नहीं देखा जाएगा। यदि हम भोपाल के संदर्भ में देखें और पुराने भोपाल की तरफ देखें तो बहुत सारे गैरेजेस हैं जिसमें मामा की कोई गैरेज है, चाचा की कोई गैरेज है, चाचू की गैरेज है, मामू की कोई गैरेज है और उसमें बच्चा यदि काम में हाथ बटा रहा है तो वो चाइल्ड लेबर की कैटेगरी में नहीं होगा, बशर्ते कि बच्चा स्कूल जाता है, बच्चा स्कूल में एनरोल्ड है और स्कूल जाने के पहले के घंटे और स्कूल से लौट के बाद के घंटों में वो बच्चा यदि अपने पारिवारिक उद्यम में कहीं हाथ बटाता है तो वो चाइल्ड लेबर की कैटेगरी में नहीं है। मैं फिर दोहरा देता हूं, ऐसा बच्चा जिसकी उम्र 14 साल से कम है उसको इस कानून में बच्चा कहा गया। बच्चा कहीं काम नहीं कर सकता है, अपने पारिवारिक उद्यम में वो हाथ बटा सकता है और पारिवारिक परिवार को इस कानून में डिफाइन किया गया माँ, पिता, भाई बहन और माँ के भाई बहन और पिता के भाई बहन। यानी इस विस्तारित परिवार के उद्यम में कहीं पर बच्चा यदि काम में हाथ बटाता है, ये स्कूल जाने से पहले के घंटे, स्कूल से आने के बाद के घंटों में, एक दिन में 6 घंटे से ज्यादा नहीं, तो वो कानूनन चाइल्ड लेबर की श्रेणी में नहीं होगा। दूसरा, 14 साल से 18 साल के बीच के बच्चे अभी किशोर के रूप में परिभाषित किए गए हैं, वो एडोलसेंट एज के रूप में है। तो 14 वर्ष से ऊपर के बच्चे और 18 साल से कम उम्र के बच्चे कहीं भी काम कर सकते हैं, लेकिन ऐसी स्थितियों में काम नहीं कर सकते जिनको पर खतरनाक उद्योग है, जैसे कांच की काम यहाँ पर होता है, कांच बनाने का काम यहाँ होता है, या कांच का कटिंग वाला जो काम होता है, या फिर ऐसे उद्योग जहां पर फास्फोरस का काम किया जाता है, यानी पटाखा इंडस्ट्रीज जहां पर है वहां पर नहीं, वो या मैच बॉक्स बनाने वाली जो स्थितियां हैं वहां पर बच्चे काम नहीं कर सकते हैं। और इसमें भी ये कहा गया है कि जो मिनिमम वेजेस एक्ट के अंतर्गत एक शेड्यूल दिया गया, वो शेड्यूल को जितना शेड्यूल में जहां पर वो शेड्यूल में जिन जिन प्रक्रियाओं को निरुद्ध किया गया है वहां पर ये बच्चे काम नहीं कर सकते हैं। लेकिन ये बच्चे भी जो किशोर काम कर रहे हैं वो शाम 7 बजे से लेकर सुबह के 8 बजे तक कहीं काम नहीं कर सकते हैं। एक समय में ये 3 घंटे काम करेंगे, उसके बाद इनको 1 घंटे आराम की सुविधा दी जानी चाहिए और फिर उसके बाद फिर बच्चे 3 घंटे काम कर सकते हैं। तो ऐसा नहीं है कि 14 से 18 साल से ऊपर के बच्चे जहाँ काम करेंगे वहां पर उनके लिए कोई प्रतिबंध नहीं है। वहां पर मैं काम कराने वाले नियोक्ता पर कोई प्रतिबंध नहीं, नियोक्ता पर प्रतिबंध है कि बच्चे किसी भी स्थिति में 3 घंटे से ज्यादा काम नहीं कर सकते हैं। 3 घंटे से ज्यादा काम करेंगे तो उनको 1 घंटे का आराम दिया जाएगा, फिर 3 घंटे काम कर सकते हैं। लेकिन शाम 7 बजे से लेकर सुबह के 8 बजे तक बच्चे वहां पर भी काम नहीं कर सकते हैं। और यदि ऐसा कुछ करते हुए कहीं बच्चे पाए जाते हैं, यानी बच्चे यदि अपने 14 साल से नीचे के बच्चे अपने पारिवारिक उद्यम के अलावा कहीं पर काम करते हुए दिखते हैं तो वो चाइल्ड लेबर की कैटेगरी है। 14 से 18 साल के किशोर कहीं पर ऐसी जगह काम करते हुए दिखते हैं जहां पर खतरनाक उद्योग है तो वो चाइल्ड लेबर की कैटेगरी है। 14 से 18 साल के किशोर ऐसी स्थितियों में काम करते हैं जो कानून में डिफाइन नहीं की गई, जैसे शाम 7 बजे से लेकर सुबह के 8 बजे के बीच या 3-3 घंटे के बीच में उनको अंतराल ना मिलना, तो वो भी चाइल्ड लेबर की कैटेगरी में शामिल है। और इसमें जैसे मैंने कहा कि बच्चा किसे कहा गया, परिवार किसे कहा गया, वैसे ही पारिवारिक प्रतिष्ठान किसे कहा गया है। कोई भी काम, कोई भी व्यवसाय, कोई भी निर्माण इकाई जिसमें परिवार का कोई सदस्य भी यदि हाथ बटा रहा है तो बच्चा वहां पर भी हाथ बटा सकता है, ये भी कानून में कहा गया है। सो चाइल्ड लेबर को हम मोटे मोटे ऐसे देखें, चूंकि वक्त की सीमा है और मैं अपने समय से थोड़ा पीछे चल रहा हूँ, तो मैं इसको थोड़ा यही विराम दूंगा कि 14 साल से नीचे का बच्चा कहीं भी काम नहीं कर सकता है और वो अपने पारिवारिक उद्यम में हाथ बटा सकता है, बशर्ते कि बच्चा स्कूल जाता है और स्कूल जाने से पहले के घंटे और स्कूल से लौटने के बाद के घंटों में ये काम हाथ बटा सकता है। 14 से 18 वर्ष का बच्चा कहीं पर भी काम कर सकता है, केवल हैजार्डस इंडस्ट्रीज को छोड़कर, और वहां पर भी काम की स्थितियां जैसे डिफाइन मैंने की आपको कानून में वैसी डिफाइन की गई है कि 3 घंटे तक बच्चा काम करेगा, फिर 1 घंटे का आराम, फिर 3 घंटे बच्चा काम करेगा, लेकिन शाम 7 बजे से लेकर सुबह 8 बजे के बीच में बच्चा काम नहीं कर सकता है। फिर यदि ऐसे बच्चे कहीं हमको काम करते हुए दिखते हैं तो हम 10-9-8 पर सूचना दे सकते हैं, यानी चाइल्ड लाइन का नंबर BSSS नोडल है ही चाइल्ड लाइन के संदर्भ में, आप सब जानते ही हैं। तो BS इस तरह के कहीं पर भी 10-9-8 पर हम उल्टी गिनती जो है उस पर वो कर सकते हैं, इस फोन कर सकते हैं, सूचना दे सकते हैं। इसके अलावा पेंसिल नाम की एक वेबसाइट है, pencil.gov.in, ये पेन वाला पेंसिल है, pencil.gov.in, ये वाली वेबसाइट भी है। इस पर आप जाकर ऐसे कहीं पर जगह पर बच्चा कहीं काम कर रहा है तो उसकी सूचना दे सकते हैं। आप इस वेबसाइट के अंदर जैसे जाएंगे सामने लिखा आएगा, एक बॉक्स आता है कि यदि आप कोई कंप्लेंट रजिस्टर कराना चाहते हैं तो यहाँ रजिस्टर कराएं। और आप यदि कहीं से फोटो उसकी खींचते हैं, किसी बच्चे को कहीं काम करते हुए फोटो खींचते हैं, ये खींचना या नहीं खींचना आपकी स्थानीय परिस्थितियों पर निर्भर करेगा कि आप वहां की स्थितियों को देखकर आप तय करिए कि आपको खींचना है या नहीं खींचना है। यदि आप खींचते हैं पेंसिल वेबसाइट पर जाकर तो वो रियल लोकेशंस भी फोटो के साथ वहां पर ली जाती है और फिर जब कार्रवाई होती है तो उस लोकेशन के आधार पर अधिकारी उसमें कार्रवाई करते हैं और बच्चे को वहां से बाहर निकाला जाता है। एक स्थिति और है कि कोई भी बच्चा यदि कोई कला के क्षेत्र में है, जो कि गायन, कलाकार या खेल जगत में है, या कोई मनोरंजनात्मक गतिविधि में बच्चा शामिल है, खासकर हम चैनल्स के संदर्भ में देखें तो बच्चे वहां पर जब सारेगामा चल रहा है या कोई दूसरे तरह के कार्यक्रम चल रहा है उसमें बच्चे जब शामिल होते हैं सर्कस को छोड़कर, तो वहां पर बच्चों के संदर्भ में सुरक्षा मानकों का ख्याल रखा जाएगा ताकि बच्चे किसी भी तरीके से वहां प्रभावित ना हो। लेकिन उसको चाइल्ड लेबर की कैटेगरी में नहीं माना है। यदि सर्टेन कंडीशंस पूरी की गई हैं सुरक्षा मानकों के संदर्भ में तो बच्चे वहां पर एक निर्धारित समय तक वहां पर काम कर सकते हैं। इस कानून के अंतर्गत आप देखेंगे ये कॉग्निजिबल ऑफेंस है और इसमें यदि कहीं बच्चा काम करते हुए मिलता है तो नियोक्ता को कम से कम 6 माह से लेकर 2 साल तक की सजा हो सकती है और 20,000 से लेकर अधिकतम 50,000 रुपए तक का जुर्माना, या दोनों ही वहां पर लगाए मतलब उस व्यक्ति पर किए जा सकते हैं। ये कॉग्निजिबल ऑफेंस है और जैसे मैंने कहा 6 माह से लेकर 2 साल तक के सजा की जा सकती है। और जो खतरनाक उद्योग जिसका मैंने जिक्र किया कि माइनिंग जहाँ पर है, विस्फोटक बनाने वाली जो फैक्ट्रियां हैं, कठोर कामों के क्षेत्र हैं, और जो फैक्ट्री एक्ट 1948 है, सॉरी मैंने मिनिमम वेजेस एक्ट कह दिया था, फैक्ट्री एक्ट 1948 है, उसके अंतर्गत एक और सूची डिफाइन की गई। उस सूची के अंतर्गत जो जिनको हैजार्डस इंडस्ट्री डिफाइन की गई, वहां बच्चे काम नहीं कर सकते हैं। बाकी जगहों पर किशोर व्यक्ति काम कर सकते हैं। और बच्चे 14 साल से नीचे के बच्चे कहीं काम नहीं कर सकते हैं। सो चूंकि वक्त की सीमा है, 2:56 हो चुके हैं, इसलिए मैंने ये बात को अपने थोड़ा यहीं विराम दिया है और हमारी अगली वक्ता हमारे साथ जुड़ चुकी हैं। सो मैं अपनी बातचीत को अपनी तरफ से यहीं विराम दे रहा हूँ। हालांकि मेरे पास 3 विषय थे तो थोड़ा समय ज्यादा लग गया, लेकिन फिर भी यदि कोई एक दो सवाल यदि आप मित्रों के हैं तो आप रख दें, और नहीं तो मैं चैट बॉक्स में अपना मेल आईडी छोड़ देता हूँ और मेरा नंबर भी छोड़ देता हूँ, तो आप साथ ही उस पर मुझे मैसेज कर देंगे अपने सवाल, तो मैं बाद में भी कोशिश करूंगा कि आपके सवालों को ले सकूं और आपके सवालों का जवाब दे सकूं। बहुत बहुत धन्यवाद।
सर जी, मेरा सवाल ये है कि जैसे अपने सीडा में पढ़ा था कि वो वीमेंस की प्रोटेक्शन के लिए वन स्टॉप क्राइसिस हर जगह लगे, तो विद दैट अभी शेल्टर होम्स भी है। तो अपन ने अभी एक रीसेंट न्यूज सुना होगा आपने भी कि यूपी में जो बच्चे लोग हैं जो शेल्टर होम्स है, उनको जो है सेक्स के लिए लोग बेचते हैं, वहां पर मेंस आते हैं उनके साथ सेक्स करते हैं। तो अपन का क्या कॉन्सेप्ट है कि शेल्टर होम में बच्चे लोग सुरक्षित रहेंगे, महिला लोग सुरक्षित रहेंगे, बट वहां के जो वर्कर्स है बच्चे लोग को जो है गलत कामों में लगा रहे हैं। तो इसमें क्या कर सकते हैं अपन, क्या केसेस इनके ऊपर लग सकता है ऐसे शेल्टर होम्स में?
देखिए, किसी के खिलाफ भी यदि कहीं पर भी शेल्टर होम में बच्चों के साथ या कहीं पर भी बच्चों के साथ सेक्सुअल वायलेंस या इस तरह की स्थितियां बनती हैं तो उनके खिलाफ तो केस होगा ही। और शेल्टर होम, पहली बात तो मैं जेजे एक्ट का एक प्रिंसिपल का यहाँ इस्तेमाल करना चाहता हूँ। जेजे एक्ट कहता है, जुवेनाइल जस्टिस एक्ट कह रहा है कि बच्चों को हर समय हर संभव ये कोशिश किया जाना चाहिए कि बच्चों को हम किसी भी इंस्टीट्यूट में रखना सबसे लास्ट प्रायोरिटी के रूप में होना चाहिए। पहली बात तो ये है। तो बच्चों को हम कोशिश करें कि बच्चे शेल्टर होम में इस तरह की स्थितियों में सबसे बाद में जाएं, पहले जितने भी संभव विकल्प हैं पहले उस पर बातचीत कर लें। दूसरा, यदि किसी शेल्टर होम में बच्चों को ऐसा रखा जाए, आप यूपी की बात कर रहे हैं, मध्य प्रदेश के भी 2-3 शेल्टर होम्स में इस तरह की घटनाएं सामने आ चुकी हैं। शिवपुरी का आ चुके हैं, रतलाम के पास के शेल्टर होम में आ चुका है। तो ये स्थितियां लगातार बनती रहती हैं कि लोग शेल्टर होम्स में भी बच्चों के साथ ऐसे दुर्व्यवहार की स्थितियां सामने आती हैं। तो कानून उनके लिए भी समान है यदि शेल्टर होम में भी है, बल्कि यदि आप पॉक्सो कानून देखेंगे तो उसमें यदि कोई ऐसी व्यवस्था या ऐसी कोई संस्था है जहां पर बच्चे जब रहते हैं उनका बच्चों के प्रति विश्वास है, बच्चों का उनके प्रति विश्वास है, बच्चों का उनके प्रति भरोसा है, या बच्चे उनके पास रहकर अपने आप को प्रोटेक्टेड फील करते हैं, यदि ऐसे लोग कुछ इस तरह के सेक्सुअल वायलेंस की या बच्चों को बेचने के संदर्भ की, खासकर सेक्सुअल वायलेंस पॉक्सो में डिफाइन किया गया है, ऐसी कोई घटनाएं उनके साथ घटित करते हैं तो उसको एग्रीवेटेड माना गया है, यानी उसको गंभीर माना गया और उनके खिलाफ सजा के प्रावधान भी अधिक है। तो आपने जो सवाल उठाया है कि ऐसा नहीं है कि उनके लिए सजा के प्रावधान नहीं, बल्कि उनके लिए सजा के प्रावधान और कठोर हैं। लेकिन इसमें एक चीज भी और मान्य की जाती है कि इसलिए जब कोई भी शेल्टर होम या इस तरह के ऑब्जर्वेशन होम या किसी भी तरह के होम्स में जो स्टाफ रहता है, इसलिए वहां पर एक सीपी पॉलिसी बनती है, चाइल्ड प्रोटेक्शन पॉलिसी बनती है। उस पॉलिसी को हर स्टाफ को मतलब एक प्रकार से पढ़ाया जाएगा, स्टाफ को उसके विषय में बताया जाएगा और उसको साइन कराए जाएंगे। जो भी स्टाफ वहां रहेगा उसका वेरिफिकेशन करने के बाद उसको रखा जाएगा। और ये इसी बात के लिए किया जाता है ताकि स्टाफ इस बात से अवेयर रहे कि बच्चे यहाँ पर रहते हैं, बच्चों को विशेष प्रावधान है और बच्चों के साथ किसी भी तरह की इस तरह की गतिविधि नहीं की जा सकती, बच्चों या किसी के भी साथ। इसीलिए ये वो है कि सीपी पॉलिसी बनेगी और सीपी पॉलिसी को पढ़कर सब लोग उसको साइन करेंगे कि हमने बच्चों के संदर्भ में ये सुरक्षा मानक समझ लिए हैं और अब हम इनका ख्याल रखेंगे। यदि इसका वायलेशन होता है तो उनके खिलाफ एग्रीवेटेड माना जाता है, क्योंकि उन्होंने बच्चों के इन अधिकारों का उल्लंघन किया और उनके साथ ये प्रक्रियाएं की। तो शेल्टर होम तत्काल प्रभाव से बंद भी किए जाते हैं, रद्द भी किए जाते हैं और उनके जो लोग हैं उनके खिलाफ कार्रवाई भी होती है। सो ये प्रावधान बहुत स्पष्ट है। हालांकि 3 बजे हैं तो मैं आपसे निवेदन ही करूंगा आप सब मित्रों से कि चूंकि मेरा समय यहाँ समाप्त हुए हैं, डॉक्टर हमारे साथ जुड़ गए, डॉक्टर सुष्मिता, तो मैंने आप सब मित्रों के लिए अपना मेल आईडी और मेरे दोनों नंबर, व्हाट्सएप नंबर और कॉलिंग नंबर दोनों आपके पास छोड़ा है। आप अपने सवाल, और भी सवाल निश्चित होंगे ही, आप अपने सवाल मुझे प्लीज उस पर रख देंगे, तो मैं जवाब देने की हर संभव कोशिश करूंगा। बहरहाल चूंकि मेरा समय समाप्त हुआ है, आप सब ने, खासकर BSS परिवार ने, और आपने मुझे ये मौका दिया आप सबके साथ बातचीत करने का, डॉक्टर शीबा का, डॉक्टर फॉदर का, और आप सब युवा साथियों का बहुत धन्यवाद कि आपने बहुत शिद्दत से मुझे सुना, और आप सब ने मुझे ये मौका दिया कि मैं अपने कुछ अनुभव और कुछ सीख समझ आप सबके साथ बांट सकूं। बहुत बहुत धन्यवाद।
सर ने बहुत खूबसूरती से तीनों सेगमेंट्स पेश किए। इतने सारे जो कंसेप्ट्स थे आपने बहुत सरलता से, बहुत आसान भाषा में हमें समझाया, और मैं आशा करती हूँ कि जितने भी मित्र हैं जो हमारे साथ जुड़े हैं वो भी इन कंसेप्ट्स के बारे में सोचेंगे जो सर ने इतनी खूबसूरती से इतने डिफिकल्ट कंसेप्ट समझाए। तो इसी थॉट के साथ आई वुड लाइक टू एक्सटेंड माय हार्टफेल्ट थैंक्स टू मिस्टर प्रशांत दुबे फॉर शेयरिंग विद अस हिज पावरफुल आइडियाज. His awaz and all that it stands for is sure going to stir us into action. Thank you so much, sir, for this informative talk. You Thank you so much, sir, for the informative talk. You explained the intricacies of women and child rights with extraordinary eloquence. We are motivated, energized, and look forward to following your example by working for the cause of children and women. Thank you for your time and inspiring work. A special thanks to NHRC for sponsoring this training session and making it possible. I hope that our strive for knowledge and zeal to make a difference only grows with each learning experience like this one. Over to George.
Thank you, Lama. What you see, you may forget. What you listen, you may forget. But what you experience, you will not. Good afternoon and warm welcome to everyone. Myself, Joyce Varghese, student of MSW Semester 1 and host of this session. It is my immense pleasure to welcome and invite Dr. Sushmita Sen, our expert, Dr. Sushmita Dhar, our expert speaker of this session. Welcome, ma'am. Welcome to the session. Thank you for your presence. Let me introduce her. Our expert speaker is an assistant professor at Sister Nivedita University, West Bengal. Professor has an experience as a guest lecturer in the Burdwan University and Calcutta University from the Department of Law. She has practiced in High Court of Calcutta, especially in criminal and writ jurisdiction, for 8 to 9 years. She has participated in 29 international and national webinar, seminar, and workshop. Plus, she is having 21 publications in her credits. Thank you, ma'am. Thank you for being here. Now, this platform is all yours. Please enlighten us with your wisdom. Thank you.
Thank you. Am I audible?
Yes, ma'am, you are audible.
Okay. Thank you for the nice introduction. It is just echoing. Any problem? Let me check. Now am I audible?
You are audible, but I think, ma'am, the problem is with you have long been using 2 devices.
Okay. Actually, my computer just camera is failing. That's why I am locked from phone also.
Okay, so then you can reduce the volume of the phone.
Okay.
I think that would help.
Okay.
Yeah, now you are audible, ma'am. Very clear.
Okay. Okay. Ma'am, can I share my PPT?
Yes, ma'am. Absolutely.
Where is the share option?
Ma'am, there is an arrow option there.
Not my screen. Yes, yes.
मैम नीचे देखो मैम
enters screen. Okay.
Ma'am, do you want to share from our side? I have your PPT. Let me give a try.
Just a minute.
Yeah, okay, ma'am.
If I can.
That would be fine.
Let me try. Is it visible?
No, ma'am.
Oh, ठीक है. Then you can share it.
Okay.
Very good afternoon to all of you. My heartfelt thanks to Shiva Madam and BSSS and NHRC for giving me this opportunity. Today, I am just discussed on 4 vulnerable groups' rights, that is, the bonded labor issue and the Bonded Labor System Abolition Act of 1976, and SC/ST issues and Scheduled Caste and Scheduled Tribes, Prevention of Atrocities Act 89, Civil Liberties Act 1988, and the Forest Rights Act 2006.
Ma'am, sorry to interrupt. Is the screen visible?
Yes, yes.
Okay, so then you just tell me, then I'll move the screen accordingly.
Okay. Come to my third slide. So this is a workshop arranged by BSSS with the NHRC. The concept of human right I need to explain once again to my present listeners, that the international laws are solely concerned with states. Actually, in ancient time, international law only dealt about the connection between the states and interrelation between the states. So primarily, individual has no place in the international law except nationality principle. In the course of the passing of time, the position of individual after the Second World War has improved, and the international arena they regard it as a subject of international law having rights and duties. So as individual came as one of the enlightened definition of international law, that the subject of international law include individuals also. From then we can achieve the concept of human rights, that is the human being having the special right after his birth in the human family and having specialized duties also. So now come to my fourth slide. Please exchange the slides. Come to my fourth slides. So human rights are the rights of human being by virtue of their birth in the human family, which are inalienable and operative from time to time, and the birth irrespective of caste, creed, religion, sex, and nationality. These rights are the most basic fundamental rights and essential for their existence with freedom and dignity. Next slide, please. According to Justice J.S. Verma, Chief Justice of India, then, human dignity is the quintessence of the human rights, which are the essential for the protection of individual dignity and for their personality development. The World Conference of Human Rights, held in 1993 in Vienna, stated that all human rights derive from dignity and worth of inherent in the human person, and the human person is the central subject of the human rights and fundamental freedom. Next slide, please. And from this slide, from the last portion, we can see that there are various kinds of human rights: civil and political rights, economic, social, and cultural rights. Human rights can be divided into these groups. Next slide. International humanitarian law, it tells about human rights are universal, and the international human rights refer to obligation of states to individuals within their jurisdiction. According to the UN Charter of Human Rights, we, the people of the United Nations, determined to reaffirm faith in fundamental human rights, in the dignity and worth of human person, in the equal rights of men and women, and the nations large and small. So we, the people of the United Nations, here we can find all the world global citizen, we are in the same crew, that the beautiful habitat called Earth, we are the crew of this Earth, and we are living in this planet as a soul community. Basic international document, next slide please, on human rights. The Universal Declaration of Human Rights 1948, that is UDHR, that talks about the 30 articles that are divided into civil, political, economic, social, and cultural rights. And the other documents of international rights are the ICCPR, that is the International Covenant on Civil Political Rights, and Covenant on economic, social, and cultural rights, and the optional protocols. Next slide, please. The states are duty-bound to implement various charters and treaty conventions in their municipal law to protect human rights within their boundary. Now, as we are the international subjects also, individual states, they have their duty to implement the law that are treaty-based law, that are general principle-based law, that is internationally accepted law, into their municipal law. So there are certain vulnerable groups like human beings who need more protection to enjoy the right to life. Their rights are frequently violated by the dominant portion of the society. In this discussion, we'll look into the issue of bonded labor, SC/ST atrocities, civil liberties, and forest rights of the forest dwellers. Next slide, please. We will discuss the 3 Indian Act, that is bonded labor issues, and the Bonded Labor System Abolition Act 1976, SC/ST issues, and Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act 1989, and Forest Rights Act 2006, along with US Civil Liberties Act 1988 to understand the issues. So human rights are the inalienable rights. We must know one thing, that these rights are never be compromised. This is very essential for our enjoyment of right to life, that we should not be in a position to live as a mere existence like any animal. We should live with all the extent of our rights and fully with spiritual, economical, social, cultural, all the rights will develop our personality. That's why we have this right to life concept in Universal Declaration, in ICCPR, ESCR, and also in our Indian Constitution making. I will first discuss the bonded labor system. So let us go to the slide deals with bonded labor issues. Coming to next bonded labor. Yes, bonded labor issues and the Bonded Labor System Abolition Act. So forced labor constitute the violation of rights of men referred in the Charter of UN and enunciated by the Universal Declaration of Human Rights, that is UDHR. This UDHR is called the Magna Carta of Human Rights. That is, after the Second World War, the World Polity and UN, they talked about the maintenance of the human rights, and the UDHR that came into force in 10th December 1948. That's why we are observing this 10th December as our Human Rights Day in every year. Under the International Labour Organization, a convention for the abolition of forced labor was adopted. and the convention came into force on January 17, 1959. The state parties to the convention undertake to take effective measures to secure complete abolition of the forced labor. Now, this is the particular connectivity of, yes, next slide. That is the thing, that if we internationally agree something, if we ratify something as a state party, we must implement that in our municipal law. So that's why we, as we were the party, so we implement the law here. Generally, forced labor that was presented in India from the ancient times, but by an ordinance, our president in 75 that just promulgated the ordinance and said the bonded labor system hence be abolished. And after that ordinance, this act came into force. Forced labor in India, Indian Constitution under the Article 23, Para 1 lists down that the beggar and other similar forms of forced labor are prohibited. Beggar means labor of service provided by a person without remuneration. Bonded labor means any labor service rendered under the bonded labor system. So next slide, Bandhu Mukti Morcha case versus Union of India, AIR 1984. Supreme Court of India observed that bonded labor is included within this scope and forced labor and therefore prohibited under the 23 of the Constitution. In order to give effect to it, the Bonded Labor System Abolition Act was enacted in 76 with amendment in 1987 to abolish the system of bonded labor. Next slide. Indian Supreme Court on forced labor. People's Union for Democratic Rights versus Union of India, AIR 1982. Supreme Court 1473 held that labor is forced upon a person irrespective of payment factors shall be a forced labor where he is bound to serve because of some force or reason. Now, this binding can come as a custom, as a result of custom, as a result of various practice. So this kind of labors, they are bound to serve for generation to generations to the creditors. Suppose they take some money from the person and they are bound to serve. Public Union of Civil Liberties versus State of Tamil Nadu and others, 2002, the Honorable Court observed that the exploitation and miseries of the bonded labor, identifying the issues of bonded labor and rehabilitations there. Next slide. The National Human Rights Commission also, NHRC, been involved in the monitoring and implementation. Now NHRC has established by the Act of 1993, that is the Protection of Human Rights Act. We have the Protection of Human Rights Act to protect our civil liberties in India in 1993. And National Human Rights Commission has established by this Act. And now NHRC has been involved in monitoring the implementation of this kind of gross human right violations. So, as per the order of the Supreme Court of 1997, NHRC is monitoring the implementation of the Bonded Labor Act. So, what is the meaning of the term bonded labor? Bonded labor was historically associated with rural economies where the peasant from economically disadvantaged communities were bound to work for the landlord. Its existence both in rural and urban areas, mainly in our organized industries. The industries may be brick kiln industries and stone quarries, coal mining, agricultural labor, domestic servitude, sexual slavery, etc. So India has obliged to end this slavery by 2030 under the SDG goals, that is the Sustainable Development Goals. Sustainable Development Goals target 8.7 that are targeting the ending of this forced labor, human trafficking and child labor. So we can see that the India's position is 53rd out of 167 countries in the year of 2018 in the Global Slavery Index. That is, we are in the middle. We need to improve a lot. We can go to my next slide. that Indian constitutionalism, that is the Indian constitution making in the when the B.R. Ambedkar, he was the chairperson of our drafts committee. He and other teams, they, our founding father and mothers, 15 women were also there in the team. They prepared the constitution document of the draft constitution. They incorporated this right to life, but this right to life was a mere existence of a life with human. Animal existence is not required. That is our judicial creativity. That after 1978, there was a case, I can say the story of the Maneka Gandhi case, from where we can look back at, to the definition of life, that it is not a mere animal existence. Now, if we can include the natural rights, natural justice rights also, which is just, which is fair, which is reasonable, that can all be connected with the right to life. So which is unjust, unfair and unreasonable, that should be curtailed according to that, the particular judgment of the Maneka Gandhi's case. So a paradigm shift towards the looking at to the Article 21, that is right to life, has been incorporated after 1978 judgment. That is the finest creation of our judicial interpretation, creativity and judicial activism, that it just enlarged the view. We can see the right to life as not only a mere animal existence, but a life with dignity. That's obviously include the right to human rights also. And now under this facet of Article 21, we are enjoying so many rights. Suppose we are enjoying our right to education under the facet of 21A. We are enjoying our right to environment. We are enjoying just a right to travel abroad, right to speedy trial, right to health. Everything, right to life includes all these kinds of rights, and these are right to privacy, all are included under this Article 21. Now, Article 23 deals with practically with the forced labor. Article 24 prohibits the child labor, and 39, that is the directive principles of state policy. Now, when Constitution was in making, there are some rights given by the constitutional makers. If you could see the picture of Supreme Court, before the Supreme Court, there was the sculpture of Chintamani Kaur. I think all of you have the particular vision of that Supreme Court when you see the photo, that a black stone sculpture is there, that a mother in her lap, a baby is there. The baby, mother is our constitution, and baby, the just newly born nation, that is India, Bharat, that is in the lap of mother constitution. So constitution is our mother law of the land. So at that point of time when the constitution was making, the human rights that are also our fundamental rights that are attributed to us, the citizens and non-citizens also, but all the rights are not come into the category of fundamental rights due to at that point of time our state was in nascent stage, just created. So it is not possible for our state to provide all these kind of rights at a time. That's why some rights that are kept under this DPSP, that is Directive Principle of State Policy. That is part 4 of the Constitution. So part 3, that is deals with fundamental rights, which are very much connected to human rights. And part 4, that is DPSP, that our constitution makers have the wish to give us that kind of rights. But at that point of time, due to paucity of fund and everything, they have only wish but not have the capacity to give us all this kind of rights. Now, this DPSP, they are from Article 36 to 51 onwards. There are some rights are incorporated. Afterwards, from there, we could bring the section article that right to education. Now it is our fundamental right, 6 to 14 years of age. Then they can enjoy free of cost education as a matter of right, and state is bound to ensure that. That was previously under the DPSP, but now our state is in a sound position to give that kind of right to everybody. So that is come under the purview of 21A, that is the right to life. Now this 39 of the Directive Principle of State Policy talks about various types of labor community as well as state's duty to secure, next slide, health, strength of workers, men, women, and to see tender age of the children are not abused, not forced by economic necessity to enter a vocation unsuited to their age or strength. So Bonded Labor System Abolition Act that provides an institutional mechanism to abolish the system by framing vigilance committee in the district level. Now, if you could go through this act, this Bonded Labor System Abolition Act 76 has been passed to provide abolition of this bonded labor with a view to preventing economic and physical exploitation of the weaker section of the people, and for matter of connected therewith or incidental thereto. It has stated that the object and reasons of the act that there still exist in different parts of the country a system of usury under which the debtor of his descendant or his descendant depends to work on the creditor without reasonable wage. So there is a debtor-creditor relationship if then the person they are bound to serve without any consideration, without any remuneration. That is the bondage. At the time of several generations, work under the bondage for repayment of paltry sum which has been taken by some remote ancestors. So they are under the one kind of slavery. The interest rates are exorbitant and such bondage cannot be interpreted as a result of any legitimate contract. So there was no increment, no contract, only due to their ignorance, they are binded within this contract. So there is a gross human right violation at that point of time. The system implies the infringement of basic human rights, destruction of dignity of human labor. So we have our Article 23 in the Indian Constitution, which prohibits the beggar. We have our Article 35A of the Constitution, not only confers the power to Parliament to provide for punishment for the contravention of the said provision of 23, but expressly takes away the power of state legislature to make any legislation with regard to the said matter. So Bonded Labor System Abolition Ordinance, I have talked it previously. That is 75, it was promulgated by our president on 24th October 75. And later on this act, say Abolition Act 76, that came into force. So it shall be system, the act, the property of the bonded labor that shall be stand free when the act came into force, and they are discharged from the any kind of mortgage, charge, lien, encumbrances, and shall be restored to the position of the bonded labor. For the compliance of the provision of the Act, the state government is authorized to confer such powers and impose such duties on district magistrates as it deems fit for the purpose. The Act makes provision of the Constitution of Vigilance Committee also. So it is a social welfare legislation, we could say. Bonded Labor Abolition Act 76. It is a social welfare legislation providing for socio-economic justice to the weaker section of the society. So there are some definition. If we could say that what is bonded labor, that means a labor or service rendered under the bonded labor system. The bonded laborer means a person who incurs or has or is presumed to have incurred a bonded debt. So bonded labor system means that is forced or partly forced labor under which debtor enters or is presumed to have entered into an agreement with creditor to the effect that in consideration of advance obtained by him or by him on his lineal ascendants or descendants. So to the upcoming generation or to the previous generation, if any loan is given by the creditor in pursuance of any customary or social obligation or in pursuance of obligation developing him the succession for economic consideration or by reason of his birth in any particular community, that can make also the bondage rendered by himself through the member of his family dependent on him and labor or service to the creditor. So forfeit the freedom of the employment and forfeit the right to move freely and right to appropriate to sale, market value, etc. So this bonded labor system means this kind of bondage without any remuneration, connectivity with the debtor-creditor relationship. So bonded debt means any kind of advance that obtained or presumed to be obtained or have been obtained or bonded labor under the pursuance of bonded labor system. Next slide. The central sector scheme for rehabilitation of Bonded Labor 2016 also they are to give financial assistance to release them from the bondage. Bonded labor system means the system of forced labor under which a debtor enters or has presumed to have entered into agreement with creditor to serve him against any debt. The Act of 1976 extended the whole India, having 27 sections, and that came into force in 25th of October 75. We can discuss various definitions under the Act to understand the issues of bonded labor system in India. We can discuss section 2D, E, F, G. Already I have discussed it. That is, what is bonded labor, what is the bonded labor system, what is the meaning of the term bonded debt. Already I have discussed it. Now section 4, 6, 7, 8, 9, 13, 14, 16, 23, 24, 25 and 26 to understand the bonded labor system in India. There are some famous cases also. If we have time, we will also discuss it. Abolition of bonded labor system, that is the main object of the Act, to abolish the system that is prevailed in India, the bonded labor system. So any agreement, any custom that creates the bonded labor system, that is void from now. So that is the liability to pay the debt, that is the bonded debt to the other party, that is the creditor, that was extinguished and extinguished. So from the passing of the Act, that is from 1976, if there are some liability, some connectivity with the creditor that to pay off that bonded debt, that liability was extinguished. The commencement of the Act, every obligation of a bonded laborer to repay any bonded debt of such part of bonded debt as remains unsatisfied immediately before commencement shall be deemed to have been extinguished. So they have no duty to pay the debt or duty to serve again. So after the Act commenced, the suit and no suit can be laid against them for the fulfillment of the term of the bondage. So it is every decree or order of recovery of bonded debt passed before the commencement of the Act are not fully satisfied if before such commencement shall be deemed to be commenced to have been fully satisfied. So decree means the formal order of a civil court. So if any decree that is passed by the formal order of the civil court, that should also be from the time of commencement of this Act should be said that it is fully satisfied. Okay. So then the attachment made before the commencement of this Act, if any attachment of property has done, that is also stand cleared. So this Act under section 6, we can only learn section 6 in this way, that the liability to repay the bonded debt, that is totally extinguished. The property of bonded laborer are now free according to section 7. So free from mortgage, there is no kind of bondage till now. And free bonded laborer, they cannot be evicted from their home state. That is where they are residing at that point of time. Section 8 talks about that. They cannot be just, after coming into the Act, they cannot be just evicted from their home state. So section 9 talks about that creditor not to accept payment against any extinguished debt. No creditor has any right to receive any payment against that debt that is already extinguished by the Act. That means that the Act totally relieved the bonded laborers from their charges. Section 10, that the authority who may be satisfied for implementing the provisions of the Act, state government may confer such power to impose such duty to district magistrate. So in district level, DM is the authority to satisfy this, and the duty of the district magistrate and other officers to ensure the credit also, and the officers also authorized by him, by DM, they specified by him under section 10 to inquire whether after the commencement of the Act any bonded labor system is there, forced labor system is there available. That should be also taken into consideration according to section 12 of the Act. Now there is a vigilance committee. That vigilance committee, according to section 13 of the Act, every state government by the notification in the official gazette, they will constitute such vigilance committee for district magistrate as a person nominated by him, who shall be the chairman, and 3 other persons, 2 social workers will be there, not more than 3% to represent the official, non-official agencies, one person to represent financial credit institutions. So vigilance committee will be instituted after, according to section 13, which is a mechanism to check and monitoring the bonded labor system. And in the subdivision also there will be vigilance committee with subdivisional magistrate, that is SDO. Like DM, there will be SDO and 3 other persons, 2 social workers, etc. Same. The function of the vigilance committee, according to section 14, is that to advise district magistrate or any other officer authorized by him as to effort made and action taken to ensure that the provision of this act or any rule made thereunder any properly implemented to provide for the economic and social rehabilitation. So the bonded labor are freed, but their rehabilitation is also needed. The section 14, subsection 2, subsection B, C, that are the provision to provide economic and social rehabilitation to the free bonded laborers, and to coordinate the function of rural banks, cooperative societies, to provide them loan, etc., credit, etc., to keep an eye on the number of offenses, whether the cognizance has been taken or not, and to make survey. So monitoring system should be very vigilant. If not only passing an act, the bonded labor system will be just abolished. It is not an pen and paper issue. It should be implemented through the proper monitoring system also. So vigilance committee is there according to section 14. So burden of proof whether the date is bonded date or not, or a vigilance committee to a bonded date, the burden of proof is on the creditor, that is the charge to prove that it is not a bonded date at all to the creditor who is claiming the money. So there are some punishment according to section 16. There are punishment to enforcement of bonded labor whoever after the commencement of this act compels any person to render any bonded labor shall be punishable with imprisonment for a term not extend to 3 years. Then 3 years punishment will be given along with 2,000 rupee fine. So advancement of bonded date punishment is available, or extracting of bonded date punishment is available. So punishment are dealt with section 17, 18, 19. And if there is any abatement of offense, any instigation of offense, so there will be another kind of punishments. So offense is always to be tried by the executive magistrate. There are 2 kinds of magistrate. We all know that we have separation of power according to the article 50 of the Indian Constitution, that there is separation of power, and there is judiciary to pronounce judgment, to implement justice. There are legislature to frame law, and there is executive to implement those things. So there is separation of power. So the executive, in executive there are some magistrates, they are called SDO, DM, and other executive magistrates, they are called EM. And the demarcation is stated by the 1973 Act of Criminal Procedure Code. That act demarcated the executive magistrate and judicial magistrate. Now we have judicial magistrate to judge, to become judge in the lowest judiciary, and we have executive magistrate to deal with such cases. So these offenses of bonded labor, if any offenses has happened, they will be tried by the executive magistrate, that is according to the act. Every offense under these acts shall be cognizable and bailable. Now it is the term of law that according to CRPC, cognizable offense means when a police officer can arrest without warrant. So that is a more serious offense. So that serious offense can be, the police officer may have the power. Otherwise, the police officer cannot go to one fine morning and arrest a person without any warrant. But the cognizable offenses are more serious one. So they have the power to arrest any person in case of if there is no warrant issued by magistrate also. So these are serious kind of offenses. If any bonded labor issue can be filed, so that should be tackled by the executive magistrate. And as well as a cognizable offense, it is also bailable also, but they can seek bail also. There are many miscellaneous provision like 24, 25, 26 and 7. I'm not going to that. Now, I am just talking about 1 or 2 cases if time is permitted. There is Shannasharamanna and Samakhirarappa, that is others versus Gurappa Radhashami and others. There is a case where some children, 4 children, they were allegedly worked as they have to work as a bonded labor, and the petitioner that they were freed by the deputy commissioner of the police, and that was alleged that the petitioner, they approached to the parents of that particular 4 child to engage them in some kind of animal grazing and etc. for again some payment, and that was alleged that it was a bonded labor system, but ultimately court could not find any proper evidence that cattle rearing and clothes providing to them or paying some remuneration make them any bondage. The parents, they were not forced, compelled to give their child for that particular rendering of service. So they was not bonded labor and cannot be charged under section 16 of the act that was held. So this is the bonded labor system, from where we could understand that this act provides an institutional mechanism at the district level by providing this vigilance committee to advise the district magistrate to how to ensure to implement the law, provisions of the law. Now we can go to the second act, that is the SC and ST Atrocities Act. Next slide, please. The SC and ST Issues and Scheduled Caste, Scheduled Tribes Prevention of Atrocities Act, 1989. So that was enacted in 30th January 1990. When the Protection of Civil Rights Act, before the act, there was a act name called 1955 Act, that is called Protection of Civil Rights Act, but found that is inadequate to check the crimes or atrocities, recognizing the continuing gross indignities and offences against SC and ST. Parliament passed the SC/ST Prevention of Atrocities Act 1989 to provide special courts for trial and relief and rehabilitation of the victims of such offences, and to prevent commission of offences, atrocities against SC/ST. Intention of the legislature was to provide justice to the community through proactive efforts to enable them to live with dignity without violence, suppression from the dominant caste. So SC/ST, they are always in a vulnerable position. That's why we can see that there are some provisions still now to protect them in case of employment, in case of education, they are due to their vulnerability. So there are some atrocities that cannot be answered through the Civil Liberties Act of 1955. So this act was provided the creation of special courts and protection to the against them to the atrocities. Now, the next slide talks about the rehabilitation of the victim of such offences and to prevent commission of offences of atrocities against SC and ST. So, it is always the intention of the legislature before framing an act. There are the drafts acts. When the legislature is framing the act, the intention can be gathered from by reading the statute, by reading the act as a whole, that what is the main intention of the maker of the act. So the intention of the maker of this particular act to provide justice to the communities through proactive efforts to enable them to live with dignity without violence, suppression for the dominant caste. Right to life with dignity is the core principle of constitutionalism, as we discussed previously. Next slide. It was amended in 2015, 2018, section 18, capital A, that was added. The purpose of this act to help social inclusion of Dalits into the Indian society. So as of October, Dalits, they are very vulnerable in condition. All of you know, I think, about Dr. B.R. Ambedkar, who was the drafting committee chairperson of our constitution. When he was in tender age, he was in his school. I can remember from an article that was published in Employment News few years back, that about B.R. Ambedkar, it was stated that in his school, when he used to attend as a Dalit, he used to connect a bell in his neck, so that when he will passing through from any path, so that from the ringing of the bell, one can just understood that Dalit is coming, so that his shadow cannot be just overlapped by any upper caste people. So that was the condition. If Ambedkar has to take water during the tiffin break also, he has to wait for the time that when upper caste students, they are taking their water from the sources, and that source is not also available from tap from the school, from some away provision from the school. The tap is the source, some source of water is available, suppose pond or etc. And after all the upper caste, they are taking their water consumption needed for the day, then Ambedkar can go to that particular place. Unlike the Dalits, friends of Ambedkar, they are taking the water at that point of time after all the upper caste people has taken their particular consumption of water for the day. So what was the condition at that point of time? So Dalits, they are in the Indian society, that very much prone to atrocities. So atrocities against the member of the SC/ST are not a thing of the past. They continue to be reality in the society even today. Next slide. Hence, statutory provisions which have been enacted by the Parliament as a measure of protecting the constitutional rights of persons belonging to SC/ST must be complied with and enforced conscientiously, according to Justice Dhananjay Y. Chandrachud and P.V. Nagaratna. So the Act created a new kind of offence by specified persons, but the crime among SC/ST does not come under the purview. So if two SC/ST members, there is happening any crime, both the members, that is the offender and the victim, both are SC/ST, the Act will not operate. That Act only operate when one member is SC/ST, that is victim is SC/ST, and the upper caste is inflicting atrocities upon that victim. That only this Act will come into force. And the Act provide compensation, relief, rehabilitation for the victims of the atrocities and the legal heirs. Now, atrocity means some kinds of cruel, inhuman treatment that is punishable under the Indian Penal Code. So legal aid can also be available. So these are the particular social inclusion of Dalits, and it is a social welfare legislation. We can also say that about this Act. Now, the purpose of the Act to help these particular Dalits or the SC/ST people to include it in the Indian society and prevail the right to equality, justice, liberty that is given by the Indian Constitution to enjoy them. So misuse of the Act was rampant. After that, the Indian Supreme Court has banned the immediate arrest. Now, if a good thing came, there are some black side also of that thing. So you can have the idea of 498A Act, Section 498A, that is the matrimonial offences, that is also abused by various wives also. So in this case of SC/ST, there are false allegations of atrocities sometimes. So our Honorable Supreme Court has ordered that no arrest can be made without any proper check. So proper check should be there. But in 2018, the ruling was bypassed, and that includes Section 18 capital A. I have talked, that is under subsection 1A, which was amended the 1989 Act, which says that the preliminary inquiry shall not be required for registration of a FIR. So for registration of FIR, no inquiry is registered. The National Human Rights Commission for SC/ST, they conducted a study in 1990 on atrocities of SC/ST. They pointed out various casual factors of atrocities like land dispute, bonded labor, indebtedness, non-payment of minimum wages, caste prejudice, on practice of untouchability. So that was untouchability, that was totally repealed by our Article 17, but that is still prevailed. The root can be traceable in the caste system. So despite the constitutional promise of Article 14 to 18, that is right to equality, and abolition of untouchability, etc. Our offenses are still going on. So the act need to be protect these Dalits. As of October 2021, Supreme Court of India was constrained to observe that atrocities against the member of the SCST are not a thing of past. They continue to be a reality of the society even today. Hence, the statutory provisions which have been enacted by the Parliament as a measure of protest, constitutional rights of person belonging to SCST must be complied with and enforced conscientiously. So, to eradicate the vulnerability faces by this SCST community, secure right to life, property, and create awareness among the people through education to resist the practice of untouchability. Against them, the act commenced. The provisions of the act, that the first category contains the provision of criminal law. It establishes that criminal liability for a member of specifying defined atrocities extended to the scope of certain category of penalizations given to the penal code. Second category contains of provision of relief and compensation for the victims, and third category containing the provisions establish special authorities for the implementation and monitoring the act. So there are some new types of offenses that are incorporated by the acts, and the commission of offenses are specified by persons, crimes against SCST that does not come to the purview. We know about the thing. So various kind of atrocities are there. There are some enhancing punishment and attachment even for property are ordered, can be ordered. Creation of special courts that is ordered under section 14, appointment of special public prosecutors to deal with such cases that can be done, and the denial of problem to convict, section 19 is there. Provide compensation, relief, rehabilitation, and setting a mandatory periodic monitoring system in the district, state, and national level. That is the direction of the act. So we can say that atrocity is a cruel treatment, inhuman treatment of the act, treatment by the upper caste to the lower caste. That is, initially can make them liable against any gross human right violation under section 3/1, 3/2. So this is commonly used for the refer to the crimes against the SC/ST communities. Quality of being shockingly cruel and inhuman treatment, that can be called as atrocities. Now, second slide, next slide. Next is forest one. So before going to Forest Act, I can say that this SC/ST Act, which are Scheduled Tribes Prevention of Atrocities Act 1989, that is a particular unique legislation to protect the particular sect from the atrocities. But there are some provisions that are not totally by creating an act or legislating an act that can anything be totally closed. I think not, because there are so many case references. Suppose a SC/ST person, they are being the victim, they want to file a case against any upper caste person, they are going to police station. The upper caste police officer is not dealt with very good way. So there are so many lacuna. So there are so many pending cases we can see in this SC/ST Atrocities Act. The pending cases, the act came into force in 1989, and in 1998 there are so many pending cases. We can see that 14,700 cases are under this act, they are pending. So upper caste policemen, they are lacuna to taking the cases or implementation of the law, or the conviction rate is so poor, that are the main lacuna. So act is there, but the implementation should be monitored in a proper way. Court have to be more vigilant, more speedy trial need to be given. The many cases, the particular persons, they are just get freed from the charges. So that is not unwelcome step. That should be taken into consideration also. Now we will go for the last act, that is the Forest Act, FRA, that is the Forest Act 2006. The Forest Rights Act 2006, this can also be called as Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act 2007. So this act, the law concerns the right of the forest dwelling communities. Sometimes in the forest, some people, they are very vulnerable, but for generations they are live in the forest and taking their livelihood from the forest. They are from the ecosystem services available there. They are just passing their livelihood by taking help of the forest. So they are the indigenous people, they are the traditional people, they are sometimes the various kind of people having not so much connection with the civilized society. So they are the forest dwellers. They are used to live in the forest for decades, and that results to continuance of the colonial forest laws. We are not look back to the particular provisions of the forest dwellers right. This particular act, that is FRA 2006, that dealt with the human rights of the forest dwellers. So we are concerning about the only not the environmental aspect of the Forest Act, that is the Forest Conservation Act is there, like 27, and 1980 Act was there. There is Wildlife Protection Act. We are not concerning with the environmental issue. We are concerning with the human rights jurisprudence, that is the man and his rights. So forest dwellers, they are the indigenous people. Their rights, how that can be protected, that is only dealt with by this Forest Act. Next slide. This is an act recognized and based in the forest and rights and occupation in the forest land, and forest dwelling scheduled tribes and other traditional forest dwellers who have been residing in such forest for generations, but whose rights could not be recorded to provide for a fair move up. The act was enacted on 29th December 2006, commenced on 31st December 2007. The act will redress historical injustice committed against the forest dwellers. Forest provides sustenance in the forms of minor forest produce, water grazing, grounds and habitat for shifting cultivation. In India, forests are governed by Indian Forest Act, Wildlife Protection Act, Indian Forest Conservation Act, all acts are there. The Forest Act of 1927 empowers government to declare any area to be a reserve forest, protected forest, or village forest. The Act of 72, that is the Wildlife Act, defined the protected area, national park, wildlife sanctuary, tiger reserve, community reserve. So these are talking about the environmental issue. We are not connected with this. We are connected only with human rights issue. That's why we are choosing this FRA, that is the Forest Rights Act. Section 3(1) of the Act talks about the rights. What are the forest rights? Right to hold and live in the forest, land under the individual or common occupation, for habitation of self-cultivation, for livelihood by a member or members of a forest dwelling schedule, tribe or traditional forest dwellers, community rights like uses, entitlements, fish and other products, water body, grazing and traditional seasonal access of nomadic and pastoralist community. So right to access, next slide. Next. Right to access biodiversity, community right to IPR, and traditional knowledge. So traditional knowledge is the particular knowledge of that particular persons. They are living in that particular forest area. They are from generation to generation, they are passing this kind of knowledges. Suppose how to collect honey from the jungle and how to prepare proper and maintain that honey for years to come. The honey will not be spoiled. That are their traditional knowledge. By doing so, this sometimes Sundarban peoples they have that kind of traditional knowledge. So they are on site. You can see and you can study about the traditional knowledge of the people from the WIPO site, WIPO, World Intellectual Property Organization. They are talked about the rights of traditional knowledge of the peoples also. They are like the ancestral people of forest and etc. They are living there. So rights of IPR. IPR means intellectual property right. Suppose I am inventing something. Suppose I am the inventor of some scientific invention, or I have written a poem, or I have composed a song for anybody, or I have painted something. So I have some right, copyright, trademark. If I am a manufacturer of a particular goods or services, and that kind of thing can be trademarked. Like we having knowledge of various kind of things that are the patent, trademark, copyright. These all are intellectual property rights. So that rights are also connected to the forest people, because the forest people, they are sometime, they are preparing something, they are inventing something, and that is according to their traditional knowledge, that should be protected. So IPR, that is intellectual property law, is very much vigilant to protect their rights also, globally and nationally. So in global arena, WIPO is their World Intellectual Property Organization. They are taking cognizance of this kind of IPR rights. Anyway, biodiversity, biodiversity means the flora and fauna available in any particular ecosystem. That is the particular trees, people, microorganism, biotic, abiotic components. So environment is our surrounding. So that are available in our biodiversity. There are so many species we can see. So right to access that biodiversity, that are also rights of the forest dwellers. The species available there, they can use that ecosystem services to maintain their right to life, because we are sometimes grazing cattle, we are sometimes catching fish, we are sometimes taking fruits from the tree. All of the things are coming from our environment. So the forest dwellers also, they have the same kind of rights to take such kind of access to biodiversity. Right to settlement and conversion of the forest villages, old habitation, unspread villages, and other villages in forest, whether notified or into revenue villages. Right to conversion of pattas or lease of grants issued by any local council or any state government on forest land or titles. Next slide. So ownership right, relief and development right, forest management rights are the main rights given to the forest dwellers. So according to this act, Forest Rights Act, Section 3, subsection 1, talks about this kind of rights. There are from A to M, there are various kind of rights. I have only talked about 3 or 4 kind of rights, but there are so many other rights also. Community rights is there. The right to include community tenures and habitation, right to over disputed lands, and right to protect, regenerate, conserve, manage any community forest, right to reorganize under the state laws, any autonomous district council, right to access that biodiversity, traditional right customarily enjoyed, or right to in situ and ex situ, that is an environmental concept principle. That is rehabilitation, including alternative land in cases where the scheduled tribes they are residing, and other traditional forest dwellers they are already. Other traditional forest dwellers means OTFD. So ST and OTFD, they are the main beneficiaries of this act. Other traditional forest dwellers, that is OTFD, and ST, that is the scheduled tribe, they can only claim this kind of rights. Okay. Now, who are there in the forest, living in the forest, and for generation, like previous 3 generation, they are living in that forest, like for like 75 years, they are living in the forest, they can claim this kind of rights. So the Forest Act 2006, next slide. Section 6, the scheduled tribes and other traditional forest dwellers, Recognition and Forest Rights Act 2006 provide a multi-layered and hierarchical procedure for recognition or rejection of forest dwellers' claim, starting at the Gram Sabha level with multiple appellate community in the state level. So the basic, the bottom is there, that is the Gram Sabha level, and there are other appellate communities, appellate tribunals also there, communities there too in the state level to tackle the cases. The act provides the framework to recognize and waste for forest rights, and occupation in the forest land and forest dwelling, scheduled tribe and other traditional forest dwellers who have been residing in the forest for generations but not recorded. So they have no recorded rights. The judicial notion of forest dwellers. Next slide. So what are the judiciary's opinion? There are so many various cases. You can go to India Kanun if you could see, if you can have time, if you could have time, you can access India Kanun website, live law websites, advocate Khoj website to find such kind of interesting cases on forest law. There are so many cases. If you required, I will share this with Shiva madam also, all the links I do have regarding the case references. I can share it to Shiva ma'am also, and you could find some interesting cases from there. During paucity of time, I cannot discuss all the cases here. So in 2008, the Wildlife Trust of India, that is an NGO, and other conservationists, they moved to Supreme Court to assess the validity of this FRA, that is the Forest Rights Act. They argued the act led to deforestation and encroachment upon the forest land. So environmentalists, they talked about that this act, if the forest right is given, this kind of section 3, all the rights is given to the forest dwellers, then deforestation will certainly happen, because they will rear the cattle and grazing the cattle in the land of the forest. So you all have the idea that there was an Amazon fire previously last year. The Amazon fire, why it was happened? To destroy the environment and to uphold the particular cattle grazing. That was a very famous business, that we are eating so much of meat. So cattle grazing is a very famous business. So cattle grazing, there needs some land. So in Amazon, there was a great fire, and that was concocted, man-made fire, to graze the people, graze the cattle. So environmentalists, they protest that if these forest dwellers giving the right to graze the cattle in the forest area, they will certainly hamper the forest. So whether the act is valid or not. In 2014, the petitioner, they claimed that edict of illegal forest dwellers on 13 February 2019, Supreme Court ordered that states to evict all the individuals whose claim was rejected by the act. So under the act, if some people has given the claim under the Forest Rights Act, they are only liable, that is ST and OT FD. Other the communities, they will not have the right to stay in the forest, and they should be evicted. That was the view of the petitioner. Supreme Court was also of that view. Supreme Court ordered eviction, but that was stayed and again stayed by the Supreme Court. And meanwhile, our central government, they has proposed to amendment of the Forest Rights Act, that is 27, and vest an additional power to state government that potentially erodes the rights of the traditional forest dwellers also. So the 27 Act is also now totally in upcoming days in a way to tackle the issues of forest dwellers also. Not only this FRA Act is there. So before going to civil liberties, I can say that these kind of forest dwellers, their recognition, restoration, and vesting of forest rights related to matters that are dealt under Section 2 and Section 4/2, and then no member of forest dwelling scheduled tribe and other traditional forest dweller shall be evicted or removed from the forest land under the occupation till the recognition and verification of the procedure is complete. And there are some duty also attached to these forest dwellers. That is, they have the right to protect the wildlife of the forest, biodiversity, to ensure the adjoining attachment area, water sources, and other ecological sensitive areas adequately should be protected. Ensure that the habitat of forest dwelling scheduled tribes and other practices, traditional forest dwellers, is prevented from any other destructive practices affecting their cultural and rural heritage, natural heritage, and ensure that the decision taken by the Gram Sabha to regulate access to the community forest. So they not only have some rights under the Act, they also have some duty. So there are so many authorities who are vesting with the mechanism whether the proper act is implemented or not. Gram Sabha is the lowest level, is the authority to initiate the process of determining the nature and extent of the individual community of forest right, both that may be given to the forest dwelling scheduled tribes and other traditional forest claim dwellers. So the state government can also constitute a subdivisional level a committee to examine any resolution passed by the Gram Sabha. And under section 567, there are some offenses and penalties, and section 7, as per 7, where any authority or committee or officer, they are member of such authority or committee, contravenes any provision or any rule they are under recognition of the forest right, they can be slapped with fine and etc. And the offense is cognizable one. And there are so many cases. If we could discuss, we have time, we will discuss the cases. Now I want to go to Civil Liberties Act, my next slide. I have to complete it within time. That's why I want to go to my next slide. That is the Civil Liberties Act. The Civil Liberties Act 1988, that was signed by the President Ronald Reagan on August 10, 1988, the United States federal law that generated reparation to Japanese Americans who had been interned by the US during the World War II. Now, all of us having the knowledge of Second World War, that there was an attack by the Japanese on Pearl Harbor. I think you all know about that Japanese attack on Pearl Harbor, and so US was so much frightened by the attack of the Japanese, and they just taken cognizance of this act, and they tackled in a very inhuman way with the Japanese. They are resident of America at that point of time, citizens of America. So at that point of time, their life, right to life, property, all was devastated by the US, the then US president and the other machineries at that point of time during the Second World War. So this act was there to give reparation after 40 years. That is 39 or 40 was the age limit, time limit of Second World War, and 1988 we could see that is a very gentle approach of America, that our past generation has done something wrong in case of violation of human rights, and we are correcting the same. So President Ronald Reagan, he has, after passing the act, he has formally acknowledges that there are some atrocities were there against the human rights, and they take the particular view that the act connected with the surviving internees, they given the reparation to the interns of Japan also. That is the $20,000 in compensation payment that was started in 1990. The act acknowledges the fundamental injustice of the evacuation, relocation, internment of the US state citizens and permanent resident alliance of the Japanese ancestry during the World War II. Next slide. It also provides public education fund to inform the public about the internment of such individuals so as to prevent recurrence of any similar events and to make restitution of those individuals who were affected by the action. It was more credible, sincere declaration of the concern by the US over violation of human rights committed by the other nation. The act generated presidential apology and reparation to every surviving citizen of US or legal residents, immigrants of Japanese ancestry that were incarcerated. Next slide. It was a trump for American civil rights. So after 40 years of the incident and loss of life and property, American president openly issued an apology and reparation that the unique inward scenario. So America is so gentle in protecting the human rights issues in that. So they are very sorry for their past actions, that during the Second World War, we have done this to our Japanese citizens who were American citizens also. And we are very much sorry for this action, and now we are giving this kind of apology through precedent and reparation also. So America stands not only on racial idea, but on the human rights ideal. America can prove this. The Civil Liberty Act of 1988, that is a unique stand of America, that they are just stand for human rights as an ideal. Actually, civil liberties are guaranteed by the government, not by committing any violation by the constitutional legislation. So civil liberties, next slide, it includes the freedom of conscience, freedom of religion, right to life, all are civil liberties. In India, civil liberties that are protected by the Constitution first. Our Constitution is the mother law of the land. It is the basic law of our land, or ground norm of our land. Any law cannot come by contravening any provision of the Constitution. Suppose there are some law before the Constitution came into force, that is, Constitution came into force in 26 Jan 1950. Before that, suppose there are any law that is contravening any provision of Constitution, that law will be repealed. Constitution is the mother law, that should be intact, that should be protected. That is the basic structure of our constitutionalism. That is the separation of power, judicial review, or the federal provisions, federalism, that is the adult franchise. All are the basic principles of our constitution that should be protected. And this constitution, our constitution, has given us so many constitutional as well as fundamental rights and directive principles, as well as it incorporates the duties also. So all these are a good package to protect our civil liberties in India. So constitution is there as a mother law. Legislation, various kind of legislations. We have studied already bonded labor, SC/ST atrocities. So there are so many human rights, Protection of Human Rights Act 1993. So many other acts, 100 acts are there, 1,000 acts are there to protect our human rights here. And there are so many judicial notion, that is the judges' notion, by delivering their judgment. While delivering their judgment, the judges are taking cognizance of any kind of this human right violation. Suppose when a Vishakha case, that is the exploiting the woman in a sexual way, that is in her workplace, that was particularly direction of CEDAW, that is the elimination of all form of racial discrimination against women in 1979. But at that point of time, we were the party. We have signed the convention, and at that point of time, we have no law in our land to protect the women workforce from sexual harassment in their workplace. At that point of time, Supreme Court given that Vishakha guideline in 1997. So judicial notion is very important. Judicial, according to Article 141 of the Indian Constitution, what Supreme Court is saying, that is the law of the land. So if they are saying something, some guideline cases, suppose how to arrest a people, DK Basu versus State of West Bengal, there are some guidelines how to arrest a people. So many guideline cases are there that can be tackled as a law. So Vishakha cases, we could find that Supreme Court has answered against the gross violation of human rights of Manwari Devi case. So this the law judicial notion is also very important to tackle the civil rights issue of our Indian citizens. And PIL mechanism. What is PIL? PIL mechanism, that is public interest litigation. That is under the Article of 32 and 226 of the Indian Constitution. Any public spirited person, suppose I am not directly connected to that person, but if I am a public spirited one, I can have the access to write a legal letter to a Supreme Court or High Court by seeking that apostolary jurisdiction. That is, by writing a letter, I can attract the view of the judges. And my lord, that things are going on, this kind of human rights are violating, atrocities are going on, please take notion. So, but at that point of time, Supreme Court through PIL mechanism, that is the public interest litigation, that is the unique invention of Justice Krishna Iyer and Justice Bhagavati. That is, through this mechanism, justice can be taken to the doorstep of the poor people. So that poor people, if they cannot go to court, court will go to them. That is, they can achieve the court's door by seeking any other third party's help also. If I am a public spirited lawyer, I can also file a letter, I can also file appeal on behalf of them if there is any kind of right violation. So appeal mechanism is there to protect our human rights also. And it is a wonderful device by which judiciary can protect the civil liberty. The Protection of Human Rights Acts, I have talked it in a very brief way. That is, in 1993, India that is promised to uphold the human rights even before England passes its right. In 1998, India passes the Protection of Human Rights Act, and we passes it even before England in 1993, from where we could find the establishment of NHRC, SHRC, that is the State Human Rights Commission, National Human Rights Commission. So we have the various ground to protect our civil liberties here also. So in this discussion, we can easily focus on the 4 aspects of gross human right violation. Already we have studied bonded labor issues, how they are just exploiting by their bondage from generation to generation, and that they are freed by this Act of 76, and how the SC/ST people, they are the facing the atrocities by the upper caste people, and the Act just want to abolish this kind of atrocities. That is also to protect their human rights also, and the traditional rights of the forest dwellers, like through the FRA Act, that is the Forest Rights Act, and the Civil Liberties Act of US, that remind us how gentle a nation can be. US is so gentle, very gentle nation. They even taking cognizance the 40-year past act of their ancestors, and they are seeking apology to the upcoming generation, and even that generation people, if they are alive, giving them reparation and apology. So how a human right can be protected with all its facets, that can be learned from US, from the Civil Liberties Act also. So human rights are the basic human needs which need to be protected for better enjoyment of right to life. The Indian constitutional promises is also to uphold dignity of individual, which is the core issue of human rights jurisprudence also. In conclusion, next slide, it can be stated, proper education and awareness among the citizens can proper monitoring and deterrent punishment for gross violation of human dignity can wipe out the human rights violation. Vigilant judiciary, proper collaboration between the organs and the government, and the proper infrastructure implementation can eradicate this kind of issues. So next slide, we have no planet B. We have to live in this planet. So we should all live here with harmony, peace, and human rights. Tamasoma Jyotirgamayo should be the prayer of every soul who want to live peacefully. Only ignorance is the cause of all exploitation. No act is sufficient. As a lawyer, as a law teacher, I am saying that no act is sufficient alone to protect or preserve human rights. They are only aids. They are only handmaid of justice. No act can alone eradicate all the evils from the society. We need to cohabit with dignity and duty. That if we have rights, some others have duty, correlative duty, rights and duty that are very dual correlative according to jurisprudential view. That is, if I have some fundamental rights, you have some, state have some fundamental duty to protect my right. So if I have right to life, state has the duty to protect my rights. So there is a fine blending of right and with a duty. So we have to live in this planet not only by exercising our right, but also doing our duty, so that all people's right can be protected in that way. Then only a proper societal goal can be achieved. Up to this, thank you very much. And if you have any question, I can answer as per my limitation. Hello.
Hello.
Hello. Am I audible?
Yes, ma'am, you are.
Yes, ma'am, you are audible.
Okay. if there is any question. Any question from my audience?
Hello.
Yes.
Ma'am, can you hear me?
Yes.
Ma'am, just a second. We are facing little technical difficulties.
Okay, ma'am.
Just a minute, ma'am. Students, if you have any questions for ma'am, please ask. Unmute yourself and you can ask the question. Please give us a moment, ma'am.
Okay.
Joyce, over to you.
Yes, thank you very much, ma'am, for your time. Thank you for elaborating and explaining and giving us an idea about these acts and rights. Thank you very much. Once again, giving thanks to NHRC for conducting this session. And over to Diana.
Gratitude, as William Faulkner once said, is a quality similar to electricity. It must be produced and discharged and used up in order to exist at all. I take the privilege to invite Dr. Shiba Joseph, IQSE Coordinator and Associate Professor, Social Work Department, to propose the vote of thanks.
Thank you, Diana. Very good evening to one and all. Respected resource persons, dear faculty members, and our fellow participants. At the outset, we wish to place on record our sincere gratitude to the National Human Rights Commission for accepting our proposal and sponsoring this event. We had four informative sessions since morning by Professor Kavita, Professor Patil, Mr. Prashant, and Dr. Sushmita Dhar. Very comprehensive sessions. We are aware that all the issues pertaining to human rights cannot be covered in a day, but we truly believe that the students got a brief idea about human rights, its provisions, laws pertaining to human rights, and the role of social workers as well. We thank all our resource persons on behalf of the entire BSSS family. Leadership is the capacity to translate vision into reality. And our principal, Dr. Father John P.J., is a true visionary. Under his guidance, we are very confident to take up any responsibility. The encouragement and motivation that we receive from him is remarkable. Thank you so much, Father, for guiding and mentoring us in all our endeavors. Our Vice Principal, Dr. Sister Sonia Kurian, holds a very warm and receptive personality. Thank you, Sister, for being a source of inspiration and motivating us to take up good initiatives, especially in the area of social work. We also thank the head of the Department of Social Work, Mr. Abraham K. Varghese, for his guidance, Ms. Anurupa, Assistant Professor, Mr. Sudhanshu Shekhar Detta, for all the support rendered to make this event possible. Thanks to our dear student volunteers, Diana, Alan, Lama, and Joyce, for coordinating the training program very diligently. We are thankful to all the participants who attended very keenly from the beginning till the end. Hope you all had a good learning experience. I understand that, compressing the area of or the domain of human rights into a day's session, it's a mammoth task. And we believe that you got a bird's eye view on all the area pertaining to human rights. We also thank Mr. Eugene and Musharraf for their technical help. Once again, I thank the entire organizing team, the Internal Quality Assurance Cell members, and also the Department of Social Work members. Thank you all and good evening. Stay safe and blessed. Thank you all. The participants are requested to kindly fill the feedback form. We have floated around 5 feedback forms. 4. Kindly fill it. Once again, thank you, Sushmita ma'am, for joining and for your very informative session. Thank you.
Thank you, ma'am. Can I leave?
Sure, ma'am. Thank you. Thank you so much.
Okay. Okay. Thank you.
बंद मत करना, उनको फीडबैक करना।
नहीं, वीडियो
ये सब स्क्रीनशॉट ले लिया ना, इसका भी और फादर का।